to the defaulter. Well, as my other remaining property which I have not sold to the defaulter has been attacked, and before this court already filed the writ petition. Well, as now the original
The unsold property is sought to be attached.
Yes, now that is under planning.
Monday.
The petitioner is a successful bidder, forest products. Now work order has to be issued. Now they are imposing FDT method. That is not permissible.
FDT is subject to Supreme Court order. But Monday we already have 217 matters. It will come. If it will come up on Monday, it won't reach. Are you okay with that? Tuesday 148, Wednesday 155. Reach agಲಿಲ್ಲ ಅಂದ್ರೆ ಕೇಳಬೇಡಿ. ಮತ್ತೆ ಇಲ್ಲಿ ನಿಂತ್ಕೊಂಡು it is not reached ಅಂತ ಹೇಳಬೇಡಿ. Registry will see when there are lesser matters and they'll post it. We are also not telling them.
Now they are making, they are refusing to make payment in respect of me, and then that I will provide all the payments under the rights of the previous disputes. Those disputes are pending for DRT. So, order that DRT considers government.
Yes, virtually what you are asking for is extension of the facility when there is a loan default. But that means it is a surface matter. Proceedings are pending before the DRT.
These are totally different than the transactions which are subsidized before.
Mr. Counsel, why we are telling you this is, why we list it and then forwarding it is different. If you can go before that the concerned court, you will be saving time. Aitappa kodappa.
Date was given as 16th last week, so this day pending.
Depending on the availability of slots, it will come. This one, outdoor advertising, 4 o'clock. After succession certificate, next week, 3rd. What is this commission doing in all these matters nowadays? 233rd. Delay ಆಗಿದೆಯಾ? Monday, only for that purpose, Monday. Stay of the AC's order. So who is taking the? You are for the. That's why you are for the senior citizen. So Monday, Tuesday, Wednesday. If you move so many matters, it can't reach. Depending on the availability, it will be fixed. NCLT. Next week, though. We are having a lot of matters of this NCLT coming up before us because NCLT is not discharging its functions. So we'll be discharging NCLT functions also. Yes, next week it will come. Next week it will come. Madam, then you'll have to move that. Tomorrow is a CMP day. We can't take any other. There are already 117 matters CMPs which have been listed. Pudi. Not at all, madam, not today. Bank account yavatama?
Sir, 9.
Huh?
9.
Ninth list, my dear.
Senior citizens matter
Well,
a lot.
Just one moment.
Memo for being.
Just one moment.
Lordship, memo for being spoken, Lordship. Lordship has already
So Tuesday, though.
Memo for being,
being spoken.
CMP, my lord, memo for being spoken to.
CMP.
Yes, my lords.
Tomorrow.
Memo for being spoken.
Or classification.
GM passport.
Tuesday.
My lord, one matter, my lord, the petitioner is a member of the Karnataka State Waqf Board, my lord. His membership is terminated, my lord, without notice to me, on the ground that my bar council membership is, my lord, seized. My lord, that has been extended by the Bar Council of India, intimating that the government doesn't have power, my lord, they have unilaterally.
You are a member on account of being an advocate.
Member of the Bar Council.
Member of the Bar.
Council, yes, my lord. My lord,
Tuesday.
Sixth is the meeting, my lord, they wanted me not to attend, therefore, that is the reason, my lord.
One meeting, don't attend. What is it?
There is this important decision that they want to tilt the equations. Tomorrow, my lord, I may request.
Tomorrow is CMP day.
I'll take chance.
Preferences to CMPs.
I'll
If
take
it
chance.
reaches, yes.
Yes.
Senior citizens matter. Not the petitioner is senior citizen suffering from cancer. Son has neglected him, not even paying money for the treatment also, my lord.
What happened before the AC?
Lord, that has been the AC, my lord, did not cancel the gift day. I filed the writ petition.
You sought for maintenance or cancellation?
No, gift cancellation I have filed, my lord. That has been rejected. Writ petition is filed and there is a stay order. Now, my lord, my son has neglected me. I am a cancer patient. He is not given.
You are the respondent in the matter.
There I am the respondent.
Illi and
He petitioner, sir. My application before the district petitioner.
Rowdy next week.
Tomorrow.
Not tomorrow, next
Tumba
week.
urgency. At least on Monday,
Yes.
you can have.
It'll come, Mr. Counsel. Just a moment, please. Wait, please.
The petitioner is code recognized under the RTE scheme, my lord. Only to have not been receiving the reimbursement. I'm not able to file applications because the pending reimbursements have not been processed to me. I filed multiple representations.
Next week, third.
Auction sale notice for
Hmm?
auction sale notice or challenge for the DRT. As against not outstanding of rupees 2,75,000. Even directed to not deposit.
Surface a matter.
Surface amount, not given
Not
directly.
before this court. Court all 20. Surface a namgilla. WP DRT, WP surface a, all those things are not
Miller.
Yesterday I have given electricity
disconnection. Next week, third.
Millards, I'm the petitioner and the DC has passed an order regarding title. And even though the land is not a revenue land, the respondent number three's land, according to his sale deed, measures only 100 into 60 feet. But in the survey sketch, it is mentioned as 175 into 60 and the DC has confirmed this order. And in that 175 into 60 feet, my land is there. And based on this flawed DC order, they're trying to change the khatas.
Be a GM, madam. It will have to go as KLR.
It's not a revenue land. It's not a revenue land. Yes,
Third.
please. Kindly have it on Monday, Millards.
It
They're
will
trying to change the khata based on the
It will
flawed.
come,
DC
madam. You
order.
filed your petition, we will consider.
Lords. Main matter was got disposed on the same subject matter, my lords. This matter was not connected with that. So kindly put up on tomorrow.
Next week.
Adjournments. List number 1, page number 6, serial number 48. Page number 7, serial number 49 to 55.
Still number 52, madam.
52.
Pay for responding, inform the petitioner. They inform the petitioner today my senior is not in station.
Just for a date next week, Mullah.
Not next week. If it gets adjourned, it's going to go to January. If we oppose, we won't adjourn.
Because the council is not there, Mullah.
Two options. If it gets adjourned, it'll go to January end.
Because the petitioner is a Nigerian national, Mullah. He's been in detention.
Then you oppose the adjournment, we won't adjourn. No adjournment. Next.
You want to secure some instructions.
Yes. Next,
50.
50. Have you informed the respondent? No objections? 50 at the request of counsel for the petitioner.
Serial number 41.
Your date.
3rd February.
Serial number 41 is a surfacing matter.
41 is sufficient.
Surfacing matter.
41, learned counsel for respondent submits that the matter is is a proceeding under, arises of proceeding under Surface Act. Registry is direct placed before the appropriate bench.
Page number 8, serial number 56 to 62.
This is Surface Act. State of Karnataka. Francis Xavier. Freezing. At the request of counsel for the petitioner, relist on 9th.
Yes.
9th.
Page number 9, serial number 63 and 64. Page number 10, serial number 65 to 69. Page number 11, serial number 70 to 76.
My lord, serial number 71. Serial number 71.
Yes.
Hearing for respondent 2 and 3. Short accommodation.
Have you informed the other counsels?
Please, my lord.
71 at the request of counsel for respond number 2 to 4.
3rd February. Page number 12, serial number 77. Page number 14, serial number 78 to 80. Page number 15, serial number 81 to 85.
Have you informed the respondent? 81 released February.
3rd February.
Serial number 110.
120.
Respond number 2, but instead of wrongly calculated respond number 1.
Learned AGA accepts notice for respond 120. Learned AGA accepts notice for respond number 1, issue notice to respond number 2, returnable by February.
3rd February.
Yes. Yes. At the request of counsel for the petitioner, February.
3rd February.
110 was.
Huh?
Filed a memo for withdrawal from petition.
110, petitioner is before this court seeking for the following leave. A memo of withdrawal has been filed which reads as under accepting memo and submission dismissed as withdrawn.
My lord, serial number 115, my lord. I seek short accommodation, my lord. A week time.
115 awaiting service ideyalama.
Please, my lord, the notice has
115
been served,
awaiting
my lord.
service, relist also.
3rd February. List number 1, fresh matter, serial number 1, Ranjan Kumar.
Mic on ಮಾಡ್ಕೊಳ್ಳಿ.
Lord, read for a
Particular
mandam.
surface ಇದು.
Yes, DRT matters. But
You
not
should classify-
DRT, my lord. The proceedings against
GM,
DRT,
DRT and ಬರೆದ ಮೇಲೆ
one
ಯಾಕೆ ಇದು
submission.
ಬಂದಿದೆ ಇಲ್ಲಿ?
One submission, my lord. DRT, against DRT, my lord, the proceedings have been concluded. Now I am seeking for a direction, my lord, to the bank.
Yeah, we don't have jurisdiction. We are not the roster court. Every perusal of the file indicates that the matter relates to proceedings under surface. Registry is directed to place the matter before the appropriate bench as expeditiously as possible.
Serial number 2, Mohana Chandra.
But in this case, my lord, I am disabled. Henceforth, Ajay Prabhu will be appearing. My lord, his name may be shown.
Shri Ajay Prabhu accepts notice for respond number 1, na?
1.
Ready? None appears for the petitioner. Shri Ajay Prabhu accepts notice for respond number 1. Registry is direct delete the name of Shri Shanti Bhushan as that appearing for respond number 1. And AGA accepts notice for respond number 2.
The batch of
Lord, he
petition.
challenged for Kaushik of Annexure K, my lord. I will take notice.
EIA has to be submitted as well. Batch of petitions
The
there,
batch of petitions, my lord.
numbers,
Writ petition 7467 of 2007.
Ajay, write down the numbers.
Ajay.
Connect with so and so and relist. Yesterday I objections.
Applicant.
How long do you want to file objection? Have you filed objection in those matters?
Lord, I think I will take instruction, Lord, in that those matter I will not appear.
That counsels for the respondent seek for and are granted 3 weeks time to file their respective
Objection.
objection. Connect with so and so, relist and so and so.
3rd February. Serial number 3.
Here for the
MB
petitioner,
Chandrachуда.
the land of the petitioner has been submerged for construction of the tank. I filed an application for payment of the compensation. Not been paid till today, even after lapse of 15 years.
Who has taken this land now?
The minor irrigation department. Third
Minor
respondent.
irrigation department, a biggest problem. Urban Development Authority, minor irrigation. And without acquiring, you use the properties.
Yes, ma'am.
Even before construction of the tank, I filed a representation. It is submerged into the tank backwater. Please pay the compensation and make use of the land. Instead of doing that, you constructed a tank.
You are the
Entire
fringes
land
of the tank or you are in the tank?
I am in the tank now.
In the tank.
They have given representation, my lord.
Consider it. But then you need to come up with some scheme because so many matters are coming up before
Yes.
us on this.
I'll instruct.
That AGA accepts notice for respond number 1 to 5. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the land of the petitioner in survey number 42 of Doddikatte village, Vanvalli Obli, Tiptur Taluk, Tumkur district, has been made use of by the respondents for the construction of a percolation tank, and the petitioner has not been granted without any acquisition, nor has the petitioner been granted any compensation in relation thereto. Though several communications and correspondence have been exchanged with the state authorities, no action has been taken. The petitioner is before this court seeking for a direction to the respondent to consider the representation submitted by the petitioner on 18/10/2012 and grants necessary compensation. State or its authorities cannot make use of the land of a private individual, private citizen, without acquisition of the said land. Admittedly, in the present matter, the land of the petitioner has been made use of without acquisition. If such land is so used, it would but be required that acquisition proceedings are initiated now under the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013 as expeditiously as possible and necessary compensation granted. In that view of the matter, I pass the following. A writ petition is allowed, a mandamus is issued directing respondent number 3 and 4 to verify if the land of the petitioner has been used for the purpose of construction of the percolation tank, and if so used, which verification shall be done within 15 days from today. And if such use has been made, to take necessary steps to acquire the said land and make payment of compensation to the petitioners within a period of 120 days from the date of such verification.
Serial number 4.
Serial number 4, my lord, he is seeking for direction to investigation, my lord. He has given a complaint, my lord. I would take instruction. What is the status of those complaints, my lord?
Second round of, yes, my lord, on an earlier occasion had come before your lordships with a direction and they issued an endorsement. Your lordships would see the endorsement in page number 79, my lord.
He is not challenged that.
It's a
75.
79 is the endorsement. ಈ ಮೂಲಕವಾಗಿ ನಿಮಗೆ ತಿಳಿಪಡಿಸುವುದೇನೆಂದರೆ ದಿನಾಂಕರಂದು ನಿಮ್ಮ ಸ್ವತ್ತಿಗೆ ಅಗತ್ಯ ಕ್ರಮ ಪ್ರವೇಶ ಮಾಡಿ ತೊಂದರೆ ಕೊಟ್ಟು ಸದರಿ ಸ್ವತ್ತಿನ ನಿಮಗೆ ಸ್ವಾಧೀನವನ್ನು ಅನುಭವಿಸಲು ಬಿಡುತ್ತಿಲ್ಲವೆಂದು ಮೋಹನ್ ಸೆಲ್ವರಾಜ್ ಅವರ ವಿರುದ್ಧ ಕ್ರಮ ಮಾನ್ಯ ಪೊಲೀಸ್ ಆಯುಕ್ತರು ಬೆಂಗಳೂರು ಅವರ ಕಚೇರಿ ನೀಡುವ ದೂರು ಅರ್ಜಿಯನ್ನು ಪಡೆದು ಮೋಹನ್ ಸೆಲ್ವರಾಜ್ ಅವರನ್ನು ಠಾಣೆಗೆ ಕರೆಯಿಸಿ ಇನ್ನು ಮುಂದೆ ಸ್ವತ್ತಿಗೆ ಹೋಗುವುದಾಗಲಿ ಮತ್ತು ಅಲ್ಲಿ ಯಾವುದೇ ಕೆಲಸವನ್ನು ಮಾಡಿಸುವುದಾಗಲಿ ಮಾಡಬಾರದೆಂದು, ನಿಮಗೆ ತೊಂದರೆ ಕೊಡುವುದಾಗಲಿ ಮಾಡಬಾರದೆಂದು. And it's in a civil nature and they close it, my lord. But this man is continuing to harass me.
So did you file any civil suit restraining from interfering with your possession?
My lord, no civil suit is filed. No, I'll do that, my lord. But this man is an influential person. Even assuming that I get a temporary injunction or a permanent injunction, without the interference of the police, my
You
lord.
can't come to court on assumptions and presumptions.
Yes, my lord. My lord,
If you go to police for these kind of matters, you are unnecessarily giving them jurisdiction and power to do things which should not be given.
I'll proceed with the civil matter, my lord.
File
but
a civil suit, you get a police
I'll do that,
protection
my lord.
there, then you can approach
No,
them.
possession is with me.
Police protection. not-
Yes, madam. I'll do that, but if your lordship should also direct them to see at least that life protection may be given to me. My lord, there is a threat to my life also. That
Your so-called threat has been persisting for the last 3 years.
My lord, I have last complaint was given on 12/6/2025.
So there is absolutely no threat on that.
Annexure F.
And AG accepts notice for respond number 1 to 5, 1 to 4. Notice to respond number 4 is dispensed with the renewal of the proposed order to be. Petitioner is before this court seeking for the following reliefs. By way of the complaints complaints at annexure A to F above, what the petitioner had sought for was for response to take action against respond number 5 from interfering with the possession of the property of the petitioner and threatening the petitioner. On inquiry as to whether any civil suit had been filed by the petitioner, learned counsel for the petitioner fairly submit that no such suit had been filed. If no suit has been filed, the question of filing a complaint before the jurisdictional police authorities seeking for their for seeking for them to take action to restrain respond number 5's interference would not be permissible, since police authorities are not permitted to intervene in civil disputes. In that view of the matter, reserving liberty to the petitioner to file appropriate civil proceedings seeking for injunction or otherwise, and if such order is passed, to seek for police protection and then approach the police authorities, the petition stands disposed.
Serial number 5. Shamsundar VS.
Except for petitioner, my lords, may I request your lordships to kindly have this matter on Monday.
If it gets adjourned today, it will go to February.
Sorry, my lords, what happened is some instructions are missed. Otherwise, I would not have requested.
Pass over ಮಾಡ್ತೀವಿ. There are 348 matters today. We'll pass over, but if it gets adjourned, it will go to February. Your choice.
I need some time, that's the reason. Otherwise, I would not.
You want adjournment, we'll go there. Otherwise, we are ready today. Your choice. Beg ಹೇಳಿ.
Actually, kindly adjourn the matter.
At the request of the petitioner, released on.
3rd February. Serial number 6.
May I request if January, my lord? Sorry.
We are only adjourning 50 matters every day in January.
Serial number 6.
Petitioners.
Yes.
Swami, from Tanigehalli village to B Durga, there is a demoed reserve forest that is in Pollikere Taluk, Chidurga district. In that reserve forest, someone has started constructing roads. So, ಮೊದಲಲ್ಲಿ 8 feet ಬಂಡಿ ಜಾಡಿತ್ತು ಸ್ವಾಮಿ, ಅದನ್ನ 15 feet ಆಗಿ ಲಾರಿ ಹೋಗಕ್ಕೆ ಜಾಗ ಮಾಡಿ.
How are you concerned with this? Private interest ಏನಿದೆ?
Private interest ಇದೆ ಸ್ವಾಮಿ.
Public interest.
Public interest ಎಲ್ಲ ನಮ್ಮ.
File a public interest litigation.
Swami, I
comply with all the requirements, make your declarations, it will be considered in a public interest.
Swami, I have filed multiple complaints to DC and they have given a
Might have
report.
filed multiple complaints, but there is no private list. Private list is there, we can take it up. If it's a public list, we don't have the jurisdiction. It's only the public interest litigation roster which can take it up.
Swami, ಒಂದು humble submission already 2 reports ಬಂದಿದೆ ಸ್ವಾಮಿ.
ನಮ್ jurisdiction ಇಲ್ಲಪ್ಪ ಇದರಲ್ಲಿ. ಇವಾಗ ಏನ್ ನೀವು ವಿತ್ಡ್ರಾ ಮಾಡಿ ಕಂಪ್ಲೈ ಮಾಡಿ ಹಾಕ್ತೀರಾ, ಇದನ್ನ ಕನ್ವರ್ಟ್ ಮಾಡ್ತೀರಾ?
ಇದನ್ನ ಬೇಕಾದ್ರೆ ಕನ್ವರ್ಟ್ ಮಾಡ್ತೀನಿ.
ಇದನ್ನ ಕನ್ವರ್ಟ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಎಲ್ಲ
ಮತ್ತೆ
ಗವರ್ಮೆಂಟ್ಸ್ ಎಲ್ಲ ಅಂಡರ್ಟೇಕಿಂಗ್ ಎಲ್ಲ
ವಿಡ್ರಾ ಮಾಡಿ ನಾನು ನೀವು ಫಸ್ಟ್ ಫೈಲ್ ಮಾಡಿ.
Petitioner is before this court seeking, learned AG accepts notice for respond number 1 to 6. Petitioner is before this court seeking for the following reliefs. A perusal of the papers indicates that the petitioner has no private interest in the reliefs which have been sought for, and the reliefs are sought for in public interest. If that be so, the present petition before this court would not be maintainable. In that view, faced with the above situation, learned counsel for the petition seeks liberty to withdraw the above petition, seeks permission to withdraw the above petition with liberty to file a public interest litigation by complying with the requirements of so and so public interest rules. Reserving such liberty, petition stands disposed. Correct tag Aki onde sati. Why do you file like this?
Serial number 7. Ramanand.
Lordship, in this case, the petitioner is seeking for a CBI investigation on her complaint. Your Lordship, she owned properties from 15/12/2011 worth several crores. It was all stain things happened in 2020.
You filed any complaint?
Yes, I have filed a complaint.
Where is the complaint?
Filed Annexure A.
Annexure A.
And also complaint was filed before Pune CBI also. They have given an endorsement for referring to Bangalore thing. Your Lordship may kindly turn to page. They have issued an endorsement for Bangalore to.
This was filed in Pune.
Pune. Your Lordship, I'll highlight.
You directly filed it with the CBI. Have you filed with the jurisdictional police?
Yes, jurisdiction.
Where is that complaint?
It is in that complaint only, Your Lordship. It runs in page 65.
You cannot directly file it with the CBI.
No. Your Lordship may,
Where is the complaint filed with the
page
jurisdictional?
65.
65.
Volume
65. Is there any FIR registered in pursuance of this?
No.
Yes, madam. Find out whether any FIR is registered. What is the status of?
Your Lordship, that is the reason I have enclosed that complaint also as, and moreover, Your Lordship will see strange things. A registered deed dated 18/8 is registered on 22.
We'll find out if the
And the
investigation
police-
is, what is the status of investigation after your complaint which was filed on 14 July 25.
They have issued an endorsement. It is a civil dispute, and I am not. They are not taken cognizance. NCT CBI complaint is.
Have they issued an endorsement or not taken?
They have issued an endorsement.
Only the endorsement. Page number?
It should be.
519.
$599, Your Lordship may kindly turn to $599. 9. It's endorsement from CBI Pune also.
Not by CBI, Mr. Counsel. Again, you are mixing the matter.
I think I have not placed. I have not placed.
File it in Baswangudi Police finally.
Yes.
You went to CBI. CBI did not take action. You
Let-
went to
let
Pune.
them-
Pune did not take action. Jurisdiction was Bangalore. You file it in Baswangudi Police. Has Baswangudi Police given you any endorsement? What is the status?
Endorsement is given that they have not taken the action.
Is it
That it
produced?
has not been placed, I think.
Do you have a copy of it?
I'll be placing that copy.
And
In meantime, Your Lordship may kindly see the strange things, how things have happened. All properties transaction has taken place on one day. Very next day, a complaint is filed against our own. They have taken property, they have taken money, everything, and they have filed a false complaint against her. And next day, she's given only 12 crores. The property was purchased for 10 crores. The respondent number 4 has taken 97 crores.
We are not deciding your list.
Lesser
Our
than if FIR.
jurisdiction is limited.
Yes,
If you have submitted a complaint, whether they have taken it, if they have given you endorsement saying that it is civil in nature, in what kind of endorsement they have given. If it's civil in nature, you'll have to go for civil suit, that we'll examine. Learned AGA accepts notice for respond number 1 and 2. Shri P. Prasanna Kumar is directed to accept notice for respond number 3. Notice to respond number 4 to 14 is deferred for now. Learned AGA is directed to secure instruction, make a submission as to what action has been taken pursuant to the complaint submitted by the petitioner at annexure at document number 1. Your numbering is also your annexure A, document number 1 is annexure to annexure A.
Yes.
A complaint dated 11/7/2025 received by respond number 1 on 14/7/2025. Released on 17th December.
Bill number 8, Pawan Shah.
Waiting for Lord's matter pertaining to the issuance of passport.
Issuance, reissuance.
Issuance, my lords. Fresh issue for the pendency of the criminal proceedings which is stayed by this honorable court, my lords, in the year 2022. At annexure 16, my lords, the stay order. Annexure page 16, my lords.
Charge sheet has been laid.
Charge sheet has been also been challenged and that was also stayed by this honorable court.
This has been stayed.
Yes.
Lord,
Short validity.
yes, Lord, but my lord, if this, before traveling, they have to seek permission. My lord.
All the usual conditions.
But actually, my lord, prior condition, my lord, prior issuance of permission for challenge is prior condition, my lord, for issuance of passport.
So before they travel,
Please,
they'll take permission and they'll comply with the conditions of the trial court.
please.
Shri Ajay Prabhu accepts notice for respond number 1 and 2. Petitioner is before this court seeking for the following leaves. The grievance of the petitioner is that the request for issuance of a passport to the petitioner has not been considered by the respondent. Learned counsel for the Shri Ajay Prabhu, learned counsel for the respondent submits that the application could not be considered on account of the fact that during police verification, it came to light that a charge sheet had been laid in CC number 5854 of 2020, in crime number 34 of 2020 for offences under section 304, capital A of the erstwhile Indian Penal Code. His submission is that since criminal proceedings are still pending, the proceedings, the issuance of the passport could not be, aspect of issuance of passport could not be taken up. The counsel for the petitioner submits that the said charge sheet, laying of charge sheet has been challenged in criminal petition number 9470 of 2022 before this court, and this court wide order dated 29/9/2022 has stayed the further proceedings in said matter, and as such, the respondent ought to have considered the application submitted by the petitioner for issuance of passport. Heard, so and so perused papers. In the though learned counsel for the respondents submit that the prior condition for applying of a passport and consideration for the consideration of the said application is an approval stroke permission from the court seized of the criminal proceedings. In the present matter, taking into consideration that those proceedings have been stayed by order dated 29/9/2022 of this court in criminal petition number 9470 of 2022, the trial court would be unable to grant any such permission on a stay having been granted. As such, I am of the considered opinion that this court could direct the respondents to issue a short validity passport, but however making any travel of the petitioner subject to permission granted by the court seized of CC number 5854 of 2020, as also subject to the conditions that may be imposed in those proceedings. In that regard, the operation of the stay in the criminal petition number 9470 of 2022 is directed not to apply for the purpose of consideration of such an application as and when filed by the petitioner. In the above background, I pass the following order. Writ petition is allowed. A mandamus is issued directing respondents, now respondent number 2, to consider the application filed by the petitioner for issuance of passport and consider the same in accordance with law without insisting on a prior permission. Short validity and issue a short, consider the application without reference to the pendency of the above criminal proceedings and issue a short validity passport. The travel of the petitioner shall however be subject to prior approval of such travel by ಯಾವ court ಇದು?
37, my lords,
By
it
the
was brought to the
37th
notice.
ACJM Bengaluru, who is seized of CC number 5854 of 2020 and the conditions that may be imposed by said court on the travel of the
Lords,
petitioner.
one respectful submission we had,
Needless to say, if no such permission is obtained, petitioner would not be entitled to travel.
my lords, we had brought to the notice of the learned magistrate. However, the learned magistrate refused to entertain.
Because of the
our-
stay.
Yes, my lords.
That is why we have said it won't apply for that.
Yes, my lords.
Because of that stay, you are all coming before us.
Yes, my lords. Grateful, my lords.
Serial number 9, Maitreyi Krishnan.
Take notice for respondent 1 and 2, my lord, I will take instruction because he sought a compensation after disposal of the.
Compensation under the SC/ST Atrocities Act, my lord. The statute, my lord, basically, what it contemplates, my lord, one is punishment, but the other is, my lord, compensation and protection for the victims.
Yes.
In the instant case, my lord, the petitioner, she is the, Madam Lakshmamma, she is the complainant in the case. There was an atrocity that happened in 2008, ending in an acquittal in 2011. She challenged it before this honorable court, my lord. Annexure A may please be seen, page 10. This honorable court, my lord, overturns the acquittal and convicts, my lord, sentencing the accused all to imprisonment. Page 59, my lord. Honorable Apex Court has also upheld the conviction passed by this honorable court.
Now it is convict.
Yes,
Now
my
this
lord. Conviction is
compensation
confirmed
is
now.
on the basis of a complaint filed or conviction?
Lord, it is given on 3 headings, my lord, that is.
Yeah, section
on-
372.
on
na?
Filing
Yes,
of
my lord.
FIR,
This is
my
under
lord.
Atrocities Act itself.
Lord, that is under Atrocities Act, there is a circular
Atrocities
issued
Act.
by the state government, my lord. And that will be given on 3 headings, my lord. One is 25% on first
FIR
information report, my lord, 50% on charge sheet filing, another 40% after victim is punished, my lord.
Here, my
Take
lord,
notice because of that.
Accused is punished, victim
Accused.
alla.
Idರಲ್ಲಿ the only,
Not giving this compensation, you are punishing the victim.
but my lord, in this, I must clarify this. The
Section?
My lord, the sections, relevant sections are
Lord,
section
section
15A, 11B,
11B and 15A.
under 15A, my lord. There are two
15A,
provisions.
11B.
Yes.
State
Section
has,
15A, subsection 11B.
This is to provide immediate
Please, my
relief.
lord. Then there is rule 14, rule 15, my lord, which is the contingency plan by the state government.
What is the procedure to be followed for
Lord,
this?
that notification issued on 26/2016, my lord, under this act, my lord.
This is the notification.
Here's the notification.
My lord, just to clarify in this, the petitioner, my lord, her son is Govind Raju. He passes away, my lord, during the during this entire proceedings. For him, compensation has been refused, my lord.
Now, you are claiming compensation in which provision?
My lord, under rule 14 and rule 15, my lord. Rule 15(1)(f) provides for mandatory compensation for victims.
What is the particular, see, they have made separate classification
Yes, my lord.
and on that basis, the amount of compensation is.
Mine will come under section 3110, my lord. That was the offense at that time.
3110.
Please, my lord.
What is
Which is now
3110?
relatable to 31R.
31R.
Please, my lord.
Is intentionally insults or intimate with intent to
Intimidates.
humiliate. So 31R is, what is the amount?
It's 1 lakh, my lord.
Serial number PQR, yes. 1 lakh to the victim, payment to be made as follows: 25% on FIR, 50% when the charge sheet is sent to the court, 25%
On
when the accused are convicted by the lower court.
Please, my lord.
So no amount
No,
has been paid.
The first two amounts have been paid, my lord. But the last amount has not been paid because my son passed away in 2016. So they're saying that now we are not going to give you.
Who had filed the application?
Mother.
Mothers filed the application as the dependent on the victim, my lord. I have, my lord, pursued this case from 2008 till today, my lord, the petitioner.
The initial complaint was filed
By
by
me. By
you.
me, please, my lord. My son was injured, as Govindaraju. He was PW4 in this matter. He was injured, my lord, and then he passes away in 2016.
So how are you coming on a 3-1R?
My lord, 3-1, that's my
It's
lord.
insult.
At that time, it was 3-1R, my lord. The FIR was under 3-110.
Now it is 3-1R is what
Yes,
you
my
say.
lord. And that
3-1R is insulting.
Please, my lord. I'm only claiming that compensation as the dependent, my lord. My lord, please see the definitions.
How can you claim as dependent for insult?
A
Insult
victim,
is
my lord.
personal in nature.
My lord, the statute, the way the statute is contemplated, the victim, my lord, is not just in person. The victim or the legal heirs or the dependent. That's how, because this very offense, my lord, it's not just an individual who's being, the offense is committed. It's an offense against a community. Under that, my lord, which is why the statute itself provides that the victim, their legal heirs or dependents, all of them will be entitled to compensation.
How was your son injured?
During in this incident, his head was, it suffered a head injury.
So there was an assault.
Yes, my lord.
So it must be under another provision.
Allah, that at that time, my lord, when this, in fact, I had also done this matter before the criminal courts.
So why are you restricting it to a smaller provision of 3-1R?
Because that's our other madidru at time. FIR was only on 3-110.
And the prosecution is also
3-110. Conviction is 3-110. So now, my lord, everything is
323 and 324.
Yes.
But is there any other provision under which it would come under?
No, my lord.
Under the CST Act?
No, my lord. I've checked the provisions, my lord.
Inedible, obnoxious, excreta, injury, footwear.
Rule 15C, 1C. Sorry, my lord. Rule 15(1)(f). That is on mandatory compensation for the victims. I would come under that, my lord.
Physical harm is caveated with witchcraft. So it will come only under 3-1R.
Please, my lord, it won't come. And the conviction is under that, my lord. So
But
anyway,
under, for 323, 324 also there is a, anyway.
that would be under CRPC, my lord. Here, my lord, what happens, in conviction, this honorable court has already imposed a fine. So once they serve the sentence, my lord, I'll be entitled to that.
Yenappa,
Lord. Lord.
by when will you pay?
Lord, may I make one submission, Lord? Why ask the time? Because, Lord, an endorsement is issued an extra F, Lord. That says that already paid so-and-so amount.
75% has been paid. He is admitting that.
Clarification. Lord.
Balance 25% is what he is saying. If it is not paid, pay it within what time?
2 months. 2 months.
Petitioner is before the learned AG accepts notice for respondent 1 and 2. Petitioner is before this court seeking for the following reliefs. The petitioner and his son had filed an FIR which came to be registered as crime number 582 of 2008 by the Dandi Naushivara Police Station, Tumkur district on 14/8/2008. alleging that the accused therein had abused the petitioners on their as regard their caste, threatened their lives, and physically assaulted several members of the community, including the petitioner and her son. Investigation having been done, charge sheet had been laid, and cognizance had been taken in Special C number 288 of 2008, wherein the accused had been acquitted on 23/6/2011. Subsequently, on an appeal having been filed by the petitioner, the acquittal was overturned by this court by the judgment dated 31st October 2023 in criminal appeal number 876 of 2011, convicting the accused therein
My lord, page 48.
for offences under section 3 bracket 1 bracket Roman 11 of the Prevention of Atrocities Act, read with section 149 of the IPC. The petitioner, having earlier made an application for grant of compensation, the petitioner claiming that the petitioner would be entitled for a sum of rupees 1 lakh as compensation in terms of the government order number SWD 37 SPA 2016, Bengaluru, dated 20 June 2016. Only a portion of the said compensation having been paid is before this court, seeking for a direction to the respondent to make payment of the balance amount. In terms of the aforesaid government order dated 26/20/2016, it is clear that for an offence under section 3(1)R of the Scheduled Caste and Scheduled Tribes bracket Prevention of Atrocities Act 1989, which is in pari materia with section 3(1)11 Roman 11 of the Prevention of Atrocities Act, Scheduled Caste and which is in pari materia
3110, my lord.
with section 3(1)10
Please.
of the Act prior to the amendment in the year 2016, compensation of rupees 1 lakh is required to be paid, which shall be so paid as under: 1. First installment of 25% at the time of filing of the first information report. The second installment of 50% when the charge sheet is sent to the court. And the third installment of 25% when the accused are convicted by the trial court, by the lower court. Though the word convicted by the lower court has been used, I am of the considered opinion that if the lower court were to acquit the accused and the High Court were to convict the accused, it would be the date of conviction by the High Court which could have to be taken into consideration for the said purpose. And the 25%, balance 25%, was required to be paid after such conviction. Merely because there was an acquittal by the lower court stroke trial court would not mean that the respondent state would not be liable to make payment of the balance payment of the compensation. What is required is for the accused to be convicted. If the conviction were to be made by a higher court like the High Court, it would be for the state, it would then have been required for the state to immediately make payment of the balance amount of compensation. The same not having been done, I pass the following order. Writ petitions allowed. The endorsement dated 15/3/2025 issued by a second respondent at Annexure F is quashed. Respondents are directed to make payment of the balance compensation of 25% within a period of 30 days from the date of receipt of the copy of this order. Yenidiyappa, you have to process it immediately. First time when the acquittal happened, you are right. But once the conviction happened, you have to pay. After conviction, again, if they are acquitted by the apex court, is not a ground for you. What is required is only one conviction. They can't, there's no reimbursement.
Serial number 10. Harish Anna.
That petitioner submitted online application for attestation of a family tree through official website of the respondents. Respondent number 3 being the designated officer under the act. Without reason rejected on the reason ಕುಟುಂಬದ ಸದಸ್ಯರ ಮಾಹಿತಿಯ ದಾಖಲೆಯನ್ನು ಒದಗಿಸಿರುವುದಿಲ್ಲ ಅಂತ page number 20.
There's no interim order.
Page number 20.
AGA accepts notice. Thirty-one.
Please.
Yes.
ದಿನಾಂಕ 28/7/25 ಪ್ರಕರಣದ ವಿಚಾರಣೆ ನಡೆಸಲಾಗಿದ್ದು ಮೇಲ್ಮನವಿದಾರರು ಪರ ವಕೀಲರು ಹಾಜರು, ಎದುರುದಾರರು ಹಾಜರು. ತಹಸೀಲ್ದಾರ್ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ತಾಲೂಕರವರು ಅರ್ಜಿದಾರರ ಚಂದ್ರಪ್ಪ ಬಿನ್ ಸೋನ್ಸೋ ರವರು ತಾತನಿಗೆ ಇಬ್ಬರು ಹೆಂಡತಿಯರಿದ್ದು ಓರ್ವ ಹೆಂಡತಿ ಹಾಗೂ ಅವರ ಮಕ್ಕಳ ವಿವರಗಳನ್ನು ಮಾತ್ರ ನೀಡಿದ್ದು ಇನ್ನವರು ಹೆಂಡತಿ ಅವರ ಮಕ್ಕಳ ವಿವರಗಳು ನೀಡದೇ ಇರುವುದರಿಂದ ಮಹಾಜರ್ ವರದಿಯಲ್ಲಿ ಕಂಡುಬರುತ್ತದೆ. ಸದ್ರಿ ಅರ್ಜಿದಾರರು ಪಾವತಿ ಖಾತೆ ಉದ್ದೇಶಕ್ಕಾಗಿ ವಂಶವೃಕ್ಷ ಕೋರಿರುವುದರಿಂದ ಸುಳ್ಳು ಮಾಹಿತಿಯನ್ನು ನೀಡಿರುವುದರಿಂದ ಸದ್ರಿ ಅರ್ಜಿಯನ್ನು ತಿರಸ್ಕರಿಸಲಾಗಿರುತ್ತದೆ ಎಂದು ಅರ್ಜಿದಾರಿಗೆ ಹಿಂಬಾರ ನೀಡಲಾಗಿರುತ್ತದೆ. And even in his pleadings, he has nowhere stated about his two wives.
Please, madam. The respondent number 1 passed this order, madam, on the basis of the respondent number 3 Tahsildar on the report of the respondent number 3. Without recording my contention, madam, though there is no speaking out, my contention is also not recorded.
What is your contention?
My contention, my lord, I have submitted sufficient documents. My lord,
but you are the legal heirs.
I am the legal lord.
No problem.
I'm only legal.
There is no dispute about you being the legal heirs. The only problem is there are some other legal heirs also.
Like this is on the basis of the report of the Tahsildar, madam. Even my lord, except this regarding this report of the Tahsildar.
Harish, you have to give the details of them. They should have been made parties and they should have been heard.
That is like, please.
You have suppressed it.
I'm not surprised. Even the respondent number 2 ought to have given opportunity to at least to make them as parties.
You want to make them parties. So we'll set it aside, give you opportunity to bring them on record and consider your application.
Please, madam. One more submission, madam. Under section 13 of the act, 13 subclass 7, but the respondent number 1 and 2 have powers of the civil court.
To
and
conduct
also
an inquiry.
Issuing notice and summoning documents, all the powers they have.
It is your duty to make them parties.
That opportunity
it is
was
not for them to make an inquiry and make them parties. Don't go under 13(7).
Please, madam.
If you are going to make them parties, they'll consider that.
Let them pass reasoned order, madam, after remand. I will make them
order only if you make an application.
Please.
What will permit you to make an application to implead them and seek for recall?
Please, madam.
If you make such an application, we'll direct them to recall and proceed with the matter.
Please, madam. Let the matter.
This order will stay.
Let the matter be remanded to madam first respondent.
Remand ಮಾಡ್ತಾ ಇಲ್ಲ. Remand ಮಾಡಬೇಕು ಅಂದ್ರೆ it will be setting aside. We won't set aside the order. You make an application to bring on record the other legal heirs, and then if you make such application, we'll direct them to recall and proceed with the matter.
Please, my lord. And also, my lord, all the contentions may be, my lord,
will be open.
Please, my lord.
Petitioner is learned AG accepts notice for respondent number 1 to 4. Learned AG, sorry, petitioner is before this court seeking for the following grievance. The grievance of the petitioner is that the family tree sought for by the petitioner had not been furnished by respondent number 3 as required under the Karnataka Sakala Services Act 2011. Learned AGA submit that the application filed by the petitioner came to be rejected on the ground that as per the report of the Tahsildar, the grandfather of the petitioner is stated to have 2 wives the petitioner belonging to the family of one of the wives, the persons belonging to the family of the second wife have not been made parties. And as such, there being suppression of fact, the application came to be dismissed. Learned counsel for the petitioner submits that it was for the respondent to have issued notice under sub-rule 7 of Rule 13 of the
Sakala Service Act.
Sakala so-and-so, subsection 7 of section 13
Karnataka Sakala
of the
Services.
Karnataka Sakala Services Act 2011 and summon those family members
Please.
and proceeded with the matter.
Please.
I am unable to accept the submission of learned counsel for the petitioner that it would be the duty of the authority to issue summons when the applicant has not made the necessary persons party to the application filed by the petitioner. In that view of the matter, reserving liberty to the petitioner to file an application to implead those persons
Please.
which shall be considered by respondent number 3, and if such application is filed, to recall the order dated 1/8/2025, restore the said proceedings, conduct an inquiry in accordance with law. The petition stands disposed.
My lord, one more submission, my lord. Page number 20, my kindly seen, my lord. This is, my lord, I submitted application through online. Therefore, my lord, I have no knowledge of after passing of this impugned order only, I came to know, my lord. Even, my lord, there was no opportunity
When
of
you
being
submit
heard.
through online, you'll have to give all the details of the parties.
My lord, I have given
You're not.
all the details, my lord.
Did you give the details of the second wife and the
My lord,
children?
as per my condition, there is no second wife itself. That's all.
Then this order stands.
I will,
Don't try to get the property by this kind of methodology.
Serial number 11. H. Ashok Kumar.
My lord, this matter is pertains to Forest Department, my lord.
Forest?
I am challenging answer yes, my lord, page number 111. In this case, there is no notification and there is no joint service conducted.
No notification. Copy ಕೊಟ್ಟಿಲ್ಲ. ಯಾಕೆ copy ಕೊಟ್ಟಿಲ್ಲ?
Copy I have served, but after.
But until you serve a copy, nothing. There is no but until you serve a copy. Serve them a copy, then they will get instructions. Counsel for learned AG accepts notice for respondent 1 to 3. Counsel for the petitioner is direct furnish 2 sets of the petition along with annexures on the learned AG. Released on 17th December.
My lord, in this connected case, 34063, which is came before this court on 2nd, stay is granted in this case. In the same
We are not going to give you a stay without you having served. You can't bypass things. Connect with WP number so and so.
Serial number 12.
Birth code number.
P.R. Balra.
Petitioner, the society which is registered under Society Registration for Apartment Ownership Act, that is challenge. Next year.
Respond number 4.
Please.
You are ready to subject yourself to the deed of declaration in the Karnataka Apartment Ownership Act?
No, I am the resident of, one of the resident, my lord. I am the.
You ready?
Ready, my lord. ಅಲ್ಲ ಇದರಲ್ಲಿ.
Are you ready?
But society, but the association must be registered under the Karnataka Cooperative Society.
Are you ready?
Yes, please. Ready.
And AG accepts notice for respond number 1 to 3, issue notice to respond number 4. The categorical submission of the learned counsel for the petitioner is that the petitioner he is ready to sign such documents as may be necessary to subject the apartment complex to the and under the purview of the Karnataka Apartment Ownership Act 1972. 1972. And the fourth respondent society registered under Karnataka Societies Registration Act 1960 does not have the power to manage and maintain an apartment complex. Pending the registration of of the association by executing a deed of declaration under the Karnataka Apartment Ownership Act 1972, it would still be required for somebody to manage the affairs of the apartment complex. As such, at this stage, respondent number 4 cannot be restrained from collecting the maintenance amount and or carrying out the maintenance activities. This aspect would be considered after notice is served on respondent number 4. Petitioner is also permitted to take out hand summons on respondent number 4, returnable by so and so.
13. Rajesh Shettigara.
For petitioner, my lord.
Yes.
Challenging the notice issued by the third respondent for payment of ground rent, my lord. I am preparing food inside my house, my lord, near beach side, my lord, and selling there only, my lord.
30.
And also I am unauthorized occupation of this
Who
schedule.
is asking for ground?
Third
rent?
respondent, my lord. Tourism department, my lord.
As regards?
For payment of ground rent, because I am preparing food inside my house, my lord. I am selling there. That is situated near beach side, my lord. Therefore, they are interfering, my lord, and they are asking for payment of ground rent.
You are in unauthorized occupation.
Unauthorized occupation,
You are
my lord.
not the owner of that land.
But I have filed writ petition before this honorable court, my lord.
You want to be there free.
Not free, my lord.
Matte?
They have directed to consider my application, my lord, as per annexure K, my lord, page
You
number
are in
39.
unauthorized occupation of a portion of the beach.
No, that is
Other than
from,
throwing you out, they are asking you for ground rent.
from several years I am staying there, my lord.
That doesn't
In the
mean that
year-
you become the owner of the
In
beach.
the year 2016, I have filed application, my lord. They have not considered my application. Therefore, I filed a writ petition before this
And
honorable court.
AGA accepts notice for respondent number 1 to 4. Counsel for the petition. Service agreement. She seeks for and is granted 2 weeks time to obtain instruction, make a submission. January.
27 January. Serial number 14. N.R. Nayak.
Petitioner, my lord. The petitioner filed the application under section 5 of the KPM Act, my lord. The said application pending in the 2024, my lord.
You want to file a complaint.
Naxal Gmail, my application, my lord.
So your application needs to be considered.
Yes, Lord, I will take instruction, my Lord, I will make submission whether it is rejected or not.
If not rejected,
By interim, it will be considered, but by interim
not
order,
rejected, consider it.
he's seeking continuation of practice. That's why I will take an instruction, my Lord. It may be taken.
See, he's only asking for the application to be placed before the committee for registration. If not rejected, place it before the committee. Because if we adjourn it today, it will go to February. He'll have to wait for 2 months for that.
Oh, please.
And AGA accepts notice for respondents. The grievance of the petitioner is that the petitioner, being a doctor in naturopathy and yogic sciences, having made an application under
Lord, KPME Act, my Lord, under section
Private
5 of
Medical
the.
Establishment Rules 2009 for registration of the petitioner, the said application has not been considered and in fact not been placed before the committee for such consideration. The application having been filed on 23/2024, in my considered opinion, could not have been kept pending for more than 1.5 years. The same should have been placed before the committee and necessary orders passed thereon in accordance with law. In that view of the matter, I pass the following order. Writ petition is allowed, a mandamus is issued directing the third respondent to place the application of the petitioner dated 23/2024 before the committee for registration within a period of 15 days from today, if not already placed / rejected, and the committee is directed to take necessary, pass necessary orders on the same within a period of 30 days thereafter.
Serial number 15.
Lords, appear for the petitioner.
Vivekananda.
Lords, the petition before the NCLT, Lords, the petitioner is, herein is a petitioner therein, under section 241, 242 for operation mismanagement. Lords, Lords, why during the pendency of the proceeding, Lords, the petitioner was removed from the directorship, Lords. But subsequently, my lords, the NCLT directs us to furnish details regarding her employment in Karnataka state government, my lords. My lords, we make a submission to know whether she is disqualified. We file a memo, my lords, at page 116, indicating that she is not disqualified under the Companies Act. Section 164 is all comprehensive. She is not disqualified under that, my lords. But subsequent to that, my lords, an order is passed at page number 28, my lords, which is the impugned order, directing action against the petitioner, bringing it out at para 5, my lords, that a notice be sent to the concerned medical department through the Secretary Health, Government of Karnataka, Bangalore, informing that the petitioner had been a director of the respondent number 1 company while being a government servant. There is no submission on to that effect. To take necessary action under the conduct rules under the intimation to this tribunal. My humble submission is the jurisdiction which is not vested in the NCLT. So KCSR rules, even if that is where to be the position. My humble submission is.
Are you a government servant and you became a director of the company?
The position is this, sir.
It's only a show cause notice that they will issue. If you are in the clear, why are you bothered?
My humble submission is this, section 164 of the Companies Act brings out the disqualification.
Violation is being brought to the notice of a judicial authority or a quasi-judicial authority.
Violation is not brought in. It's an observation which is made without any, if I may just draw your lordship's attention to page 116.
Violation has come to the notice of.
There is no violation, my lords.
They have said that it appears so. They have asked the authorities to look into it. If you have no violation, if there is a notice issued to you, you make it clear.
My lords, but your lordship may kindly appreciate.
Honorable Apex Court has also said more than 20,000 rupees, if it is there, we have to bring it to notice of the income tax department. If a violation comes to the notice, we will have to bring it to the notice of the concerned department.
My lords, my humble submission is, my lords, the whole thing would fall under KCSR even if that were to be the case. And if I may just draw your lordship's attention to page 116, my lords.
The action will be taken under KCR Act only. It's not under the NCLT, under the IBC.
My humble submission.
Only being brought to the notice of the concerned authority to look into the matter, that you being a government doctor, you became a director in a private company, which is not permissible.
My humble submission is the petitioner and the respondent number 2, husband and wife, they became directors of the company. They started running the company. My humble submission is this.
Were you a government doctor in government employment at the time that you became a director?
That is not the case, but my humble submission is. My humble submission is.
Give you a notice, you respond to it.
My humble submission is, if I may just, it's not within the jurisdiction of the tribunal. If I may just rely on a couple of the case laws of the Honorable Supreme Court,
Tell us where, if a violation comes to notice, the court should restrain its hand. And
there is no, if I may just, before that, if I may just draw your lordship's attention to page 116, 116.
Yes.
Is a reply given, The petitioner herein submits that this honorable tribunal, wide order dated 3/9/25, had directed the petitioner to clarify aspects as to whether the petitioner was a director of the respondent company while in employment with the government of Karnataka, and whether requisite approval under the conduct rules for becoming a director of the private limited was obtained. It is humbly submitted that the petitioner herein that she was not disqualified under any of the provisions of the Companies Act 2013, that is section 164, which deals with disqualification for appointment of directors. For immediate reference, section 164.
Your client has been very smart. We will give her a certificate for that.
No, Lord, my humble.
What was asked was did she take permission under the conduct rules to become a director? And she goes on saying, in the 164, I am not disqualified.
My humble submission is this. Under the NCLT would have the jurisdiction under the Companies Act. The disqualification
now that
is
it has
complete.
Come to our knowledge, we will recommend if that is the thing.
If I may just draw your lordship's attention to the.
Yes, what is the judgment that you want to refer
to?
Yes.
Lords, in fact, if I may just draw your lordship's attention to the first case law, Whirlpool.
Yes.
Lords, if I may draw your lordship's attention to para 14.
14.
The power to issue prerogative writs under Article 226 of the Constitution is plenary in nature and is not limited by any other provision of the Constitution. This power can be exercised by the High Court not only for issuing writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari for the enforcement of any fundamental rights contained in Part 3 of the Constitution, but also for any other purpose. Under Article 226 of the Constitution, the High Court, having regard to the facts of the case, has a discretion to entertain or not to entertain a writ petition. But the High Court has imposed upon itself certain restrictions, one of which is that if an effective and efficacious remedy is available, the High Court would not normally exercise its jurisdiction. But the alternative remedy has been consistently held by this court not to operate as a bar in at least three contingencies, namely where the writ petition has been filed for the enforcement of any of the fundamental rights, or where there has been a violation of the principles of natural justice, or where the order of proceedings are wholly without jurisdiction. My humble submission is
Not relevant.
it is without jurisdiction, my lords. If I may also draw Lordship's attention.
We are not saying we won't excise. We are excising jurisdiction, upholding that order.
Lordships may kindly appreciate.
We are not saying you go to NCLT. You probably thought we'll say
No,
go to NCLT. But that's why you got this judgment. We are not saying that.
Lordships may kindly appreciate. If that is the case, my lords, all the aspects would be brought before NCLT. My humble submission is, if I may just draw Lordships.
Vivekanand, please understand the distinction. NCLT has not prosecuted you. Is not taking any action against you, your client.
No,
What NCLT has said is this issue has come to our light.
It's already
Has
given a
sent
finding
the
there, my lords.
details to the disciplinary authority to take necessary action and report to the NCLT. That report to NCLT may be not correct, but it's being brought to the notice of the disciplinary authority.
My lords, if I may submit, my lords, there is no submission on the part of the petitioner that she was a government employee at any point of time. And the
That's why
reply
we
does
are
not
asking
indicate,
you,
but the
are
order.
If you're not a government, that's the first question that we ask.
My lords,
Are you a government employee?
my lords, the submission that I made, my lords, even if she's a government employee, she's ready to resign if she's reappointed as a director, my lords.
That is a different issue.
So there is a finding,
That's a different issue.
my lords.
Please answer our question
Yes.
carefully. Think about it. We are
Yes.
asking you again.
Yes, my lords.
At the relevant time when you became a director of this company, were you a government employee?
My lords, she did not report and she stopped appearing. She has not gone to the government hospital at all, my lords. When she was a
We
director.
are trying
This
to
is-
avoid this question in
My
any
lords,
manner that you want.
My lords, my humble submission is this, my lords.
Was
did
she
not-
a government doctor, government employee?
My lords, at that relevant point in
That's
time,
all.
for whatever period, my lords, see, if I may just draw your lordship's attention. Your lordship's attention, if I may just draw to the third case law, my lords. Embassy,
Page?
page 45. my lords.
Yes. Para, page.
My lords, para 24, if I may just draw your lordships. My lords, in fact, if I may just draw your lordships to the very first paragraph, my lords. Two seminal questions of importance, namely, first, whether the High Court ought to interfere under Article 226, 227 of the Constitution with an order passed by the National Company Law Tribunal in a proceeding under the Insolvency and Bankruptcy Code, ignoring the availability of a statutory remedy of the appeal to the National Company Law Appellate Tribunal, and if so, under what circumstances. Lords, that is dealt with, my lords, in para 24, 29, 30 minutes. Para 29, if my quote, my lords, where the direction is given by the NCLT to extend the mining lease, my lords. That is challenged before the Honorable Supreme Court, my lords. Where it is held, it wouldn't fall within the jurisdiction of the NCLT to pass such an order, which falls within the administrative.
It's not a
jurisdiction.
direction.
My lords,
They would not have the jurisdiction to adjudicate upon disputes such as those arising out of MMDR and the rules issued thereunder, especially when the dispute resolved around decisions of statutory or quasi-judicial authorities.
so my humble submission is, my lords, administrative jurisdiction of public nature, my lords. It wouldn't fall within the jurisdiction of, my lords, so far as the court question, my lords, if I may just file a document to that effect, your lordships may kindly pass over to so, no, my lords, it would be my duty. Your lordships may pass it over. I'll just get the document to show your lordship that she was not, your lordship may kindly pass it over. I will file it along with the memo
If
right
you
now.
are, you are going to produce a document that she was not a government employee,
She was not serving the government, my lords. I will furnish it.
she appointed or not?
My lords, she was appointed long back, my lords, even before the company was incorporated. After the company was incorporated,
Mr. Vivekananda, we can tell you so many times, but when you cross the thing, then we'll have to now impose costs for these kind of matters.
my lords, in fact, that is the reason why I want to file the memo
Place it.
along with the document.
Place it. Because basic question you are not, if you are refusing to answer.
My lords, it's not a straight answer which I'm, that is the reason why I want to produce the document.
It is clear that that answer you can't give. As simple as
My
that.
lords, that is not, I'll produce a document, my lords.
You are put on notice, that's all.
Your lordship may
Pass
kindly
over.
pass it over, my lords.
Pass over.
Much obliged.
You are put on notice is what we have told you.
I'll furnish the memo. Much obliged.
Serial number 16, Syed Kamaluddin.
I appear for the petitioner, my lord. My lord, this is, my lord, a case for refund of a spoiled e-stamp paper, my lord, which is at page 45. I had, my lord, purchased an e-stamp paper wrongly in my name and my wife's name.
Spoiled, please.
Yes, ma'am. Spoiled in the sense, my lord, I purchased it for agreement of sale. I've printed a refund affidavit on the same stamp paper, my lord. I intended to refund, seek for refund of this page 45, my lord, annexure C.
Page
45, annexure C. This stamp paper, my lord, was wrongly purchased in the name of the husband and wife for agreement of sale. Then, my lord, the affidavit printed was for refund of the very same agreement of sale, my lord. We did not intend to execute this document. In fact, it was wrongly purchased, and we purchased a fresh stamp paper, my lord, annexure B, and the correct agreement of sale was executed. This was meant for refund, my lord. Wrongly an affidavit is printed.
And this affidavit is only by one of them.
Yes, my lord, only one of
The
them.
affidavit by the wife.
Yes, not by the wife, my lord. In fact, it was for
It was purchased in both your names.
Yes, my lord.
One of, you have asked only for one.
My lord, what is?
Where is the other person?
She is my wife, my lord. But this,
Where is that affidavit by the other person? Both of you
my lord,
saying
this
that
was
it's not.
stamp duty was paid only by Vishal Aurora. So they said,
We don't know who has paid.
my lord, my wife, my lord. I'll give that affidavit if required, my lord. Please, my lord. That is. I've extracted the section at page 7, my lord, of the petition, page 7 of the petition.
Stamp on any document which is written out only or in part, but which is not signed and executed by any party. But the document was supposed to be, what document was it supposed to be?
They have printed an affidavit, that should not be signed.
What is that affidavit, Ravindranath?
Sale agreement, document was purchased for sale agreement.
And what is the affidavit which has been printed?
Printed an affidavit.
What is the affidavit?
Affidavit was reimbursement.
Actually,
Can't be signed. If signed,
you can't be that hyper technical on things. They have got the affidavit, they did not, they got the stamp paper, they did not execute the agreement of sale. At the most, you could say, both the parties have not submitted the application. Unfortunately, laymen, they have made the affidavit on the same stamp paper and given it back to you.
that's what it says. It is signed.
They have given back the original stamp paper to you. So you should consider it. Get the affidavit of your wife.
My wife, my lord.
If she says transfer it to your account,
I will get that affidavit.
and AG accepts notice for respondent, when will you get it?
Any date, my lord. It may be 2 days or 3 days. I will immediately get it done.
And AG accepts notice for respondent number 1 and 2. Learned counsel for the petitioner seeks for and is granted a week's time to place on record the affidavit of the wife of the petitioner authorizing the, or we'll dispose the matter, they'll submit that. Why should we keep it pending? Petitioner is before this court seeking for the following reliefs. The petitioner and his wife had purchased a stamp paper for a sum of rupees 82,000 for agreement of sale between the petitioner, his wife, and the seller Srimati Nusrat Unissa. The transaction, for various reasons not having gone through, the petitioner made an application in the form of an affidavit on the very same e-stamp paper seeking for refund of the stamp duty on the ground that the stamp paper was not being used for the purpose that it was obtained. The said request of the petitioner came to be rejected by the respondent on the ground that the e-stamp paper, that an affidavit has been printed on the e-stamp paper and bore the signature of the petitioner, and as such there being an execution of a document, namely the affidavit, the same would come under the mischief of section 47(1)(b) of the Karnataka Stamp Act 1957, and as such the refund could not be made. It is challenging saying the petitioner is before this court. A perusal of Annexure C, which is the concerned stamp paper, would indicate that the stamp paper the property description is stated to be a description of the wrong, print the stamp duty is calculated under Article 5 bracket small e bracket Roman 2 for an agreement or the record of the MOA for sale of immovable property, namely an agreement of sale. The consideration being indicated to be 1,64,00,00,000, 000, a stamp duty amount is calculated at rupees 82,000,000. The affidavit, which is the perusal of the document, indicates that it is not an agreement of sale which has been printed on the said stamp paper, but it is an affidavit which has been printed and signed by the petitioner. And the affidavit, in fact, is a request made for refund of the amounts, the refund of the face value of the e-stamp paper. There is no other agreement or no other document which has been printed on the said e-stamp paper which would result in any agreement or arrangement between any parties. The affidavit is only a request made for refund of the face value of the e-stamp paper on account of the said stamp paper not being used. In fact, the said affidavit on the original e-stamp paper has been furnished to the respondent. In that view of the matter, I am of the considered opinion that the contention of the respondent that a document has been executed and therefore the refund could not be made cannot be accepted, inasmuch as the petitioner and his wife had purchased one other stamp paper on the very same date. Subsequently, by indicating the name of the seller and the agreement of sale had been executed, as regards which the very same sum of rupees 82,000 had been paid in terms of Annexure B. Thus, I do not find any reason as to why the respondent could have denied the refund of the stamp duty paid by the petitioner. That's what we say, affidavit beda. A perusal of Annexure C indicating that the stamp paper was purchased by the petitioner, it would be required for the respondent to refund the amount to the petitioner, though the name of his wife has also been mentioned in said document. As such, I pass the following. Writ petitions allowed. A certiorari is issued, and the endorsement bearing number so and so dated 12/11/2025 issued by respondent number 2 at Annexure A is quashed. A certiorari is issued. Certiorari madbudi. Mandamus is issued. Respondent number 2 is directed to refund the amount of rupees 82,000 towards the unused e-stamp certificate number so and so dated 5/11/2025 within a period of 60 days from the date of receipt of a copy of this order. Page 9 is the certificate number.
Grateful.
Hmm?
47B and C.
C ಅಂತೂ ಏನು apply 47B and C.
Serial number 17.
My lord, this matter pertains to government order directing closure of Jan Aushadhi centers.
Jana Aushadhi. Yeah, give that order. Same order, name, you have mentioned the name?
I mentioned,
12th.
please,
Connect with so and so, relist on 12th.
the name of the hospital is.
You mentioned that. Hospital change again, name of hospital.
Serial number 18. Vijay Kumar.
And for the petitioner in this matter, petitioner is before this honorable court challenging annexure H, page 241.
Sanction of prosecution.
Yes, my lord. Yes, my lord. But this is a case, my lord, so the petitioner is retired in 2014 itself. My lord, the incidents, my lord, he was also a committee member. During the year
2014.
Retired in 2014. My lord, he was also a committee member of the tender accepting committee. My lord, the chairman of this tender accepting committee was the my lord joint commissioner, and the other my lord chief engineer and the executive engineer my lords are the my lord technical heads my lord who are the tender accepting committee members. My lords, the petitioner was my lords assistant controller of finance. He has no role to play, my lords, in accepting the tender. Only one of the member was nominated for in the committee.
Member of the tender acceptance
Yes,
committee.
yes, my lord. Yes.
So he has a role.
My lord, may for a moment, my lord.
Then if he did not discharge his role, then another issue.
I was also a member of the committee, my lord. My lord, in respect of my lord, the first my lord, the chairman, my lord, the joint commissioner, my lord, there is no proceedings initiated against the joint commissioner. And my lords, the chief engineer and the executive engineer, my lords, who were the my lord technical heads, my lord, they my lord have been their sanction prosecution has been rejected by the very authority on the ground that there is no material available. My lord, when my lord, I have produced it annexure J, my lord, page 244, wherein my lords, in respect of the chief engineer and the executive engineer, my lord, in 32 cases.
Were they members of the
Yes,
tender
my-
acceptance?
yes, my lord.
Where do we get the constitution of the tender acceptance committee?
I beg
Where do we get the constitution of the tender acceptance committee?
My lord, that I have not produced, my lord. My lord, only with regard to my lord, so the committee decision was taken where my lord, the national standard rates have been adopted in view of the
We are not
decision, my lord.
deciding the merits, we are only deciding the sanction.
Please, my lord.
Your contention is Article 14 violation,
Yes,
certain
Lord.
others.
Yes.
So were they members, where is it shown?
Annexure J, my lords, 244 is the rejection in respect of the chief engineer and the executive engineer, my lord. Where, my lord, in respect of 32 cases, my lords, the sanction prosecution has been rejected in respect of the chief engineer and executive engineer. My lord, they were before this honorable court, my lords, in writ petition number 19221 of 2022. My lords would get it at page 185. Page 185, my lords, it's the judgment starts, my lords, from page 144. 185 is the common judgment is passed, my lords, where 19121 of 2022 is the petition. My lords, the first petitioner and the third petitioner, my lord. There, my lord, the sanction prosecution has been rejected.
Without there being sanction.
Yes, my lord.
So it was again remanded for.
Yes, my lord. Yes, my lord. Thereafter, my lord, the learned trial judge, my lord, learned session judge also, my lord, discharged the petitioner along with all others, my lords, which was questioned before this honorable court in criminal revision petition, my lords, by the state government.
That was due to non-grant of sanction.
Yes, my lord. Now, my lord, sanction has been granted, wherein, my lords, in respect of the technical health, my lord, chief engineer and the executive engineer has been rejected.
We are again going to ask you the third time.
Please, lord.
Show us where they were members of the technical tender acceptance committee.
Lord,
Then
that-
only Article 14 will apply. Just being the executive engineer, they won't.
Lord, that, my lord,
If they were members of the tender acceptance committee.
Yes, lord.
And then their sanction has been rejected, you can claim parity with them. If
They
not,
were,
you
my
can't.
lords. They were, my lords.
So show us where.
That, my lords, May I draw your lordship's attention to page 244, Annexure J, where the sanction has been rejected, my lords.
244.
Annexure J, my lords.
Huh.
My lords, this order is passed on, my lord,
We saw that it doesn't indicate that they were members of the tender acceptance committee.
they were all, this is the case, my lords, where one FIR is registered on the basis of the report of the TBCC. Nearly 150 charges have been filed, my lord.
That is why we
Yes,
are
my lord.
asking you. There, everybody, they made a party.
Yes, my lord.
The main important people are the tender acceptance committee.
Yes, my lord.
Implementation is next. So if any of the members of the tender acceptance committee, the sanction has been rejected, you can show it to us and claim parity. Otherwise, you can't.
Those are the members, my lords, where, my lord, the rejection has been done.
You place it on record otherwise.
My lords,
Learned AG
for a
accepts
moment,
notice
lords.
for respondent 1, 2, 3. Learned counsel for the petitioner seeks for and is granted a week's time to place on record any document indicating that the sanction has been refused in respect of other members of the tender acceptance committee.
That I have placed before your lordships, my lord.
Where
Annexure
is it?
J is the rejection, my lords, in respect of those other
Were they members, Mr.?
Yes, my lord, they were members, my lord.
Show us the document.
My lord, kindly see the document, my lords, the Annexure J itself, my lords, BG Prakash Kumar Mattu BT Ramesh, Chief Engineer. 259, my lords, is the very charge sheet, my lords, where the present petitioner is before
If
the
that is what it is, then we don't need to give you an opportunity. Correct?
Kindly have it, or otherwise pass over, my lords, I will place it.
We are trying to give you an opportunity, you don't want it.
Kindly pass over, my lord. Kindly pass over.
Pass over.
Serial number 19.
Yes, Mr. Arvi.
My lord, the second respondent has issued the Annexure K, page number 61.
61.
Page number 61K. My lord, the guidelines is issued by the Government of India, Department of Finance. Can you see, my lord, this is the meetings with SC, ST, OBC, PWD, Welfare Association, so revised guidelines as per the Department of Finance and the Government of India guidelines is, periodical meetings are being held with the combined SC, ST and OBC Welfare Association, so at the regional, zonal and all India level. My lord, the second respondent has bifurcating this, my lord, ST separate. Can you see page 63? Pradeshika Matta, Valaya Matta, Rashtriya Matta. There are 3 zones, my lord, it is. In the, my lord, 63, page number 63. And the second table, my lord, second table. Separate ST welfare.
Page?
63.
63.
The table 2, my lord, it is. Separate ST welfare association. There is no any separate, my lord. Combined SC, ST, OBC and PWD there. This is illegal show moto action taken by the second respondent, my lord. This is illegal against the guidelines of the government. And then, my lord, the can you see page number 62,
There is a
62.
combined SC, ST.
Please.
There is separate SC, there is separate ST. There is separate OBC, there is separate PW, person with disability.
There is no any separate, this only SC, ST combined in this only.
Then
But
we'll
he
have
is
to
making-
ask that information from them. You cannot say that.
Like, can you see page number 62, the point number 7. 7, my lord. Just above the table, my lord, is 7 point. 62. In the present setup as rosters are not being maintained as at regional offices, so hence the periodical meetings held with SC, ST, OBC welfare associations at regional office is dispensed with. It is illegal matters. There are 3 zones, but dispense with the regional office, that is illegal matters against the guidelines of the government. And restricting 22 representatives to participate in the meeting, it is also illegal. My lord, at least 18,000 employees working in the Union of India Bank, my lord, only 22 representatives participate. There is no in such guidelines. At least 30, 25 with the state level may participate, my lord.
Nobody is preventing you from having meetings. You can have meetings of all the SC associations. You can have a meeting of all ST associations. You can have a combined meeting of SC and ST associations. You can have a meeting of all OBC associations. You can have a meeting of all PWD associations.
It is welcome, it's welcoming.
You can't say that there should be only one meeting of everybody. What you're saying is there should be only one meeting.
Please, August, that's
What they are facilitating is one meeting of all the SC associations, one meeting of all the ST association, one meeting of all SC and ST combined, one separate meeting of OBC.
ST
Your meeting is not restricted.
ಅಲ್ಲ ಇದು ಎಸ್ ಟಿ ಅಂತಿದೆ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ ಎಸ್ ಟಿ ಬ್ಯಾಡ್ ಅಂತ
ಇದೆ. ST ಯಾಕೆ ಬೇಡ?
ಅಲ್ಲ ಕಂಬೈಂಡ್ ಇದೆ ಸ್ವಾಮಿ ಎಸ್ ಸಿ ಎಸ್ ಟಿ ಕಂಬೈಂಡ್ ಇದೆ ಬಟ್ ಸೆಪರೇಟ್ ಮೀಟಿಂಗ್ ದಟ್ ಇಸ್ ಇಲ್ಲಿಗಲ್ ಅಂತ ಸ್ವಾಮಿ.
Union Bank of India ಯಾರಮ್ಮ?
ಟಿ ಪಿ ಮುತ್ತಣ್ಣ ಮೇಲೆ ಟಿ ಪಿ ಮುತ್ತಣ್ಣ.
TP Mutharna is directed to accept notice for respond number 1 and 2. Counsel for the petitioner to serve 2 sets of the petition along with annexures on the
In
said
the
counsel
meanwhile-
released on 16th December.
Great. In the meanwhile, my lord, and they participate in the meeting at national level, my lord.
You can participate. In fact, it is for everybody.
Please, and
It is much better than what you are asking for.
Please, in interim order,
ಏನಂತ interim?
other
To
participate.
stop ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀರಾ, participate ಅಲ್ಲ.
At least alternative, this is, my lord, in the.
You can always participate. Who says no?
Left to the court order, my lord, and participate.
Petitioner has always the liberty to participate in any of the meetings conducted.
Great, my lord. And then,
Number 20.
participant recording, the hand is delivery, my lord, interim order.
Mr. Arvi,
Please.
you are asking it, you are restricting your client's right by doing this. Please understand.
Sorry.
20. Yana Nayak.
For the petitioner, my lord, the respondent issued the letter to the petitioner on 17/1/2025, Annex G, my lord, to stop the practice and pay the cost of rupees 1 lakh. My lord. The petition is the practice of homeopathy, not allopathic practice. My lord. I produced the Annex B and C, my lord.
You are a practitioner of?
Practicing homeopathy, my lord.
Are you registered?
Why the application, my lord? The application is not issued by the.
How can you practice without registration? This is a medical issue.
My
You
application.
You can't practice without
application
registration.
submit, madam, before the third respondent, madam. Third respondent not issued the application.
So
madam.
process that application.
And
They
madam,
don't give me permission, but I'm going to practice and prescribe drugs to people? No. By saying you are a doctor. Cannot happen.
the cost pay the 1 lakh rupees, my lord, you was then only
Have you stopped practice?
till today stop the practice, madam.
Give a undertaking that your will reduce the cost to 50,000. 50% ashte. You can't be doing this.
My lord, the use a village.
That is why people will think that you are a doctor and come to you when you are not a registered practitioner.
20%, madam.
How many people will be misled by this? And AG accepts notice for respond number 1 to 5. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the respondents have called upon the petitioner to stop practicing in the field of
Homeopathy, madam. The electric.
electro-homeopathy research and development. No, in the field of homeopathy. And levied cost of rupees, penalty of rupees 1,00,000,000 for having indulged in such practice without registration under the KPME Act. A purview of the petition indicates that the petitioner is a BA graduate who has joined some course called Karnataka Electro-Homeopathy Research and Development and has been carrying on his profession as a doctor of alternate therapy. And it is in that background that proceedings had been initiated against the petitioner. Though learned counsel for the petitioner submit that an application had been filed by the petitioner for registration of the KPME Act, his submission is that the said application has not been considered and no registration certificate has been issued. If no such registration certificate is issued, the petitioner could not have, on account of the so-called delay or otherwise, of the consideration of the application continued to practice without the permission having granted. More so when the petitioner is not even a doctor, but is only a BA graduate. In that view of the matter, I do not find any infirmity in the order passed. But however, considering the request made by the petitioner, counsel for the petitioner, that the petitioner resides in a rural area and the cost of the penalty of rupees 1,00,000,000 is on the higher side. The said penalty is reduced to a sum of rupees 50,000,000. The rest of the terms of the order dated 17/1/2025 remain unaltered.
21, R. Shashidhara.
Petitioner in this case, my lord. So questioning the order passed by the court below at annexure K, my lords, wherein the response number 2 to 9 were permitted to withdraw 50% of the compensation amount deposited by the first respondent. The first respondent has my lord, filed the reference petition under section 3 of the National Highways Act, my lord, with the dispute with regard to the entitlement of compensation.
Land acquisition matter ಅಲ್ಲ ಇದು ನಮ್ಮ ಮುಂದೆ
National Highway Authorities Act.
ಆಯ್ತಪ್ಪ ಅದು land acquisition.
No, my lord,
What you are seeking for is as regards compensation amount, not to be discharged. It will have to go before the land acquisition roster.
Office has made him GMRS.
Ingama, how is it coming? You had made it as CPC.
Yes, I am from CPC, but office has made GMRS.
Can be CPC.
Since his application and order is passed on the.
So the matter indicates that it relates to the awardal and stroke withdrawal of compensation in persons of acquisition of land. Registry is directed to place the matter before the appropriate.
Tomorrow, matter is urgent.
See, we are having this problem in all this wrongly classified. This will again have to go to the chief and he has to allot. You want shortcut, what is to long cut agatte.
They withdraw the amount. If they withdraw, my lord, my suit will become infractious.
We can't direct the chief to do it in one day. So
Office may be directed to my lord, earliest.
Place it before the appropriate bench as expeditiously as possible. Correct ಆಗಿ ಅಲ್ಲೇ ನೋಡ್ಕೊಳ್ಬೇಕು ನೀವು.
Not allowed to.
SAS ಮಾಡಿ can do the self assessment of all the scrutiny ಅಂತ ಹೇಳಿದ್ರೆ ಅದು ಮಾಡ್ತಾ ಇಲ್ಲ. If you do that, all these issues will be sorted. You will yourself know what is the classification.
CPC, my lord.
How can it be GMCPC? Next.
22, VF Kumar.
The appeal for the petitioner. This is pertains to the Janaushadhi came out.
Janaushadhi.
12th ಇದೆ.
IA 125 is allowed. Name ಹೆಸರು ಬರ್ದು ಕೊಡಿ. What is the name of the?
Please, my lord.
Same order, released on 12th.
Serial number 23.
23 is a general peril, my lord. Take instruction.
23 is GM-RES.
GM-RES is general peril, my lord. 90 days is sought, my lord.
My lords, I am seeking a mandamus to R1 and R2, seeking implementation of online hearing in RTA first appeals, my lord. I have given a representation to Chief Secretary and Secretary DPIR on 14th October.
And AG accepts notice for respond number 123, seeks for and is granted 10 days time to obtain instruction and make a submission.
My lords.
Released on 17th
My
December.
lords, I am seeking an interim order.
We can't by interim order direct online.
Tomorrow there is 2 appeals. It is in Hubli.
So by that time you want the online hearing to be established in one day.
There is one Supreme Court judgment which is.
Supreme Court judgment is there. Our judgments are there to establish it. But can an online hearing be established in one day?
In Zoom or WebEx they can. If
They need to get computers. They need to set up infrastructure. They need to get internet.
My lords.
Nam court al madakunu ಎಷ್ಟು ದಿನ ಆಯ್ತು?
ಅಲ್ಲಿ R3 ಇದು ಕೊಟ್ಟಿದ್ದಾರೆ my lords. There is no provision ಅಂತ.
That we'll deal with. We can't say for tomorrow establish. Let them file their application.
Any date name you.
17th.
24. Basavana Tem.
Gadipar, my lord.
Gadipar. Annexure D, page number 25, my lord.
Yes.
Externment.
Externment.
Please, madam. The petitioner is involved in the 4 cases
Two cases is
You
acquitted.
received
my-
instructions?
Lord, I will take the notice.
And AG accepts notice for respondent number 1 to 4. He seeks for and is granted a week's time to obtain instruction, make his submission. Released on 17th December.
25, Pradeep Patil.
Idu
My lord,
parole.
Parole. My lord. My
Pradeep
lord.
is Pradeep Patil parole.
Yes, no, my lord. I don't.
ಇಲ್ಲ, triple P ಆಗೋಗುತ್ತೆ. And AG accepts notice for the respondent. He seeks for a week's time. Released on 15th December at
My
2:30
lord,
PM.
along with serial number 26, 30 and 32, my lord.
ಅದಕ್ಕೆ ನೋಡಿ PPP ಅಂತ ಹೇಳಿದ್ರು.
ಇಲ್ಲ.
26,
26, 30, 32.
30, 32.
Yes, my lord.
All on
Obliged.
15.
Obliged.
27,
Lord, 27 club matter, my lord.
Club mat.
Recreation of club.
Tender ಅಂತಿದೆ.
It's regarding tender, my lord. Without
Tender.
following the tender has been not been invited, my
Sir,
lord. They have
then-
randomly issued the work order.
In your list is wrong or what is that?
Lord, there is some difficulty in my list only, Lord, sorry.
Lord, I have sought to quash Annexure D, my lord. Without calling for the tender, my lord, the work order has been issued randomly.
Without calling for tender.
Please, without calling the tender.
Where is the work order?
Annexure D, my lord, page number 18, my lord. The ತಮ್ಮ ಮನವಿಯ ಪತ್ರ ದಿನಾಂಕ so and so, and my lord, they have issued the work order to conduct the sports adventure activities in Srinivas Sagar Lake, my lord.
We'll issue a qualified order. If there's no tender called, we'll stay it.
Please, my lord.
And AG accepts notice for respondent number 1 to 4, issue notice to respondent number 5, returnable by January. The operation of the work order dated 21/5/2025 at Annexure D in favor of respondent number 5 is stayed subject to, in the event of no tender having been issued
My lord, there is no tender. has
prior
been
to the work order dated 21/5/2025 at Annexure D, the operation thereof would remain stayed till the next date of hearing. Process fee and copies to be furnished by end of day tomorrow, failing which interim order.
29 January, serial number 28, Parani.
I'm attending the petitioner in this case, my lord. Petitioner is before this honorable court second time, my lord. First time the petitioner is acquitted from the criminal case, my lord.
ಕೇಳಿಸ್ತಲ್ಲ?
Petitioner is acquitted by the criminal case, my lord. Then the petitioner approached to remove his name from the rowdy sheeter
the
list,
rowdy
my
sheet.
lord. Please, my lord.
There's no proceedings which are pending?
No, madam, this honorable court is allowed the petition, my lord, directed to consider. After that, my lord, the endorsement has been, page number 68 may be taken, my lord.
68.
68, my lord. 6/6/2025, my lord.
Hmm.
There's no criminal case pending against me, my lord, but they says, my lord, they may read this.
CC number 443 is pending ಅಂತಾರೆ?
No, my lord, that has been acquitted. I am acquitted from that criminal case, my lord. Page number 44, my lord, the order is, trial court order, my lord.
Annexure L is passed, my lord, that is the Annexure J, sorry, my lord. Annexure J,
ಖುಲಾಸೆಗೊಂಡಿರುತ್ತದೆ.
my lord.
Annexure J says 443.
ಹೌದು.
They say 443 acquittal. Where is the acquittal order?
We will reconsider that representation, my lord, if there is any
Where
case.
is the acquittal order in 443?
That
Page number 44 may be taken, my lord.
44.
44, my lord. Under section 248, my lord, the accused is acquitted from the, under section 323, 324, 494, 496, my lord. ಇಲ್ಲೇ ಹೇಳಿದ್ದಾರೆ, endorsement ಅಲ್ಲೇ ಹೇಳಿದ್ದಾರೆ,
Notice for
ಖುಲಾಸೆಗೊಂಡಿರುತ್ತದೆ.
respondent number 1 to 4. Petitioner is before this court seeking for the following leaves. The grievance of the petitioner is that despite there being no criminal proceedings which are pending against the petitioner, the request made by the petitioner on 16/5/2025 for deleting the name of the petitioner from the rowdy sheet list has not been considered favorably, and an endorsement dated 6/6/25 has been issued by respondent number 4 at Annexure J, stating that there is a proceedings in CC number 443 of 2015, which is still pending. The counsel for the petitioner refers to Annexure
ಮೆಲೋಡ್ ಮೈ ಇಂಟರಪ್ಟ್ ಮೆಲೋಡ್ ಅಲ್ಲ ಅವರೇ ಹೇಳ್ತಾರೆ ಖುಲಾಸೆಗೊಂಡಿರುತ್ತದೆ ಅಂತ ಅವ್ರೇನ್ ಹೇಳ್ತಾರೆ ಸುಮ್ಮನೆ ಅರ್ಜಿ ಬರೀತೀರಾ ನೀವು ಅದಕ್ಕೆ ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂತ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಮಿಯ ರೀಡ್ ಮೆಲೋಡ್ ಎಂಡೋಸ್ಮೆಂಟ್ ವಿಚಾರಣೆ ನಡೆದು ಖುಲಾಸೆಗೊಂಡಿರುತ್ತದೆ
ಇದೇನಪ್ಪ ಇದು?
Lord,
How can they write like this?
Lord, may make one submission, Lord. In a rowdy sheeter matter, Lord, it is not the case where the case is also pending, Lord. The conduct of the person who shows to the society if there is any threat to the society, my lord, that is one aspect. But for that I have to take instruction. But the case is that declare that, my lord, that is closed anta. That is only.
You open all these rowdy sheet against people, but you never succeed in any proceedings against them.
Lord, that is only
And you continue
to prevent.
Keep the rowdy sheet opening. Do the investigation properly, convict them.
But rowdy sheet is only to prevent the
What is the point
evil
in
things in
doing
society,
this when
my lord?
there is no proceedings, and what proceedings you file? He has been acquitted.
Lord, the rowdy sheeter's case will be open to monitor the persons if he is involved in any to threat to the society. If he is having such a nature where he is making trouble to the society, then it will be open, my lord. That the concept of opening the rowdy sheeter, my lord. It is only that we are not harassing him. We not. There will be eye on him whether he is committing a same again and again. Because of that reason, that rowdy sheeter will be open.
There is only one proceeding against the petitioner. You can't use the executive power for these kind of things. There was only one proceeding that has ended in acquittal. And then you are, after acquittal also you are saying.
We will reconsider it.
Don't send these kind of letters. You won't consider.
We will reconsider.
What is the point in doing this? You will open rowdy sheet against anybody.
No, I beg your pardon. It's not like that, my lord. I will reconsider it, my lord.
You do your investigation properly and succeed.
Obliged.
No, proceedings pending. Though the proceedings in CC number 443 of 2015 has ended in acquittal on 18/6/2024, it is contended that the petitioner has been issuing unnecessary letters for. How do we even say this? It is such a ridiculous letter.
Whatever illegality is going on, my lord, I used to write a letter, my lord.
Unnecessary letters are being sent by the petitioner. And therefore, the name of the petitioner cannot be removed from the list of from the rowdy sheeter list. I am unable to, such a letter or such a rejection letter cannot be countenanced in law. A rowdy sheet having been opened against the petitioner for alleged threat to the society on account of there being a proceeding which had been criminal proceedings which had been filed against the petitioner. The same has ended in acquittal. During the pendency of that proceedings or thereafter, there is no other proceedings which have been taken up against the petitioner, which would indicate that the petitioner is a threat to the society or otherwise. The rejection at Annexure J is only on account of the petitioner allegedly having sent certain letters unnecessarily, and therefore the application of the petitioner was rejected. Such a ground for rejection is not available for the respondent. The opening of the rowdy sheet and the continuance thereof would have to be on the basis of material on record which indicate that the person against whom a rowdy sheet has been opened is a threat to the society and not otherwise. In the present case, there being no proceedings filed or pending against the petitioner during the pendency of CC number 443 of 2015, it cannot be said that the petitioner is a threat to the society as contended by learned AGA. In that view of the matter, I pass the following order. Writ petitions allowed. The endorsement dated 6/6/2025 issued by respondent number 4 at Annexure J is quashed. The respondent is directed to consider the representation of the petitioner dated 16/5/2025 at Annexure L in terms of the above observation within a period of 30 days from the date of receipt of a copy of this order.
Much obliged.
29, Varun Joshi.
Bank freezing, my lords. Bank freezing, my lords.
Freezing.
Pursuant to an arbitral award, my lords. The lordship will see, my lords, an interim order came to be passed, my lords, page number 21, against me in an arbitral proceedings, my lords.
By which arbitrator? By an arbitrator?
By online arbitration, my lords. It's not even pursuant to 11.6 order, my lords. The online arbitration is invoked against me. Page 21, my lords, an order is passed under section 17 of the Arbitration Act.
Page number?
21, my lords. An interim order is passed under section 17. Your lordship will see in the second, after A, my lords, name Madan Kumar, Siddhan Kode so and so, account number so and so, an order is passed, my lords, directing freezing of the bank account.
Who appointed this arbitrator?
Online arbitration, my lords, without following section 11.6, my lords, there's a loan agreement between the petitioner and respondent number 2, my lords. I default in my loan payment. They invoke the arbitration clause in, my lords, they go to an online arbitration center without following section 11.6. In that arbitration proceeding, my lords, an interim order is passed pursuant to their application.
Is there arbitration agreement between you and respondent number 2?
They say, my lords, it's a loan agreement. In the loan agreement, they say, my lords, I am not party to the arbitration, my lords. It's an ex parte arbitration proceedings.
Where is the loan agreement?
My lords, I'm not party to the arbitration proceedings itself. It's an ex parte arbitration, my lords.
Is there an arbitration clause? Please answer the questions which
But we don't have the.
You're not answering, that means.
No, I don't have the copy of the.
You don't want to answer, or the answer is uncomfortable?
No. I am told, my lords, he took a loan from the bank. That is undisputed, my lords.
Is there an arbitration clause in that?
We don't have the copy of the arbitration, the loan agreement with us, my lords.
So 21 notice was issued and arbitration proceedings were registered.
Please, my lords. I have not given my consent, my lords. Anyway, my lords.
11.4 and 11.5 violated.
Please, my lords. Then, my lords, section 17 application is filed. Page 21 is the interim order passed by the arbitrator. The interim order, my lords, in page 21, my lords, is continued in the final award, my lords, at page 32.
Madam, the state will have to take, Ms. Kulkarni, state will have to take a stand on this. There is a private arbitration ODR centers established. Notice issued for appointment of an arbitrator. No reply. No consent. They go to this ODR platform. Arbitration proceedings are registered. Notice issued to them to file written statement. Not filed, matter proceeded with. Order passed. That order is communicated to your police to register, freeze the account of the petitioner.
There is no, my lords. The bank, my lords, based on the interim order, writes to Karnataka Bank, that is respondent number 1, saying there's an interim order passed by the arbitrator, freeze my account. And
that is what we say.
Please.
What did we say? Same thing.
Police, my lords, not.
The bank writes.
Please.
Not through the 1099. In our.
Lord, I think there is, Lord, I think there is all banks have their own arbitrator, my lord. It may be the bank has to answer for that.
Bank can have their
if
own
anything
arbitrator
which is,
after
Lord,
Supreme Court decision. It has to be either consent or through court. They can't have their private panel and pass orders the way that they want.
Lord, in other 2-3 matters, Lord, where we're privately practicing, it was seen by other people where they will call them.
It
They will
used
call
to be
for
there, but now with the Supreme Court
they will
judgment
call for
clearly
settlement.
there, that there can't be unilateral appointment of an arbitrator. Arbitrator is by consent.
Obliged.
In fact, in one of the matters, you are appearing, where we have directed action to be taken. So without even a claim statement, the arbitrator passed an order.
Oh.
Because he is appointed.
It is
and he's being
listed
paid.
today. It is listed today also. I need to bring the original records.
They can't be agents of the bank or they can't be agents of anybody.
Obliged.
It has to be done as per law. And
One-
if this
one
kind of
last
things are
aspect.
happening, you will have to take action on that.
One last aspect, my lords. Page 32, my lords, is the final award.
Final award also.
Final award also is passed.
Very
The
nice.
arbitrator says the interim measure granted in section 17 is continued till you can enforce the award. The time for enforcement is done, my lords. Then 1 year later they
Karnataka
seek
Bank,
for-
Yarama.
Divya Purandar.
Ms. Divya Purandar is directed to accept notice for respond number 1. CSB Bank. What is CSB Bank?
But it's a private bank, my lords.
What is the full form of CSB?
Catholic Syrian Bank.
Catholic Syrian Bank.
Catholic Syrian Bank ಯಾರಿದ್ದಾರೆ?
Uday Shankar Rai.
Hmm?
Uday Shankar Rai.
Uday Shankar Rai. So if you put CSB, we won't understand. Uday Shankar, if you give the full name, we'll know the advocate.
Please, my lords. The cost title
Uday
is,
Shankar Rai is directed to accept notice for respond number 2, being of the considered opinion that the stand of the state would also have to be, is required to be considered in view of a private arbitration having been resorted to through an online dispute resolution forum by appointment of an arbitrator without the consent of the petitioner, the state of Karnataka represented by.
Lord, Principal Secretary only, but one thing, my Lord, may I make, I am not shifting.
We'll make the chief secretary a party.
I agree, my
because we
Lord.
don't know
I am
which-
not shifting the burden on other, my Lord. But the banking, on the bank authorities, my Lord, we will not have an authority to that where instruction has to be given under the Banking Regulation Act.
Take
that is-
action against these people, then everything will.
Lord, even if we come to know that in such a situations, we will take action. Otherwise,
By the chief secretary is brought on record as respond number 3. And AG is directed to accept notice for respond number 3. Being of the further opinion that the Reserve Bank of India is required to be brought on record. The Reserve Bank of India is brought on record as respond number 4. Shri Pradeep Saukar is directed to accept notice for respond number 4. Mr. Kamucharan, you were here when the arguments were.
Missed the last few minutes.
The facts are these. He has entered into a loan agreement with one bank. The bank goes to one online dispute resolution forum saying you are recognized, we'll appoint you are appointed to do it. They appoint an arbitrator. Notice is issued to them. They don't go. They are placed ex parte and matter proceeds.
No consent is taken from them.
No consent.
In the
Section
agreement
17 order passed, freezing his bank account. That order is communicated by the lender to his bank. And account is frozen. Thereafter, the matter, it doesn't stop there. Matter proceeds. Award is being passed ex parte for recovery. This is worse than unilateral appointment. So what is the stand of RBI? Can this be done?
I will seek instructions.
If this is arm twisting. This is even worse than hiring rowdies and goons to recover. This is all done in a very white collared manner. So you will have to make your stand clear. Since the order passed by a so-called arbitrator is without jurisdiction inasmuch as the petitioner has not consented to such appointment of an arbitrator, the operation of what is that order?
That's the award, my lords, is
The operation of the award dated
22/7/24, my lords. At page 24.
22/7/2024 at Annexure D. He stayed till the next date of hearing.
But copy may be served that.
Counsel for the
without
petitioner
copy,
is direct furnished 2 sets of the petition along with annexures. The learned AGA and the counsel for the RBI released on 17th.
Please. Grateful, my lords.
Counsel for RBI and other counsels, that also.
Serial number 30, adjourn 31, Vijay Prasad.
Lord 21, general peril, my lord. I will take
Learned AGA
notice.
accepts notice for respondent released on 15th.
Serial number 32, adjourn 33, Kashinath Dedi.
Extremement.
It's an order of externment, my lord.
External.
Yes, my lord.
Have you got the instructions?
Lord, I will take notice.
And AGA accepts notice for respondent number 1 to 4. He seeks bond is granted a week's time to obtain instruction, make a submission, released on 16th December.
Obliged.
34,
Yes.
Lord,
Yes, Mr. Reddy.
beg your pardon, my lord. In this, I needs to file an objection. It was, earlier it was listed on my request only.
I spent some money, I had an affair with a lady, my lord. That lady now has it out at me by filing a criminal complaint saying there is stalking, and for that they have issued a LOC and prevented my economic activities which I perform abroad.
What is the notice what has been issued?
LOC, my lord.
Why?
Because she went and filed a case saying that I had intimidated her, and somebody had taken photos, they had sent it to me and I had sent it to her family. This is the only allegation against me in the criminal complaint. On
Where
this.
is the complaint?
Yes, please. Now kindly see page 15. That portion. Para 16. I'm sorry, page 16. In that last para in that page. August 2005 ನಲ್ಲಿ ನನ್ನ ಸ್ನೇಹಿತರಾದ ವೈಶಾಖರ ಮನೆಗೆ ಅನಾಮಧೇಯ ಪತ್ರವೊಂದನ್ನು ಎಸೆದಿದ್ದು, ಅದರಲ್ಲಿ ಅವರ ಪತ್ನಿ ಮೇಘಾಗೆ ನನ್ನ ಮತ್ತು ವೈಶಾಖ್ ನಡುವೆ ಅಕ್ರಮ ಸಂಬಂಧವಿದೆ. ವೈಶಾಖ್ ಜೊತೆಗೆ ಹೊರ ಊರುಗಳಿಗೆ ಪ್ರವಾಸ ಹೋಗಿ ಸೊ ಮತ್ತು ಆತನಿಂದ ಹಣ ಪಡೆಯುತ್ತಿರುವುದಾಗಿ ಅವಹೇಳನ ಮಾಡಿ ಪತ್ರದಲ್ಲಿ ಬರೆದಾಕಿರುತ್ತಾರೆ. ಅಕ್ಟೋಬರ್ 1 ಮತ್ತು 15ಕ್ಕೆ ಮತ್ತೆ ಅವರು ಮತ್ತು ಮನೆಯ ಮಾಲೀಕರು ವಿಳಾಸಕ್ಕೆ ನಾನು ದಿನಾಂಕ 17/8/25 ರಂದು ಬೆಂಗಳೂರು ವಿಮಾನ ನಿಲ್ದಾಣದಲ್ಲಿದ್ದಾಗ ನನ್ನ ಅರಿವಿಗೆ ಬಾರದಂತೆ ನನ್ನ ಫೋಟೋಗಳನ್ನು ತೆಗೆದು ಸದರಿ ಫೋಟೋಗಳನ್ನು ಮನೆಯ ಮಾಲೀಕರಿಗೆ ನಾನು ಇರುವ ಮನೆಯಲ್ಲಿ ಸೊ ನಡೆಸುತ್ತಿದ್ದೇನೆ. ವೈಶಾಖ್ ಮತ್ತು ಇತರ ಹುಡುಗರನ್ನು ಮನೆಗೆ ಕರೆದು ಅವರಿಂದ ಹಣ ಪಡೆದು ಅನೈತಿಕ ಚಟುವಟಿಕೆ ನಡೆಸುತ್ತಿದ್ದೇನೆ ಮಾನಹಾನಿ ಮಾಡುವ ಪತ್ರ ಬರೆದಿದ್ದಾರೆ. ಸದರಿ ಫೋಟೋಗಳನ್ನು ವೆಂಕಟೇಶ್ ರೆಡ್ಡಿ ರವರ ಪರಿಚಿತರಾದ ಆರ್ತಿ ಪಡಿಬುದ್ರಿ ಎಂಬವರು ನನ್ನ ಫೋಟೋಗಳನ್ನು ತೆಗೆದು ವೆಂಕಟೇಶ್ ರೆಡ್ಡಿ ಅವರಿಗೆ ಕಳುಹಿಸಿರಬಹುದಾಗಿ ಅನುಮಾನವಿರುತ್ತದೆ.
In what circumstances can you issue LOC?
LOC.
In what circumstances can you issue LOC?
Lord, that file is not there. I will take instruction, make submission, my lord, beg your pardon.
We'll have it on Monday or Tuesday.
In the meantime, Lord, I may be permitted to travel.
Where are you going in 3 days?
Sri Lanka hogi. There is some business there.
When are you going?
Nalid ಹೋಗ್ಬೇಕು, Lord. I have to book the tickets pursuant to permission.
Let him get instruction as to why, because LOC cannot.
After this, I have subjected myself to court jurisdiction.
We'll have it on Tuesday. You booked the ticket for the purpose of this petition, so it's fine. And AG accepts notice for respondent.
ಯಾವಾಗ? December ನಲ್ಲಿ there is a cricket.
Tuesday
1 to 5. Shri Shanti Bhushan is directed to accept notice. DSGI is directed to accept notice for respondent number 6 to 8. KSHRC,
K. Rajshekar.
K. Rajshekar is directed to accept notice for respondent number 9. Learned AGA is called upon to make a submission as to in what circumstances can a lookout circular be issued, and could it be issued only on the basis of a private dispute between two parties?
Yes.
As regards certain private disputes between them.
Yes. But can I be permitted to go and come, because I'm organizing a cricket tournament there. That is another additional.
You're organizing
a lawyers cricket tournament in Sri Lanka. This petitioner.
He's a lawyer.
He's a lawyer, Lord. And Sri Lanka organize ಮಾಡಿ ಮುಗಿಸ್ಕೊಂಡು ಬರ because month end ನಲ್ಲಿ tournament ಇದೆ. International tournament of lawyers. ಹೋಗಿ ಬಂದ್ಬಿಡ್ತೀನಿ.
Not a threat.
Yes.
LOC is for people who will fly away.
Fly away.
The operation of.
ಅದು they have not furnished the
Considering that the complaint which has been filed is as regards probably a relationship which has gone sour.
Yes.
Between the petitioner and the complainant. And the considered opinion that there is no danger of the petitioner being a flight risk, requiring a lookout circular, imposing a travel ban on the petitioner. As such, the order dated, the lookout circular dated.
ಅದು lookout circular they have not given, they have not furnished to us.
I will take instruct.
Were police officers in the other matter where we are dealing with it. Definitely there is something wrong. Lookout circular issued against the petitioner is stayed till the next date of hearing.
Please. Obliged.
They are involving themselves in all private dispute, and this is one new novel way which has come about.
Yes.
Issue lookout circular so that they can't go. They'll come and sit and negotiate.
Negotiate.
ಮೊದಲು ಇವರಿಗೆ ಇತ್ತು ಸ್ವಾಮಿ ಪವರ್.
ಅವ್ರು ದೊಡ್ಡವ್ರು ಹೋದಾಗ ಏನೂ ಮಾಡ್ಲಿಲ್ಲ.
ಈ ಕೇಸಲ್ಲಿ ಇವ್ರು ಶ್ರೀಲಂಕಾಗೆ ಹೋಗ್ತಾರೆ ಅಂತ ಅವ್ರನ್ನ ಕಾಪಾಡಕ್ ಮಾಡಿರೋದು.
Please. Obliged.
35. Vaisha Rupi.
Yes, Mr. Upin.
For petition.
I'm respondent number 4, my lord. ಇದ್ರಲ್ಲಿ ನಾನು KVT ಫೈಲ್ ಮಾಡಿದ್ದೆ ಸ್ವಾಮಿ.
KVT ಫೈಲ್ ಮಾಡಿದೆ.
ಹೌದು ಸ್ವಾಮಿ. ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಮಿಸ್ಕನ್ಸೆಪ್ಷನ್.
KVT put up ಆಗಿಲ್ಲ.
ಇಲ್ಲ ಅದೇ ನಾ 11:30ಗೆ ಫೈಲ್ ಮಾಡಿದ್ದೆ ಸ್ವಾಮಿ.
ನಮಗೆ ಯಾವ್ದು ಕಾಪಿನೂ ಬಂದಿಲ್ಲ.
ಅಲ್ಲ ನಿನ್ನೆ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ 11:30ಗೆ. ನಿನ್ನೆ ನಾನು ಕಳಿಸಿದ್ದೀನಿ ಬೈ ಪೋಸ್ಟ್. ಬಟ್ ನಿನ್ನೆ ಅವರು 1:30ಗೆ ದೇ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ದಿಸ್ ರಿಟ್ ಪಿಟಿಷನ್ ಮೈ ಲಾರ್ಡ್. ಇನ್ನೊಂದು ಇದರ ಸ್ಮಾಲ್ ಹಿಚ್ ಒಂದಿದೆ ಸ್ವಾಮಿ. ಏನಿದೆ ಅಂತಂದ್ರೆ ಆಕ್ಚುಲಿ 136 ಕೆಳಗಡೆ ಆರ್ಯ ನಂಬರ್ 162 ಆಫ್ 2024 ಅಲ್ಲಿ ನಮ್ಗೊಂದು ಅಂದ್ರೆ ಆಸ್ ಪರ್ ದಿ ಸಿವಿಲ್ ಮ್ಯಾಟರ್ ಇರೋದ್ರಿಂದ FDP ಪ್ರೊಸೀಡಿಂಗ್ ಪ್ರಕಾರ ನಮ್ಗೆ MR ಮೇಲೆ ನಮ್ಗೆ ಖಾತೆ ಮಾಡಿ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ನಾನು ಕೇಸ್ ಹೇಳ್ತೀನಿ ಫಸ್ಟ್.
ಆಯ್ತು
ಅವಕಾಶ ಮಾಡಿ. The land bearing survey number 96/2 Lord was originally belonged to Lord my adopted father Kotrappa Lord. In the year 67 Lord, out of this 5 acres 18 guntas, 1 acre was Lord gifted to one Puttamma Lord. I am having a copy of the gifted Lord. I am filing a memo. 1 acre was gifted to Puttamma Lord. Remaining 4 acre 16 guntas he continues to be the owner. After the death of my adopted father, Lord, I succeeded to the remaining 4 acre 16 guntas. Insofar as 1 acre is concerned, Lord, which was gifted to Puttamma, after her death, Lord, including fourth respondent, Lord, her husband and remaining children succeeded to the property. In the year 1982, Lord, by a registered sale deed, they sold this 1 acre in my favor, Lord. Since Lord, fourth respondent not joined that sale proceedings, Lord, she claims that Lord, that sale deed is not binding on her. Then Lord, I filed a suit for partition of my 4/5 share, Lord, in that 1 acre.
Yes.
Suit was decreed. Then appeal was filed. Appeal was also dismissed. Thereafter, Lord, FDP was filed. In FDP, Lord, my 32 guntas out of this 1 acre, Lord, which being the 4/5 share, Lord, was carved out and given to me, Lord. That I have produced at Annexure C, Lord, your last.
What is the total extent?
Total acres is 5 acres 16 guntas plus 2 gunta karab, Lord.
So you will get 4/5.
ಅಲ್ಲ 1 acre ಅಲ್ಲಿ 4/5 ಅಂದ್ರೆ 32 guntas.
1 acre was sold to you.
ಹೌದು.
So 4 acres 16 guntas will remain.
ಹೌದು.
You get 1 acre, out of which you get 32 guntas. From because of the 4/5 share.
Yes, my lord. Thereafter, my lord, after this FDP, my lord, she files a suit, my lord. I have produced a copy, my lord, for injunction
claiming that not she is in possession and you will get it not in page 64. Even before that, not, she files another suit, not, that is annexure A, my lord.
This is a permanent injunction suit.
Please, my lord.
This is only a suit for permanent injunction.
Before that, my lord, she files another suit, annexure A, you last kindly see. She files a suit OS 93 of 2005 for a declaration that, my lord, sale deed executed by her father and remaining brothers and sisters not binding on her. That suit was dismissed. Then annexure, appeal was filed, annexure B. Appeal was also dismissed.
Yes.
Thereafter, my lord, in FDP proceedings, under filed by me, my lord, so far as that 1 acre is concerned, my lord, the FDP was final decree was passed in my favor, granting, my lord, 32 guntas. Your lordship, my lord, annexure C, your lordship, for a moment.
Yes.
Your lordship, page number 51, your lordship, page number 51.
He was entitled to 4/5.
ಸೊರಬ ತಾಲೂಕು ಜಡೆ ಹೋಬಳಿ ಶಕನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 96/2ರಲ್ಲಿ ತರಿ ವಿಸ್ತೀರ್ಣ 5 ಎಕರೆ 18 ಗುಂಟೆ ಕಂದಾಯ 32.85 ಇದರ ಪೈಕಿ 32 ಗುಂಟೆ ನಿಯೋಗಿಯವರು ಅಂದ್ರೆ ಕಮಿಷನರ್ ಸಲ್ಲಿಸಿದ ನಕ್ಷೆಯಲ್ಲಿ ತೋರಿಸಿದ ಬ್ಲಾಕ್ ನಂಬರ್ 2 ಅರ್ಜಿದಾರರಿಗೆ ಸೇರಿರುತ್ತದೆ. This is the order passed, my lord. But, my lord, in the sketch, my lord, there is a mistake, my lord. Your lord, page 53, your lordship, I can see.
Yes.
In the sketch, my lord, they have, my lord, block number 1 correctly shown, my lord, 9 guntas. That is fourth respondent, her brothers and sisters and father, 9 guntas is shown, my lord. Second block is, my lord, shown in my favor, 32 guntas. Third block, my lord, was uncalled for because suit is not in respect of the entire property, my lord. It was only in respect of 1 acre, my lord. Your lordship get it scheduled, my lord, in page 52, your lordship.
Yes, we've seen that. But 4 acres, 17 guntas is the remaining.
Remaining, that belongs to me, my lord.
No, no, no.
That was here. One second.
Yes.
That was erroneously, my lord, entered in
How
this
does it
sketch.
belong to you? Where is the document for that?
Lord, that your lordship one registered sale deed not produce my memo along with memo.
You have filed it now.
Yes, yes. Your lordship kindly see that
Where the typed copy? Yes.
while executing, my lord, registered sale deed, my lord, in respect of 1 acre, how they have described him, my lord. ಮೇಲ್ಕಂಡ ಕೃಷ್ಣಪ್ಪನಿಗೆ 2ನೇ ಪ್ಯಾರ ಇಂಕ್ ಪೇಜ್ ನಾಟ್
ಇದು 4 ದಾನಪತ್ರ.
ಅದು ದಾನಪತ್ರ ಮೊದಲನೇದು 1 acre ಕೊಟ್ಟಿದ್ದು. ಅದು ನೆಕ್ಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಟೈಪ್ಡ್ ಕಾಪಿ ಹಾಕಿದ್ದೀನಿ, ಅದ್ರ ನಂತರ
ನೆಕ್ಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್.
ಅದು ಟೈಪ್ಡ್ ಕಾಪಿ ಇದೆ.
ಕ್ರಾಯಪತ್ರ.
ಅದರಲ್ಲಿ ಮೇಲ್ಕಂಡ ಸೆಕೆಂಡ್ ಪ್ಯಾರ ಮೇಲ್ಕಂಡ ಕೃಷ್ಣಪ್ಪನಿಗೆ ಅದು ಪಾರ್ವತಿ ಅಲ್ಲ ಪಾರ್ವತಿ, ಅದು ಪಾರ್ವತಿ, ನಾಗೇಶ ಮತ್ತು ಸುರೇಶ ಎಂಬ 3 ಜನ ಮಕ್ಕಳಲ್ಲದೆ ಸರಸ್ವತಿ ಎಂಬ ಮಗಳು ಸಹ ಇದ್ದು ಇವಳು ಚಿಕ್ಕಂದಿನಲ್ಲಿಯೇ ನಮ್ಮಗಳನ್ನು ಬಿಟ್ಟು ಹೊರಟು ಹೋಗಿರ್ತಾಳೆ. ಈ ಕೆಳಗೆ ಕಂಡ ತಪಶೀಲುಗಳ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತುಗಳು ಕೃಷ್ಣಪ್ಪನ ಹೆಂಡತಿ ಹಾಗೂ ಪಾರ್ವತಿ, ನಾಗೇಶ್ ಮತ್ತು ಸುರೇಶ್ ಇವರ ತಾಯಿ ದಿವಂಗತ ಪುಟ್ಟಮ್ಮನಿಗೆ ಸೊರಬ ತಾಲೂಕು ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಆಫೀಸ್ ಮೇರೆಗೆ ಚಕ್ಕನಹಳ್ಳಿ ವಾಸಿ ಮುಂಚಿನ ಮನಿ ಕೊಟ್ರಪ್ಪ ಬಿ ಶಿವಪ್ಪ ಎಂಬುವರಿಂದ ದಾನಪತ್ರದ ಮೂಲಕ ಬಂದಿದ್ದು ಸದರಿ ಪುಟ್ಟವನ ಮರಣಾನಂತರ ನಮ್ಮಗಳಿಗೆ ಸೇರಿದ್ದು ಆಗಿರುತ್ತದೆ. ಕೊಟ್ರಪ್ಪನ ದತ್ತು ಮಗನಾದ, ದಟ್ ಈಸ್ ನಾಟ್ ಪೆಟಿಷನರ್ ಬಿಫೋರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್, ದತ್ತು ಮಗನಾದ ನೀವು ಸದರಿ ಸ್ವತ್ತುಗಳನ್ನು ಲಾಗಾಯತಿನಿಂದಲೂ ಸ್ವಾಧೀನ ಅನುಭವದಲ್ಲಿ ಇದ್ದುಕೊಂಡು ಅನುಭವಿಸಿಕೊಂಡು ಬಂದಿದ್ದು ನೀವು ಬೇರೆಯವರು ಆಗದೆ ದಿವಂಗತ ಕೊಟ್ರಪ್ಪನ ದತ್ತು ಮಗನಾಗಿದ್ದು ನಮಗೆ ಬೇಕಾದವರಾಗಿದ್ದು ಸದರಿ ಸ್ವತ್ತುಗಳು ನಾವು ವಾಸವಾಗಿರುವ ಸ್ಥಳಕ್ಕೆ ದೂರ ಫಾಸ್ಲೆ ಎಲ್ಲಿದ್ದು ನಮ್ಮಿಂದ ಸ್ವಂತ ಸಾಗುವಳಿ ಮಾಡಿಸಲು ಸಾಧ್ಯವಿಲ್ಲದಿದ್ದಲು ಮತ್ತು ನಮ್ಮಿಂದ ನೋಡಿಕೊಳ್ಳಲು ಸಾಧ್ಯವಿಲ್ಲದಿದ್ದಲು ಸದರಿ ಸ್ವತ್ತುಗಳನ್ನು ಮಾರಾಟ ಮಾಡಬೇಕೆಂದು ನಿರ್ಧರಿಸಿ ಕ್ರಯಕ್ಕೆ ಹಚ್ಚಿ ವಿಚಾರಿಸಿದ್ದರಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರ ಬೌಂಡ್ರಿ ಸೊರಬ ತಾಲೂಕು ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಆಫೀಸ್ ಚೆಕ್ಕುಬಂದಿಗೆ ಸೇರಿದ ಜಡೆ ಹೋಬಳಿ ಶಕನಹಳ್ಳಿ ಗ್ರಾಮದ ರೀಸರ್ವೆ ನಂಬರು 96ನೇ 2 ತರಿ ವಿಸ್ತೀರ್ಣ 5 ಎಕರೆ 18 ಗುಂಟೆ ಪೈಸಹ. ಇದರಲ್ಲಿ ನಮ್ಮ ಭಾಗದ ಉತ್ತರ ದಿಕ್ಕಿನ 1 ಎಕರೆ ಜಮೀನು ಮಾತ್ರ ಇದರ ಆಕಾರ 6 ರೂಪಾಯಿಗಳು. ಇದಕ್ಕೆ ಚೆಕ್ಕು ಬಂದಿ ಪೂರ್ವಕ್ಕೆ ಹುಳಿ ಚೆನ್ನಮ್ಮನ ಗದ್ದೆ, ಪಶ್ಚಿಮಕ್ಕೆ ಅಜ್ಜಪ್ಪನ ಗದ್ದೆ, ಉತ್ತರಕ್ಕೆ ಕೆರೆ ಕಾಲುವೆ, ದಕ್ಷಿಣಕ್ಕೆ ಇದೇ ನಂಬರ್ ಪೈಕಿ ಅಂದ್ರೆ 4 ಎಕರೆ ನಿಮ್ಮ ಬಾಬ್ತು ಜಮೀನು. That is petitioner, my lord. Now, my lord, your last may kindly see, my lord, after this FDP proceedings, she files a suit, my lord, 2 suits. One suit, my lord, for declaration that sale deed is null and void. That is in respect of only 1 acre.
ನಿಮ್ಮ ಬಾಬ್ತು ಜಮೀನಿಗೆ ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಏನಿದೆ?
ಅಲ್ಲ, ನಮ್ಮ ಬಾಬ್ತು ಜಮೀನು ಅಂದ್ರೆ ಇನ್ನು ಇದೇ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ಇನ್ನು ಉಳಿದಿದ್ದು ನಂದು ಅಂತ.
ಯಾವ ಬೇಸಿಸ್ ಮೇಲೆ?
You
are the adopted son.
Yes, Lord.
There is no partition.
I am the adopted son of Kotrappa. Kotrappa sold out of this 4 acres, 16 guntas, 1 acre to Puttamma. Remaining 4 acres, 16 guntas, he was enjoying. After his death, Lord, I being the adopted son, Lord, I succeeded to that 4 acres.
Got the 32 guntas.
Yes, Lord. Then ಡಿಕ್ರಿನೂ ಹಾಕಿದೀನಿ ನಾನು, OSL ಪಾಸ್ ಆಗಿತ್ತು. 1 acre ಅಷ್ಟೇ ಡಿಕ್ರಿ ಆಗಿತ್ತು ಅಂತ ಲಾಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್.
Now what is annexure
L, my lord, M.
M is, my lord, now Tahsildar, now, my lord, there are conflicting orders by Assistant Commissioner, Deputy Commissioner, my lord. Now once again an adverse order is passed by Assistant Commissioner. I have taken steps. The order was passed.
Annexure, what is annexure?
Only communication.
Impugned order, not impugned letter is annexure M. It says that, my lord, police directed to give police protection to harvest the existing crop to the 4th respondent, my lord.
ಮಾನ್ಯ ವಿಭಾಗರವರ ಆದೇಶ ಪತ್ರ ಸಂಖ್ಯೆ RA 162. What is that RA 162?
That I have produced copy, my lord, previous document.
That has been
That order was, my lord, annexure L. It was passed on 20th November, but signed on 29th November. On the next day itself, this direction is issued. I have no time to file appeal.
What is annexure L, Mr.
Yes, my lord. My lord, after, my lord, the final decree passed, my lord, I filed an application before the Tahsildar, my lord, for I filed an appeal before the Assistant Commissioner in respect of entries made in record of rights. That is ink page 75, annexure F.
So your request for entry of your names has been rejected?
Yes, that I will take 1 second. Annexure F, ink page 75. Appeal was filed. In appeal, my lord, ink page 77, you last may kindly see, my lord. My appeal was allowed initially.
Yes.
Ink page 77. What is the observation made, my lord? For reasons given, my lord.
27 is an order passed by the Assistant Commissioner on
Yes,
5/7/2021.
Yes, my lord. Adralli internal page 3, lord.
Yes.
ಕೆಳಗಡೆ ಲಾಸ್ಟ್ ಪ್ಯಾರ. ಕಡತದಲ್ಲಿನ ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಚಕೂನವಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 96/2ರಲ್ಲಿ 2 ಎಕರೆ ಖರಾಬು ಹೊರತುಪಡಿಸಿ 5 ಎಕರೆ 16 ಜಮೀನಿದ್ದು, ಈ ಜಮೀನು ಮೂಲತಃ ಕೊಟ್ರಪ್ಪ ಬಿನ್ ಶಿವಪ್ಪರವರಿಗೆ ಸೇರಿದ ಸ್ವತ್ತಾಗಿರುತ್ತದೆ. ಕೊಟ್ರಪ್ಪ ಬಿನ್ ಶಿವಪ್ಪರವರು ಸದರಿ ಜಮೀನಿನ ಪೈಕಿ 1 ಎಕರೆ ಜಮೀನನ್ನು ಪುಟ್ಟಮ್ಮ ಕೋಂ ಕೃಷ್ಣಪ್ಪರವರಿಗೆ ದಾನಪತ್ರದ ಮೂಲಕ ಬಿಟ್ಟುಕೊಟ್ಟಿದ್ದು, ಅದರಂತೆ MR ರಂತೆ ಪುಟ್ಟವ್ವ ಕೋಂ ಕೃಷ್ಣಪ್ಪರವರ ಹೆಸರಿಗೆ 1 ಎಕರೆ ಜಮೀನು ಬಂದಿರುತ್ತದೆ. ಇನ್ನುಳಿದ 4 ಎಕರೆ 16 ಗುಂಟೆ ಜಮೀನು ಕೊಟ್ಟಪ್ಪ ಇವರ ಪುತ್ರಿ ಪೌತಿ ಸಬೂಬು ದತ್ತುಪುತ್ರ ಶೇಖರಪ್ಪ ಬಿನ್ ಕೊಟ್ರಪ್ಪರವರಿಗೆ IHRC ರಂತೆ ಖಾತೆ ಬದಲಾವಣೆ ಆಗಿರುತ್ತದೆ. ತದನಂತರ ಮೂಲ ಖಾತೆದಾರರಾದ ಕೊಟ್ರಪ್ಪ ಬಿನ್ ಶಿವಪ್ಪರವರಿಂದ 1 ಎಕರೆ ಜಮೀನನ್ನು ದಾನ ಪಡೆದಿರುವ ಪುಟ್ಟಮ್ಮ ಬಿನ್ ಕೃಷ್ಣಪ್ಪ ಇವರ ಮೃತರಾಗಿದ್ದ ಮೃತರ ಪೌತಿ ಸಬೂಬು ರವರಿಗೆ ಸೇರಿದ 1 ಎಕರೆ ಜಮೀನನ್ನು ವಾರಸುದಾರರಾದ ಸರ್ವಸುತ್ತಮ್ಮ ಬಿನ್ ಕೃಷ್ಣಪ್ಪ ಹಾಗೂ ಮತ್ತಿತರರಿಗೆ ರಂತೆ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡುವ ಸಂದರ್ಭದಲ್ಲಿ.
Mr. Upin, you have produced a lot of documents. You can read every document. If that is the thing that you want to do, you can come back at 6 o'clock. We'll hear you. We asked you what is annexure L. On the basis of which annexure M has been passed. You go to annexure F. which is 2021. What is Annexure L?
Annexure
may I
L,
make
my
one
lord, is
submission?
an order passed by Assistant Commissioner in respect of change of entries. Appeal was filed. Under the appeal, this order was passed, my lord.
So you are the person who filed the appeal.
Yes, my lord.
You have not succeeded in the appeal.
In appeal,
Your
my lord,
appeal
I-
has been
Revision.
dismissed.
Yes, ma'am.
In appeal, my lord, I succeeded. In page 78, you lost it.
78 allappa, Annexure L nodi.
Annexure L alle last operative portion.
Operative portion banni.
Operative portion.
Because Annexure M is issued in pursuance of Annexure L. We are not deciding your title here.
Please, my lord.
There is a writ petition. We are not deciding your
My
title.
lord.
Annexure M has been passed in pursuance of Annexure L. Annexure L is what you had filed an appeal, your appeal came to be rejected.
That appeal.
Sorry, my lord. Annexure F, my lord, in page 77.
We are not concerned with Annexure F, please come to Annexure L.
But
Because
before,
Annexure L is the basis for Annexure M.
my lord, annexure F, my lord, initially, my lord, my appeal was allowed.
Your history, if we go for last 100 years, we can go.
My lord, I will-
We are only concerned with the current orders which have been passed.
yes, my lord.
The current order which has been passed is Annexure L. In furtherance of which Annexure M has been passed.
Right.
So long as Annexure L stands,
Yes.
Annexure M is valid. Until Annexure L is set aside, you can't claim any right on that. Right or wrong, that is the order which is there.
My submission to your lordship is no, my lord, against annexure L, my lord, I have a right of appeal.
File an appeal.
Yes, my lord. Now, this annexure L was passed, my lord, your lordship kindly see the date for the moment. This was dated 21/12/20.
Yes, file an appeal and ask for a stay of Annexure M there in the appeal.
Now, 1 second.
Why are you before us?
1 second. 21/12, my lord, this is dated.
Hmm.
You asked my kindly see, my lord, last portion. Annexure L, last portion, when we have signed, my lord, in page 102.
2911.
28, 29/11 sign ಮಾಡಿದ್ದಾರೆ.
Yes.
Next day ನೀವು ತಹಶೀಲ್ದಾರ್ ಹತ್ರ ಹೋಗ್ತಾರೆ.
ಹೌದು.
ತಹಶೀಲ್ದಾರು
Order ಆಗಿದ್ರೆ it's entitlement of any litigant to go.
I have no breathing time not to file appeal.
You have all the breathing time to approach this court and not file an appeal.
Tashildar not, because Tashildar has power not to issue.
There's an order which has been passed by the Assistant Commissioner. He is implementing that order.
But this direction issue is contrary to civil court's judgment. Where
No, no, no,
he
my
filed
lord.
suit.
No, my lord.
Can we decide that in this petition when Annexure M is challenged?
But I will file appeal.
You have to file an appeal and in that appeal you ask for a stay of Annexure M.
But in the meantime, but you lordship may protect my interest, Lord, for at least 1 week. In the meantime, we will file appeal.
We will protect you for 2 days.
But yes, my lord, I will.
Don't harvest the crop.
My lord.
Don't harvest the crop. for
Yes, my
2
lord.
days.
Yes, my lord. Yes, my lord. My lord, what is the happen in that area? Actually, they are, andre correct agiro fact na they are not produced before this honorable court. My lord.
Correct fact now decide madakagala.
Yes, but that is the reason, my lord.
We are only concerned with the order which has been passed.
Yes, my lord. Yes, my lord.
Now the order is dated 21/12, signed on 29/11,
Yes,
signed
my
on
lord. Yes.
29/11.
Yes,
That is the only reason why
Yes,
we are
ma'am.
protecting.
Yes,
Because
ma'am.
8
Yes.
days it has been
Yes, my lord.
pending for what reason, we don't know.
Okay. Yes. Before,
And AG accepts notice.
before concern authority to DC only, my lord.
To respond number
136 plus
3, Sri so-and-so who has filed caveat accepts notice for respond number 4. Considering that Annexure M ordered on 1/12/2025 has been passed in pursuance of the order at Annexure L, which though dated 21/11/2025 has been digitally signed by the Assistant Commissioner, by the Tahsildar on 29/11/2025 at 17:56 hours. The said order can at the most have been said to have come into operation on 29/11/2025, irrespective of the date of the order. Immediately after the said order, the Tahsildar who had passed that order is directed the jurisdictional police to offer police protection on 1/12/2025 without even waiting for the appeal period to get over. In that view of thus rendering the petitioner without any remedy. In that view of the matter, the operation of Annexure M is stayed for a period of 3 days from now, since the 3 days is stayed till 9th December 2025, so as to enable the petitioner to file necessary appeal challenging the order at Annexure L. Respondent number 4 is restrained from harvesting any of the crop from the subject property till 9th December 2025. Counsel for the petitioner is at liberty to seek for such interim reliefs as may be available to the petitioner in the appeal so filed, which shall be decided by the appellate authority without being influenced by the orders passed in the present matter.
File ಮಾಡಿಲ್ಲ. Lord, may make one submission, my lord, what the reference is made in the judgment. My lord, it is announced in open court 2011-2025, my lord.
Unless they get a copy, how are they going to file an appeal?
May make one submission.
ನೀವು
20
certified copy ne uploaded copy ne ತಗೊಳಲ್ಲ ನೀವು.
ಇದು uploaded copy, he will have a right to apply for copy application, lord, that is certified copy will be given
Signed
to
on
him.
29/11.
Illa, digitally signed, it is on 29/11, my lord.
Obviously, it is signed on that day.
It is a digital sign, my lord.
Where is the physical sign? Will you produce the physical signature? We'll give you time till afternoon or tomorrow. If you produce it, we'll consider it. What is this in that? If it is there, we'll consider your submission. The appellate authority is direct to consider the application for stay at the earliest.
My lord, one submission, my lord. My lord, one.
Until, ಅದಕ್ಕೆ we are thinking, until the chain ಮಾಡಿ. Time is granted to the petitioner to file an appeal until 9th December 2025. If the appeal and the stay application were to be filed by 9th December 2025, the appellate authority is directed to consider the stay application, pass necessary orders on the same as expeditiously as possible. Till the disposal of the stay application, the operation of Annexure M is stayed. So also respondent number 4 is restrained from harvesting the crop till that date.
My lord, small submission. ಇದರಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ
The appellate authority shall consider the appeal and the application for stay without being influenced by the orders of this court.
my lord, even my opportunity has been also.
You
Yes.
can
Yes. They have served the copy to us.
ಇಲ್ಲಿ ಹೆಂಗೆ ಕೇವೇಟ್ ಅವ್ರು ಫೈಲ್ ಮಾಡಿದ್ಮೇಲೆ ಬಂದ್ರು ಅಲ್ಲೂ ಹಂಗೆ ಹೋಗಿ. You are pretty adept at it.
Yes.
We are not commenting. You are very resourceful. How much we can say.
Yes.
Government advocate will be directed to inform.
AGA is directed to inform the jurisdiction police authorities about the above order. Madhyana inform it. Otherwise, they'll go and
But Lord, may I
they
make
seem
one
to be
submission?
very resourceful.
Lord, I fairly
No, no,
submit before this court, my lord. Till 7:30, we will be here in this court. We have to give a dictation and we have to send it to my lord. I will communicate after 7 only, my lord. That is
I will inform, my lord.
problem, my lord.
Give us the Tahsildar's number, we will inform.
Sorry, I beg your pardon, my lord.
We will
Only
inform.
I will inform, lord.
We will inform.
Lord, telephonically, I will inform, my lord.
Telephonically, saku.
Right.
There are, not every day we tell you to inform.
I agree, my lord. I am not saying that, my lord.
When we
Lord, I
direct
am
you to
not.
inform, we expect it to be informed.
ಮತ್ತೆ ಅವ್ರು ಇನ್ಫಾರ್ಮ್
There is
ಮಾಡಿಲ್ಲ
no
ಅಂತ
other
ಹೇಳ್ಬಿಡ್ತಾರೆ ಅಂತ ನಾನು ಹೇಳೋದು. ಇಲ್ಲಿ ನಾವು ಬಿಜಿ ಇರ್ತೀವಿ, ನಾವು ಬೇರೆ ಕೇಸಲ್ಲಿ ಅವ್ರು ಅದು ಬಂದು ಸಬ್ಮಿಷನ್
CCMS ಇದೆ. One line you have to send. That's all. Everything is on record.
Yeah.
The date and timestamp of your sending will be on record. The date and timestamp of them receiving will be on record.
Obliged.
We understand why you are saying this.
I agree, my lord.
29th order, one, this has happened, the police will take action immediately, is your apprehension also irrespective of what you say. We'll deal with them if they do that.
Operative portion.
Operative portion and delivery.
ನಿನ್ನೆ ಪೊಲೀಸ್ನವ್ರು ಬಂದಿದ್ದಾರೆ.
ಅದಕ್ಕೆ ಅವರುನು
ಅಲ್ಲ, ನಿನ್ನೆ
ಸಿದ್ಧಾರ್ಥ
ಏನಾದ್ರು ಆಗ್ಬಿಟ್ರೆ ಅದು ನಮಗ್
ಮೆನ್ಷನ್
problem.
ಮಾಡಲ್ಲ. ಈ ಮೆನ್ಷನ್ ದಟ್ ಫಾರ್ ಎ ಪರ್ಟಿಕ್ಯುಲರ್ ರೀಸನ್. That even after informing, they may not go by what he says. And if they don't do it, we'll deal with them. Don't worry.
Serial number 36. Hemant Kumar.
My lordship, in this matter, I appear for R1, my lordship. The National Horticulture Board has already appointed a new council in this matter. So kindly, my name may be removed from the cause list, my lord.
Where is your name, Prajwal?
I appear in behalf of Nayantara BG, my lordship.
So you are not appearing. Now who is appearing?
I am for the respondent number 1, your lordship.
Raghavendra B.
Raghavendra B, your lordship.
See, Raghavendra B has entered appearance for respondent number 1. Registry is direct, delete the name of Ms. Nayantara BG as that appearing for respondent number 1. Notice not yet ordered. You appeared without notice.
No, your lordship, what happened? The copies have been not served properly, your lordship. Only the petition copy has been served. Not the annexures has not been attached to this. Lordship, I have only the petition copy, not the annexures.
That counsel for the petitioner, the Sri Canara Bank Yarama?
TP Muttanna.
Karnataka Bank kotra kashta agate. Canara Bank is the party. TP Muttanna is directed to accept notice for respondent number 2. Indian Horticulture and Food Processing Concern is, what is it? It's a proprietary concern. Relief is against respondent number 1. Notice to respondent number 3 is deferred for now. Learned counsel for the petitioner is directed to, there is no interim order, we can't grant you, I think. Issue notice to respondent number 3, returnable by January. Counsel for the petitioner to serve 2 sets of the petition along with annexures on the aforesaid counsel, who are granted 4 weeks time to obtain instruction, make their submission.
29 January. Serial number 37. Nandan Sundararajan, party in person.
Notice delivered.
Yes, served.
Date ಕೊಟ್ಟಿದ್ದೀರಾ ಇವತ್ತು ಅಂತ?
2 days.
On the earlier occasion, the party in person was not present. Hence, a court notice was issued to the party in person indicating that the matter would be taken up today. Today also, the petitioner party in person is not present before this court. It appears that the petitioner party in person is not interested in prosecuting the matter. Dismissed for non-prosecution.
38. Paniraj Kashyap.
Yes.
The petitioner has been taken, so we have to bring the loss of that.
Petitioner has expired. Sole petitioner. Huh? Learned counsel for the petitioner submit that the sole petitioner has expired. He seeks for and is granted 3 weeks time to file necessary application to bring the legal representative of deceased petitioner on record.
29 January. Serial number 39.
Pay for respondent number 5, please.
Situation where society registered
ಮೈಕ್ ಆನ್ ಮಾಡ್ಕೊಳಕ್ಕೆ
You just say yesterday's matter, what will you know? Yesterday not argued. What is this matter?
the matter wherein I'm challenging certificate of registration granted under the 1960 Society Registration Act.
Switch on the.
In respect of the respondent which is collecting maintenance charges. He said
As a layout.
This is a layout. This is not an apartment complex.
Yes.
The certificate, the impugned annexure.
Apartment Ownership Act.
Impugned annexure, your lordship finds at page 26.
This is a gated community.
This is a gated community.
So you have common interest in all the common areas.
Yes. I mean, so far as undivided share may be concerned,
There is no undivided.
that may not be, I may not have a UDS insofar as the larger property is concerned. But insofar as the upkeep of the common areas and amenities is concerned,
it's common.
It is common, and that the contesting respondent is taking care of, which is registered under the 1960 Act.
Yes. You are ready to subject yourself to the KOA?
Yes. In fact, just as a matter of
KOA
transparency, I want to bring it to your lordship's notice that a cooperative society has been registered at the behest of the petitioners. However, notwithstanding that, whatever order falls from your lordship, we are ready to abide by that. And that I'll just produce the.
Cooperative societies would only happen if there is a commercial property.
Exactly, my lords.
That is
Even
what
the
the division bench-
KAOA will not
I
apply.
understand. In
Even
fact-
the Karnataka Apartment Ownership Act will not apply to us, my lords. That is only so far as apartments are concerned. It is not
Now you
for.
have a situation which will, if you take that stand, you'll be in trouble.
My lords,
Because the division bench has said Society Registration Act will not apply for maintenance activity, which cannot be a,
In that, if
cannot
I
be
may,
a object.
if my lords may kindly permit me to make some submission on that, my lords. If my lord, insofar as the Apartment Ownership Act is concerned, it provides for a declaration to be registered under the Act insofar as an apartment is concerned. An apartment is defined by the Act as a independent residential tenement in a building. And a building is defined to mean a building with 4 or more residential apartments.
Yes.
So therefore, a layout of sites which was sold as vacant sites and subsequently people having purchased it have built their independent homes, in my humble submission, may not fall within the provisions of this act, because the provisions of this act will not apply to a layout of this nature, my lords. Now, what has happened is my lords, if my lords may kindly see the prayers that they have sought for. Insofar as, kindly see the prayers, my lords.
Your demand.
First is they're asking for a
Quashing of
certiorari
demand
to
notice.
quash a demand notice for payment of these maintenance charges that I have been collecting. This society and this association has been collecting since 1998. My humble submission is that the respondent number 5 is a private body, private organization, and the extraordinary jurisdiction of this honorable court under Article 226 may not significantly and directly be applicable insofar as R5 is concerned.
I will not press on this prayer.
The second thing, my lords, is that this is a association that has been registered as a plot owners welfare association in the year 1998. My lord. This petition is filed in the year 2025. My humble submission is that there is a huge delay and latches. Why I am submitting this, my
You will
lords?
not make the illegal thing.
I will. Why I am submitting this, my lords, is this: first, all these petitioners are only expressing a personal grouse. The first petitioner has been the secretary of this association for 15 years. And only because of his election issues, these issues have been raised.
He understand apartment or this is a thankless job.
No.
People who have some free time do all these things. That's all fine. But the fact, all said and done, the fact still remains that the division bench has said a society cannot.
May I then please try to-
Registered and KSR Act cannot do maintenance.
May I please persuade my lords to kindly see section 3 of the the Societies Registration Act.
We cannot differ from the division bench now.
No, my lord, the circumstances under
Will be
which
only bound by that. You can file an appeal.
the circumstances under which
You can't re-agitate that matter.
But what this the learned division bench of this honorable court was considering is was in reference to an apartment ownership act. Their only activity was collection of maintenance. Here, my objectives involve other things which are also covered under section 3. And my humble submission would be that section 3 is not exclusive but inclusive. And therefore, it is
You
not.
cannot have one of the objects as maintenance. You continue your other objects. There's no problem. But the maintenance cannot be one of the
But then, my
objects,
lords,
is what the division bench has said.
today, there is no enactment under which such an organization can exist at all, my
You
lords.
can go under
So-
cooperative societies.
Yeah, cooperative, then my humble submission would be that the cooperative society, the
entire premise of the cooperative society is for common economic benefit of members, essentially for a commercial activity. And one of the main principles of a cooperative society is to earn profit and distribute that profit by way of dividend to its members. Whereas that is not the objective of an organization of this
The relief
nature.
which has been sought for before us is quash the registration of respondent number.
But then, my lord, then what will
We'll
happen?
quash it, then what will you do?
Then, my lords, then I will be left
That is
in a
why we
situation.
are asking, that's why we asked them.
Then, my lords, what will
I
then
just-
happen is like this association, there are hundreds and thousands of associations all over. Now, there are monies that these associations hold in deposits of the they have entered into contracts. They hold properties which are common in nature. This particular association runs a club. It has a license to run a bar. And
RERA says it has to be a cooperative society.
this property is not
Pre-RERA.
pre-RERA. Because this is 1997, 1996, the development was completed.
Please look at it. Please speak to your clients. This order can be passed. But that will leave all of you.
It will leave us in a great conundrum, my lord.
Exactly.
Not only us, but several other such associations.
Exactly. That is why we are asking you to consider it.
No, certainly we will consider, my lord. What falls from this honorable court will certainly.
Because there has to be a solution for all the.
Has to be a solution.
In one other matter, we had 3 people fighting. This court had tried to intervene on 3 occasions. Permitted them to form a cooperative society, they did not.
No,
Permitted them to go under KOA, they did not. That was an apartment, they did not.
My instructions are, my
Now
lord.
only society was there, we had to quash it. Now they have nothing.
My lord, that is going to be a grave prejudice, my lord. There
It
are
will be.
800 people who are members, their monies are
It will be
there.
prejudicial to even the petitioners.
Even for them.
They
Therefore,
also won't get
now,
anything.
my humble submission is that the instructions that I have received is that the managing committee per se today are not averse to shifting over to any other type of organization that is permissible under law, my lords.
You examine it.
We will
We'll give you
examine.
a week's time, you examine it.
Please.
And you continue paying.
Yes, yes.
We are not
In
going
fact,
to
I have produced.
And you continue maintenance.
ಇದರಲ್ಲಿ
That's not
ಇನ್ನೊಂದು
the
ಏನಾಗಿದೆ ಅಂದ್ರೆ ಇವಾಗ what has happened because why I'm pressing this personal grouse issue. Now, without the approval of the general body of this current association or the approval of the current managing committee, the 5, 6 or 7 people who have all these personal grouses have independently gone and started off a cooperative society. That I think
all of.
I'm grateful, madam.
We are not saying you become a member of that or anything. You could become if the bylaws and everything are proper. If they have tailored the bylaws for their requirement, you don't need to. You understand?
We are now, since October, we have been trying to get a copy of that. They not have they given us the copy of those registration documents or the memorandum. Neither is the registrar of cooperative societies. Let them give the
whatever bylaws you registered.
Let them examine.
Let them examine.
But our intention is not to sideline anybody. Our intention is that the layout is maintained well and it is kept, my lord.
Well, the problem is that because the division bench has said that society cannot do it. Society cannot do it. KOA is what we thought, but now the building is a problem. Though vertical and horizontal, but the building should be
Building
there.
should be there. They're all sites with independent homes.
And you have built
with a condition that they will build only one home with not more than ground and first floor. Those are some certain conditions. So there's some sort of a unique sort of a residential layout.
Whether that is
enforceable or not is a different issue. I quite agree.
You don't want to give ideas to people now. So we'll not get into that.
Yes, please.
The issue would be if KSR is not applicable, KOA is not applicable. It appears that KOA is also not applicable. They can look at whether KOA could include plots
Ega
too.
what I'm seeing in the news, and I've also received some, is that the Federation of Homeowners and Apartment Owners are now, there is a bill that has been proposed, which ought to be introduced at some time to modify this KOA to look after all these situations.
We have suggested that in one of our judgments.
And because now we are also facing problem, my lords, insofar as apartment owners who are already societies or even KOA, not society but KOA, but their enforceability and so many other difficulties. So, government supervision is not there. So many other difficulties. Some of them and
we have suggested that, but until it happens, what we have to go by existing law. We can only suggest. we'll have to implement the existing.
My only humble submission is
If the
that
existing law has to be
the
implemented.
activity of the societies that this society is conducting, maybe similar other societies, are not barred by the
Division
provision of
bench
the.
judgment is there
I quite understand.
Division
bench has taken a view.
You can't argue contrary to that.
I
And we can't hear any there.
Unless. I quite agree.
Not that we agree with
No,
you
no,
on
no,
that,
I'm-
but we can't even consider that.
No, I
That
got it.
judgment will apply and that judgment will have to be followed.
May only take a lordship's attention just for a moment.
That were to be so, the only possibility is for you to do it under the Cooperative Societies Act. So speak to each other, see how it is.
See, that consideration.
Examine what their bylaws are, if they are
Let them give us.
available.
We will examine, we see the
Examine.
idea, my
If
lord,
not,
is that
set up a
everybody
new-
will have to call a special general meeting, we'll have to discuss this. And whatever legal steps that are required to be taken, we will take. It is not that we don't want to take it and we are averse to recognizing the current position of law. That is not the.
In the other matter also, we try to persuade those parties, saying that it is very
Like,
easy to pass the order. You will be in difficulty.
That
They were not ready to understand.
In this case, my lords, what I understand is that they are not averse to.
That is good. That is very good. Think about it.
This
Examine-
manner is being, is becoming a little uncomfortable for them.
Don't let ego come in the way.
No,
This is
absolutely
all-
not, absolutely.
You're all neighbors.
Absolutely.
You will be there for,
Be there forever.
your relatives may not be there, but your neighbors will be there next to you.
Correct.
So you can't go away from there.
Sometime about 2 weeks
You have
time.
to
we'll
work it
dis-
out and see how.
Let them give the copies. We will also.
I will hand it
discuss
over
them.
today. Could the lordships have it next week? Because my instructions are, in fact, I'll just submit this memo. Cooperative society is already registered. I
So-
understand what has fallen from your lordships is, I'll have to share a copy of the bylaws. They can examine it. There's no difficulty in that. Obviously, it's a cooperative process. Could the lordships have it anytime next week?
They'll take some time to look into it.
I understand.
You give it to them. You can't rush it.
I understand.
And it has to be done in a proper
Then we have
manner
been
for
in
everybody.
existence for nearly 30 years now, my lord.
The counsel for the petitioner is directed to furnish a copy of the bylaws and other documents relating to the cooperative society said to have been registered by the petitioner, which he undertakes to do by end of day 8th December 2025.
Yes.
The counsel for respond number 5 submits that the that in the present case, open plots have been formed and sold to the purchaser who have put up construction. The same would not come within the purview of the Karnataka Apartment Ownership Act 1972, since the same requires buildings to have been constructed and undivided interest in respect of the buildings to have been sold. In the present case, neither is undivided interest in any building sold to any particular person, nor is undivided interest in any of the common areas sold to any particular person. And as such, the KOA Act 1972 would not apply. In that view of the matter, both the counsel for the petitioner and respondents are and their respective clients are requested to look into the matter and consider whether a cooperative society would be the best possible manner.
Under
Section
COFA.
8 also is Section 8 is also a problem. Examine it. From what we saw the other day, there was some problem.
Compliances are
Both the petition councils and the parties are directed to examine any other methodology of administering the association apart from the KOA and KOA 1972 and KSR 1960. Released on January and date.
Could the lordships have it in preliminary hearing? That is-
21st January.
Could the lordships have it in
Yes,
preliminary
madam.
hearing?
49? Have you informed everybody?
43.
My lordship. 49 at the request of counsel for respond number 2 to 5. Toll matter. This is for further hearing. Why has it come for B group? 2:30 for further hearing it was. A list on 9th at 2:30 PM for further hearing. Just a moment, please. Yes. The request of counsel for the petitioner, January, not next week, January.
29 January.
43 at the request of counsel for the petitioner, January. Buy one more, get four free. 98 to? Find out why they are not accepting. Because even if we give extension, you don't accept, what is the point in extension? We'll take it up, get the instruction. Just a moment. We'll just go and get it for you, don't worry. We can't do that, it will come, yes. Yes, madam. 41. Dismissed as withdrawn.
41.
Dismissed as withdrawn and the Have you informed the respondent? Yes. You are opposing, not opposing?
File ತರಿಸ್ಬೇಕು.
That has also been completed. In view of the same, that it cannot survive the consultation.
So you are opposing, we are not adjourning. Sorry, you are here only for no person. 60? Not Monday. If it gets adjourned, it will go to January end. If you don't want it, you can take a chance today. If it is listed, it will come. It must have come. What is the CL number? What is the CL number? Then it is not listed. Have you moved a memo? Have you done anything?
Check ಮಾಡಿ. Number is. Memo ಹೋಗಿದ್ಯಾ ನೋಡಿ. ನಡೆಯಲ್ಲ.
Madam, second list ಆದ್ಮೇಲೆ next.
ಧಾರವಾಡ ಫಸ್ಟ್, ಕಲಬುರ್ಗಿ ನೆಕ್ಸ್ಟ್. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್.
Second list ಆದ್ಮೇಲೆ last.
ಧಾರವಾಡ, 2 ಕಲಬುರ್ಗಿ. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಪಾಸ್ಟ್ ಓವರ್ಸ್ ಕಂಟಿನ್ಯೂ. ಈಗ ಕೊಡೋದು ಡೇಟ್ ಎಲ್ಲ ಸಾಯಂಕಾಲ. ಇಲ್ಲ, ಒಂದು ಅರ್ಜೆಂಟ್ ಆಗಿಲ್ಲ. ಮಧ್ಯಾಹ್ನ ಈಗ ನಾನೇನ್ ಮಾಡ್ಲಿ ಹೇಳಿ? ಫೈಲು ಬ್ರಾಂಚ್ ಹೋಗಿರುತ್ತೆ, ಲಿಸ್ಟ್ ಮಾಡಿರಲ್ಲ. ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಆಗಿದ್ಯಾ? ಮೊನ್ನೆ ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಆಗಿದ್ಯಾ? 65 ಇದೆ. ಇಲ್ಲ, ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಎಲ್ಲ. ಅರ್ಲಿ ಹಿಯರಿಂಗು ಅಲೋ ಆಗಿ ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗುತ್ತೆ. ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೂ ಅದಾಗುತ್ತೆ. ಅಲ್ಲ, ಇದೆ ಸರ್, ಅದು 72 ಇದೆ. ಅದು ಗೊತ್ತಿಲ್ಲ ಸರ್. ಮಧ್ಯಾಹ್ನ ಯಾರು ಎಷ್ಟೊತ್ತು ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾರೆ, ಯಾರಿಗೆ? ಫಸ್ಟ್ ಧಾರವಾಡ, ನೆಕ್ಸ್ಟ್ ಕಲಬುರ್ಗಿ, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಪಾಸ್ಟ್ ಓವರ್ಸ್ ಕಂಟಿನ್ಯೂ.
ರೀಚ್ ಆಗಲ್ಲ ಇವತ್ತು ರೀಚ್ ಆಗಲ್ಲ.
With your lordship kind permission. With
Yes,
your
Mr.
lordship
Sridhar.
kind permission.
Really?
My
Yes,
lord,
please.
I'm in USA. My lord, serial number 63 is salary has to be released, my lord. Teachers are hesitating.
63.
ಹಾ 40 lakhs ಕೇಳಿದ್ವಿ ತಾವು ಒಂದು 30 ಲಕ್ಷ ಆದ್ರೂ ರಿಲೀಸ್ ಮಾಡಿದ್ರೆ ಸ್ಯಾಲ್ರಿ ಅದು ಇದು ವರ್ಕೌಟ್ ಆಗುತ್ತೆ
63 ರೀಚ್ ಆದಾಗ ತಗೊಂತೀವಿ. ಲೆಟ್ ಇಟ್ ರೀಚ್.
ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ, ಅದಕ್ಕೆ ಮೆನ್ಷನ್ ಮಾಡಿದೆ.
ವಾಟ್?
ಲಾಸ್ಟ್ ಟೈಮ್ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ತಾವು ಸ್ಯಾಲ್ರಿ 2 ತಿಂಗಳಿಂದ ಇದಾಗಿದೆ. ಟೀಚರ್ಸ್
Sridhar, the other matter, when it reaches, you can make a mention, not out of turn like that.
Yes,
My lords, there is a demolition order for tomorrow, my lords. If the matter can be posted for tomorrow, my lords.
Who is ordered for demolition?
Minor irrigation, my lords, from the AWE, my lords.
Classification. Dharwad bench matter. Serial number 1, Venkatesh Karvi.
Please, my lord, for the petitioners. The challenge to the petitioners, the present petition is, my lord, the issuance of factory license by annexer A dated 19/8/2024, page 20.
Settlement did not happen. Settlement enagilla.
My lord, they are so badly hurt by the submissions, the parents. They lost their sons. They are not even permitted to visit the spot where they have died. And even the permission was granted by the assistant director of factories and the DYSP Toranagallu. They did not permit. And again, they went on strike.
See, why we are asking is, since we had seen so much to see if we could settle, and so many things were said before us, would it be proper for us to take up the matter? And we are thinking.
Please.
It is, having been involved in all the, trying to be involved in the settlement, it may not be proper for having heard those
My
things.
view is that the court has done its duty, my lord. But I don't think there's a bar to your lordship's hearing. From my side, I have no objection.
We understand you may not have, but it may not be proper.
I'm in your lordship.
We tried to settle this.
I know,
thing, but
in fact, I sincerely think my learned friends, clients should, well, whatever has happened now. Let us move forward in life. And then beyond that, what can I say, my lord? I mean, if we are hung up on what happens, what unfortunate thing happened. What to do, my lord?
it's a little difficult for them also. Mr.
It is, my lord. How to repair it, my lord? How to repair it? I've gone out of the way. I said, I feel very bad for you. But if they tell me no, you should agree that you are negligent, that is a non-negotiable point, so far as I'm concerned. Otherwise, anything that they want, my lord, I have full sympathy for what happened. What more can I do? I can't bring their son back to life.
Then it may not be proper for us to take up the matter.
I mean, you are
all that.
May I suggest this, my lord?
Somewhere in our mind also, if something remains, it may not be proper.
We appreciate your lordship's concern in the matter, and even the parents are advised, let there be a human touch. And after 18 months of the incident, they want to organize a condolences meeting. And my lord, even they're not sorry for what has happened. That's what the parents' feelings have been hurt. They're not even sorry for what has happened.
Mr. Idram, if you still want to settle, we'll have it on another day. Otherwise, we'll release it, let it go before the regular bench. Because having been involved, you see, a lot of things you have said, a lot of things Mr. Raghavan has said, which may not be relevant to the legality of it.
Correct.
That is for the purpose of settlement, you have said a lot of things. So we can't forget all the things that you have said. It will be there.
Please, my lord.
That should not influence the order. Even, there must not even be a possibility of that.
Correct, my
If
lord.
you're settling it and if there's something, we'll
May I-
still
may I-
keep it. Otherwise, we'll release it.
My
We
lord,
have
may
to
I-
argue the matter before the regular court.
May I suggest
Better
one?
that way.
May I suggest
Sir,
one
may
course?
I request my lord to have it on 12th?
May I suggest?
Finally.
Yes.
May I suggest one course of action, my lord? In order to give this some new angle, you would ever consider referring it to mediation? Let them sit in front of a mediation. Let both of them air out their emotions, and then, my lord, the mediator, a senior, very experienced mediator, could
Who
be
will represent you?
well, one of the senior executives will come. Senior executives will come. No question, my lord. In fact, the senior executive has been involved.
Even there will be a problem, Mr. As to who will be there.
A senior executive who is entitled to take a decision,
Please, my lord.
not simply postponing things. I agree.
Let the, tomorrow, let the parties appear before the mediation and the matter be listed on 12th. Once for all. It's my prayer to your lordship.
Tomorrow, that person has to come. They're
I'm
not based in
going to-
Bangalore. So we'll direct it to be placed for mediation.
Yeah. And would your lordship consider, just a suggestion, my lord, a senior mediator like Laila Vellapalli, she's a very, very experienced mediator, my lord. And as I know, if your lordship thinks appropriate, I would be.
Both of you, whoever you agree for.
Yeah, I thought, my lord, a person who
At the
has.
pleasure of your lordship, any suitable experienced mediator.
Actually doesn't come to the center.
Who, my lord? No, she doesn't. We will go to
Doesn't
her.
come to the
We will go to her. We will go to her.
You can have
Yes, I know, ma'am. She doesn't.
Prashant Chandra is there.
ಇಲ್ಲ ನಾನು
Who
ಸ್ವಲ್ಪ
comes-
ಲೈಫಲ್ಲಿ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಇರೋರ್ನ ಮಾಡಿದ್ರೆ ಈ ತರ ಕೇಸಲ್ಲಿ ಬೆಟರ್ ಅಂತ ಅನ್ಕೊಂಡೆ ಅಷ್ಟೇ. ನಾಟ್ ದಟ್ ಅದರ್ಸ್ ಆರ್ ನಾಟ್ ಸೂಟಬಲ್. ಶಿ ಇಸ್ ಆಫ್ಟರ್ ಎಲ್ಡರ್ಲಿ ಪರ್ಸನ್ ಅಂಡ್
Please, the pleasure of your lordship's enemy.
Choice of mediator.
Any date before 12th and
This one is
Any
left
date.
to you.
my lord, any date before 12th and the matter, I request your lordship to list
ಲೆಟ್
it on
ಇಟ್ ಬಿ
12th.
ಕ್ಲಿಯರ್, ಇಟ್ಸ್ ನಾಟ್ ಗೋಟ್ ಹ್ಯಾಪನ್ ದಟ್ ಸೂನ್.
It is not.
ಸುಮ್ಮನೆ ಅವರು
See, if you are-
ಗಡಿಬಿಡಿ ಮಾಡಿದಾಗಲ್ಲ.
Mediation, Mr. Yadrami, if you try.
I
and put
understand, my lord.
Time
ಒಂದಿನ
limits for it,
ಒಂದು
nothing
ಸಿಟಿಂಗ್
will
ಅಲ್ಲಿ ಆಗಲ್ಲ
work.
ಇದು.
Nothing will work.
Please.
If mediation has to work, it has to be placed
Yeah,
over.
1 or
over a
2
period
rounds,
of
3
time.
more rounds. Yeah, it depends on how it develops.
Exactly.
It depends on how it develops before the mediator.
The mediator will decide.
Yes, my lord.
Please,
That discretion has to be left to the mediator,
please, my lord.
not for any of us to substitute.
Yeah,
that
my lord,
mediator.
I understand, my lord.
Your lordship may refer it to mediation. Call this after vacation. We'll see, my lord, how it works.
The fees you will pay.
Yes, we will bear. We will bear. We will bear. We will not burden them. We will not burden.
So we are not looking that side.
But I am going out of the way because I want this to be sorted out.
Both the councils.
Legally, I can argue, my lord. In fact, things have now become more complicated. I may tell you, lordships, what the further complication today is for my learned friends' clients. Better.
Better,
Better.
And anyway, we won't be taking it up on merit, that we are making it very clear. Only to facilitate settlement
I
is
know,
how
my
much.
lord. I also want to settle it, my lord. That's my sincere attempt.
Both the councils submit that
Right, okay.
the efforts were made to settle the matter between themselves, it could not settle. However, they submit that if the matter is referred to mediation, there is a possibility of a settlement being arrived at.
To
They
explore
submit
the
that
possibilities. To explore the possibilities.
There is a possibility.
Please.
They submit that Ms. Laila Olapalli, a seasoned and experienced mediator, could be appointed for carrying out such mediation process at the cost of respondent number
3 and 6. 3 and 6, my lord.
3 and 6 check.
3 is the
others,
company.
sir, 3. The cost of respondent number 6. In that way of the matter, registry is directed to forward a copy of the above proceedings and papers to Ms. Laila Olapalli. The party shall appear at the place, at the venue, time, on the date, time and venue fixed by the mediator for such purpose.
Public.
List in,
February ಬರ್ಲಿ ನೋಡೋಣ.
we'll have it in January.
All right. No problem.
Mid-January, to ascertain the progress in the mediation. If the mediation is going on positively, there would be no requirement to send back the file.
9th,
Yeah,
19th
19th. Your
19th
vacation,
January.
We don't know if in vacation she'll be here or not.
I don't know. My favorite also is to have it on the Fridays preferably. 17th is a, 16th is a Friday.
Oh, my learned friend comes from Dharwad on Friday. I have no problem.
So 19th, ಯಾವ Friday ಯಾವತ್ತಿದೆ ನೋಡಿ.
16th Friday ಇದೆ Lord, 9th, 16th, 23rd.
16th ರಜಾ ಇದೆ.
23rd.
Please.
23rd.
Obligation.
You will always welcome my friend coming to Bangalore. Great person.
Kalburgi bench matters. Case number 1.
For the respondent claimants lordship.
Like here, with the
My lord,
Advocate General, the guidance, my lord, that this mediations is going fully, everything is going to be mediation, my lord. So my humble request, my lord, the last
What
date of.
happened, some settlements that happened is what the Advocate General had mentioned.
148.
140, which is virtually half of the matters before your lordship. We've arrived at an in-principle settlement between the parties. However, some projects, your lordship, 145 is in respect of one project. However, in respect of other projects, the discussions are still underway. So our attempt is to
Finish that one project, then we can go for the others. Why should everything be pending if there is settlement
lordship,
arrived?
there
Give
are-
confidence to the others.
No, your lordship, there are some other matters also pertaining to the same project which are still pending. So we're trying to get them all consolidated. They're pending before Justice Kamal, and those matters have been adjourned to January. So we're trying to get those settled as well, so that a consolidated proposal is sent to the government, your lordship. Our only request is that these matters be taken up in the third week of January, so that we have a finalized proposal.
Every
before your
time it
lordship.
is 4 weeks, 6 weeks.
Yes, your lordship.
Mediation dated 22/12/2025 is there, my lord. So in the meantime, my lord, the process also going on. So it's going to be a right direction only. Almost it's going to be entire things is going to be consideration. It's a process.
All the councils submit that in principle settlement has been arrived at. The modalities are being worked out. So also settlement in other matters which are not connected to the present batch are also being settled. They seek for and are granted 6 weeks time to report further progress. Released on 23rd, Friday ಆಗುತ್ತಲ್ಲ ಬೇಡ. Monday ಕೊಡಿ. 19, by 19th it will happen or later?
19th okay, my lord.
By 19 January.
Deeply obliged, your lordship.
Sale number 2 no same order.
List number 2. Further hearing, serial number 1. Dr. Yasmin Shah, party in person.
Trying to resolve the problem.
Still.
Almost done. Not done fully, not almost done. There are a few things which are outstanding. There is a loan agreement which is signed, but I think that has to really come. There is some resolutions from the company which is required to give effect to the loan agreement. And then the monies have to be transferred. The idea is to transfer the money on the 8th, if possible, by the 8th.
8th of December.
8th of December, if possible, not subject to those two things being done, and some affidavits to be filed before your lordships as to the modality in which everything is closed. And then the payments to be made to each of the petitioners.
By when?
That will not, I think, 1 week's time.
Rest of it is all left to you.
Yes, yes.
We are only concerned with the last portion.
Yes, my lord, I know. But there are 1 or 2 things which we want them to file before your lordships in form of an affidavit confirming this.
But when will the payments be made?
When will the payments be made?
When you transfer to my account on the 8th, that time, immediately thereafter.
You are appearing for whom?
For Godrej, there is the
I
applicant.
should speak actually. Let me also say something here.
But they are the ones giving you the money.
No, but it's something they've taken from me for that. okay, there's a collateral here, which I've done the ultimate sacrifice to get these people paid off, because that's my commitment.
We forgot to tell you last time, it was good seeing both of you old friends walking out together.
That's true.
Yes.
So which is a commitment I mean, and therefore I've given a collateral and an agreement is in place. I signed it. They have not yet signed it. I'm waiting for that to be signed, and they said the money would be released on 8th. So I said, okay, although we have memos almost settled with all of them here.
So 8th, they are going to transfer is what Ms. Chinnappa
Yes,
says.
yes.
So by when will you make payment to all of them?
As soon as the funding lands, then we will make BDs and get everything dismissed appropriately. They were suggesting that checks be given and all. I don't think that's necessary. Once they transfer on 8th to my account, we will do a DD. And I would say like 12th would be a good date for everything to be closed and clear.
We'll have it on 12th. Shri Chinnappa, learned senior counsel appearing for?
The objector, I think it was called Vora Soaps at that time. Now it's Godrej Industries.
The objector submit that the settlement arrived at between the objector and the company. Certain amounts are going to be paid by the objector to the company.
No, it's actually to Mrs. Patel.
It will come to me because I'm providing the collateral.
It's a loan to her and then to the company.
Not to the company.
I lend
Not
it
to
to
the
the company.
Who would be paid, Shri Chinnappa, learned senior counsel appearing for the objector, submit that arrangement has been arrived at between the managing director of the company and the objector, whereunder the objector is going to make payment of certain monies to the managing director. The managing director, who is present before this court in person, submit that once she receives the money, she proposes to, she would be lending the said money to the company in order to liquidate the claims of the claimants as per the settlement which has been arrived at. She submits that demand drafts would be kept ready for handover by 12th December 2025.
Depending on them releasing the funds.
Ms. Chinnappa said,
Not my money, but anyway, we hope to release it.
Absolutely. Otherwise,
if your client doesn't, you have to release.
That's what I'm saying.
Can I make?
I'll
a
take over the
submission?
company.
Yes, madam.
Your Honor, there's 7 acres of land which is not registered yet. If there's any further delay from Godrej side in providing the amount, those 7 acres can be, by court order
If they don't do it, not 7, everything is going to go.
to 87 acres.
Why you bother about 7?
Okay.
There won't be anything left for the.
Whatever is there will go.
The CMD, Dr. Villu Patel has done everything. She has given her property and signed off everything. Still
If-
there's a delay.
If this doesn't settle and if we wind up the company, everything is going to go.
Without winding up, there's a Supreme Court precedent.
We can do that, but we'll wind up the company so that everything is clear.
No, Your Honor.
This is too precious a company. It's much.
That is
beyond
why
what
all
the
of you settle the matter. That is why even after reserving the matter, we have given an opportunity. So, and though your lawyers have changed 5 times, we are giving you
I'm
opportunity.
coming myself now. I'm the
Yes.
Sorry.
Relist on 12th December at 2:30 PM. Please carry the demand drafts on 12th. Please make it and let this bad episode be a bad episode and continue.
Because this company.
Don't
worth a
delay
lot
it,
more.
delay it further so that everybody is happy with what it is. What about CL number 2?
Recently shared a settlement agreement with us on 29.
Hmm.
Circulated, my lord, will take instruction by.
So
date
yours
15.
also will be set. So CL number 2 also will keep the DD present on.
It's for 1.5 crores, my lord.
One submission, my lord.
What amount you agree upon is between you.
Please.
If there is some shortage somewhere, then we can intervene, whatever you agree upon.
One submission, my lord.
2 same order, yes.
1.4. 2 to 9 by 2014, Your Honor. We are need at least 8 lakhs, 8 lakhs.
See, in this case, the petition says that amount. We are going by the petition. We cannot increase. Suddenly your petition, initial petition had 2.8 and that's what we are paying.
You want to settle, you settle. We are not on the money. It depends on what you want to settle for.
ಅಲ್ಲ ಸ್ವಾಮಿ 10 ವರ್ಷದಿಂದ ಫೈಟ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ ಸ್ವಾಮಿ, ಈಗ ಅದೇ ಅಮೌಂಟ್ ಕೊಡ್ತೀವಿ ಅಂದ್ರೆ ಹೆಂಗೆ?
ಅದಕ್ಕೆ ಇವಾಗ ಸ್ವಲ್ಪ ಆದ್ರೂ ಬರ್ತಾ ಇದೆ, ಇಲ್ಲಾಂದ್ರೆ ಏನು ಬರ್ತಾ ಇರ್ಲಿಲ್ಲ ನಿಮ್ಗೆ. Your unsecured credit. You would not have got
ಅಟ್ ಲೀಸ್ಟ್
anything.
ಒಂದು 8 ಲಕ್ಷ ನಮಗೆ ಮಾಡಿದ್ರೆ ಅನುಕೂಲ ಆಗುತ್ತೆ ಸ್ವಾಮಿ.
ನಿಮ್ಮಿಷ್ಟ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡೋಂಗಿದ್ರೆ ಮಾಡ್ಕೊಳ್ಳಿ, ಇಲ್ಲಾಂದ್ರೆ ಇಲ್ಲ. ನೀವು ಒಬ್ಬರೇ ಉಳಿದ್ರೆ then why should we wind up the company? You file a civil suit on Thursday.
ಲಾಸ್ಟ್ 10 ಇಯರ್ಸ್ ಇಂದ ಫೈಟ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ ಸ್ವಾಮಿ, ಲಾಸ್ಟ್ 11
Don't
ಇಯರ್ಸ್.
trying to take advantage of the situation. Don't try to take advantage. First 50% ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಇವಾಗ 8 lakhs ಅಂತ ಹೇಳಿದ್ರೆ ಸರಿ ಹೋಗಲ್ಲ.
ಇಲ್ಲ ನಾವು ಹೇಳಿಲ್ಲ ಸ್ವಾಮಿ, 50% ನಾವು ಅಗ್ರಿ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
Yes, Mr. Ariga. By 12th, they say that they are going. What you will have to do is only catch hold of Mr. Chinnappa every day till the 8th and see that he transfers the money. So you prevail upon him. Welcome to the party, Antash. Yes, 12th, please.
Thank you. Serial number 3, Shankar Lingappa Nagaraj.
Not 8 weeks time may be granted. I will file affidavit. Not
8 weeks on the affidavit.
8 days.
8 days.
1 week.
That is better. And AGS seeks for and is granted a week's time to file the affidavit released on 17th December.
Obliged.
Serial number 4.
Lord, I had an occasion to go through the report of the state government. Actually, I didn't have a copy. I just got a copy of it on the last day. That report, my lord, is not only by the police, it's by the revenue officials as well. They have gone, they have looked into the entire antecedents of the person. They have looked at the records of that family. They find that the grandparents' electoral records date back to 1966. Land records of that person have also been.
You are ready to address arguments.
Yes, my lord.
What is this respond number 6 to 9? Who are respond 6 to 9?
That's the West Bengal.
The government of West Bengal, my lord.
Waiting service.
Not. They have submitted a report that day. My learned friend has submitted that they on Sunday they were work because of that reason they were not great party.
This report.
2811.
Dispatched on 28/11. Service is not yet complete on
My lord,
6 to 9.
I didn't have the benefit of this report on the last day. But I was a little taken aback when I saw this report. When it is so conclusive, my lord, that this person in question, the petitioner herein, is a bona fide resident citizen of this country.
They are objecting to it.
Yes, my lord,
Notice
they
is
are
not yet,
objecting.
notice is not yet been served. So notice has to be served and then we can take it up and not until then.
Yes, my lord, he's been in
Notice
custody
has
from-
been dispatched only on 28/11.
on from
Okay,
August
why was
28th.
it so delay?
Inside, my lord. August 20th was when he was taken to the detention center.
10/11 we had issued the notice.
On 1811.
Please, my lord.
We only delayed. Notice to respond number 6 to 9 has been dispatched on 28/11. Awaiting notice, we'll relist it on 17th. Let us see by that time, otherwise it'll have to go after. Unlikely that it'll get served by that before that.
My humble request would be this then, my lord. If it happens till then, well and good. They've also sought instructions from the Bangladesh High Commissioner. Let them come back with what's happened on that.
What has happened on
Please, my lord, I'll come back on 17th, my lord. I'll place it, my lord. What is it?
17th? If
On that day, my lord, I would only request this. In case, my lord, either of these things not happen, my lord, may please consider passing on
until,
so far as.
until service is affected, how do we take it up? If
Understand that, my lord, it's just a peculiar situation that the petitioner is in, my lord. There are reports of the state government saying that he's a citizen.
See, if service is affected, they don't come, we can take it up and go ahead.
Please, my lord.
But if service is still to be affected, registry is direct, trace the postal track record by then. That is how much we can do.
And I understand that, my lord. But if my learned friend can use
I'll
his
get
good,
it.
good offices, my lord, just to at least get that instruction.
70.
I'll place it on record.
Yes, please.
70.
70.
Serial number 5.
No, there's an interim order.
Interim order earlier granted is extended next.
Ah, but yeah,
Most important.
in fact, my lord, I must say, Yesterday, my lord, the Honorable Apex Court, one of the orders that I referred to, the West Bengal, the Kolkata High Court, that was taken in appeal by the union. Those people who were sent back to Bangladesh, my lord, they've actually been brought back now. So, my lord, this situation now is becoming this way. my lord,
It's
where-
it's not that they've brought back. If my instructions are,
I have the order, my lord.
the apex court has told, consider of bringing them. So, Lord,
Consider is you have to do it. The apex court
Lord,
says
This is
that.
the order of the
the order you got.
Please. I got it.
ಇವತ್ತು ಬೇಡ.
Other than, just to
We'll
clear
hear
the
Mr.
case,
Manmohan in his matter. We'll hear you on 17th.
we are in such kind of a situation, my lord. That's why only submission.
Yes.
Lord,
Serial number 5.
but in this matter, Lord, I owe an apology. Lord, with regard to the GST, Lord, I dug deeper with the client as to, Lord, what is the quantum of amount. Lord, so recollect, Lord, this is with
This is
regard
that,
to the
this one.
interplay
As a
between,
company,
Lord,
MSME and-
yes, Lord. So I dug deeper to ask him what is the exact amount that is due that arises out of this transaction. He says this transaction in as such is not affecting, but the GST and not the bank are proceeding against him in respect of various other transactions, but this amount is what is troubling him. But
Same
issue
thing.
is the same. Yes.
Only one minor
Only this,
issue.
that not
minor
factual mistake, Lord.
difference. That will correct.
Yes. But I have filed an application for impleading. I think it is, I
Who do you
filed
want
it
to implead?
yesterday. But I've sought to implead not the bank and GST authorities.
In the light of the directions framed by my lord, their presence may be required is what?
Yes. IA 1025 has been filed to implead the Department of Commercial Taxes and the Canara Bank, considering that their presence would be required to effectively and completely decide the list between the parties. IA 1025 is allowed. They are brought on record as respond number 4 and 5 respectively.
Petition.
And AGA accepts notice for respond number 4. Canara Bank,
CP Muttanna.
Shri
Please.
Vignesh Shetty ne idaralla. Shri Vignesh Shetty is directed to accept notice for respond number 5.
Please.
Counsel for the petitioner to furnish 2 sets of the petition along with annexures on the said counsel.
Please.
What do you have to say, Mr.?
So we'll put together some material. My lord has given us a sense of the direction in which to go forward. The EC directives and the UK Act do provide have some provisions to enable such situations where the underlying debt or the transaction, if it fails, then the applicable VAT or the sales tax can be waived. In cases where it has been paid, you can also go and seek for refund. So what I'll do is I'll put together a brief note on what are the structures prevailing there. And we had a provision 43A. My colleague has done some good research in this. We had a provision in the GST Act 43A where the supplier or the any of the concerned parties could also amend the filings that were done on the portal. That 43A has been subsequently deleted. I have to also understand what was the logic behind that. So now once something is uploaded on the portal, it cannot be touched. But earlier this provision was there.
So all the wrong claims of ICT.
That's right.
That is why that was deleted.
So, but then this is a genuine issue that needs to be addressed. My lord has hit the nail correctly.
We really don't have a say, but if my lords
You are
have to.
the one who has to say
My lords-
everything. You can't say I don't have a
My lords,
say.
is the liabilities towards the tax department, GST, as also Canara Bank.
Not just,
That's,
no, you have a larger perspective. See, for the purpose of the IBC, right or wrong ಅಂತ ಹೇಳ್ಬೇಕಾಗತ್ತೆ. Right or wrong, you made a provision to cater to the company which is not able to pay.
that's my limited research is that as against the bank, the amount cannot be waived because it's amounting to an independent contract between the petitioner and the bank. And the creditor, he is not bound by the whatever loan the petitioner has raised against the bank. So privity of contract arises. So resolution plan does not bind under section 31 of
Please
IBC.
request Mr. Kamath to come. We'll explain to Mr. Kamath.
ASG will be making submissions.
Because you can't be taking that kind of a stand. For a simple reason that because you did something to favor one, you are disfavoring several others.
Let's probably we can consider the fact that it's an MSME unit and there's a special enactment
It's a
which
MSME
governs.
unit, not just as MSME. It's a domino effect.
Please, but
Because by IBC, You are saying you have come up with this particular thing, you accept only this money. We'll give you only this much money.
Plus, they
irrespective
had
of-
an option to appeal to NCLT. That's not been done.
Okay, what is the point in appeal?
Well, it's whatever, they could have taken a chance, my lords. Now they come up in the writ jurisdiction
want to
seeking
give-
waiver of so much.
You want to give a finality to the IBC proceedings. They go by what you say as a COC or otherwise and accept it. You want that kind of litigation, we'll make that observation, everybody challenge. Don't accept.
Yes, but the sublime object of IBC is
That
to.
is what you are saying. So if that is your stand, that's why get the ASG.
Please.
Be clear on your stand. If that is a stand, we'll record that. Please understand the implications of it also.
Yes, ma'am.
If that statement we record in the order, then everybody will go before the NCLT and NCLT will be flooded with this litigation. And nothing will close at the IBC. Nothing will close. Because then then you will say NCLT is done, now go to the Supreme Court. So they'll go to the Supreme Court. It will be a flood of litigation. You have to look at not litigation, but solving the issue. There's a genuine issue which is there. That company had a genuine issue, you close that. But what happens to the repercussions and the domino effect? You will end up closing this company also. Now they will also go under IBC. Because you close them, another 10 will follow them and into another IBC.
Absolutely right.
It's difficult to give a
So
full
behind
proof.
one, you will have 100. So you will have to apply your mind to it. You have to consider it and then do it. You can just say, let them go file NCLT. Mr. Manmohan will go outside NCLT and say, all people come will.
Karnataka High Court has opened the doors for litigation. We will
Otherwise, it's
assist the court, my lord,
it's actually barred by
putting
limitation.
together similar structures, whatever are there in other jurisdictions. We will see.
Madam, this is a important issue. You can't be technical about it. If you want to be technical, you please be. We'll deal with those technicalities.
These are the preliminary discussions what I had with it's the.
Please tell your officers also that they cannot be technical about it, because if they're technical, that technicality will result in some 1 lakh litigations. Easily. If we ask Ms. Joshi, probably you say 10 lakh litigation.
Certainly.
Easily. Don't give scope for further litigation. Close the matters, provide a solution to everybody. That is what is expected from the government.
Please, Minister.
Due to this, taking into consideration the importance of the issue, the Additional Solicitor General is also requested to assist this court in the present matter. Released on 17th December.
Copy is not served to the state court. Copy will be served.
Really, 2 sets of copies.
Yes, absolutely.
Please. Great. By that time, you will, if you're
We'll
not
put together a note on various jurisdictions, what are the prevailing structures in those jurisdictions. And the couple that my lord also mentioned in the order, we were also pleasantly surprised that they have addressed the issue. Our government may take a technical stand, but the issue has been recognized and addressed, that there will be a waiver of taxes, which was a pleasant surprise. It can be done.
Probably the officers that madam has spoken to
May not be aware of
may not be aware of it, and it requires a decision to be taken at a higher level.
the policies. More than a
It's a
legal issue, it's a
policy,
policy.
policies.
So we can just assist by
Escalate
showing
it.
the policy.
Escalate it up.
Great, great.
Serial number 6.
Lord, in serial number 6, my lord, affidavit is ready, madam. I'm flying affidavit, 2 affidavit.
In affidavit, what is this?
Lord, this honorable court has directed to file an affidavit where, my lord? There is a delay, the petition has taken a contention that delay in filing FIR, my lord.
So when was the complaint received? Complaint was submitted on 8/4.
Also.
Acknowledged.
Lord, he made a
in 6.
oblige, my lord.
Hmm.
Lord, may request my lord to take an affidavit filed by the DCP, my lord.
Hmm.
May I request my lord to turn at page 17, my lord, annexure R1, where what he is made a complaint that I will show, my lord. Page 17, R1, my lord.
Hmm.
Station house diary, that remark.
7/4/25
ಹೌದು ಸ್ವಾಮಿ.
at 9:25.
May I read, my lord?
Hmm.
ಈ ದಿನ ಸುಮಾರು 21:10 ಗಂಟೆಗೆ ಸಮಯದಲ್ಲಿ ಇಂದಿರಾನಗರ ವಾಸಿಯಾದ ಪ್ರಭು ಮತ್ತು ರಾಹುಲ್ ಎಂಬುವರು ಠಾಣೆಗೆ ಭೇಟಿ ನೀಡಿ ತಮ್ಮ ಮನೆಯ ಪಕ್ಕದ ನಿವಾಸಿಯಾದ ಶ್ರೀ ಕೃಪ್ಲಾನಿ ಎಂಬುವವರು ರಾತ್ರಿ ಸಮಯದಲ್ಲಿ ಜೋರಾಗಿ ರೇಡಿಯೋ ಹಾಕಿಕೊಂಡು ಸೌಂಡ್ ಮಾಡುತ್ತಿರುವುದಾಗೆಂದು ಈ ಬಗ್ಗೆ ವಿಚಾರಣೆ ಮಾಡಬೇಕೆಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಅದೇ ಸಮಯಕ್ಕೆ ಪಕ್ಕದ ಮನೆಯ ನಿವಾಸಿಯಾದ ಶ್ರೀ ಕೃಪ್ಲಾನಿ ಅವರು ಸಹ ಇಂದಿರಾನಗರ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಬಂದು ಶ್ರೀ ಕೃಪ್ಲಾನಿ ಅವರು ಠಾಣಾಧಿಕಾರಿ ನನಗೆ ಪ್ರಭು ಮತ್ತು ರಾಹುಲ್ ಅವರು ವಾಸವಾಗಿರುವ ಮನೆಯಲ್ಲಿ ಗಾಂಜಾವನ್ನು ಬೆಳೆಯುತ್ತಿರುತ್ತಾರೆ. Lord, on that day, my lord, that was the only complaint he was given, that they were growing ganja. Lord, kindly may I request, my lord, at page R3, my lord, 21, my lord. Without intimating anybody, my lord, on the morning I was visited that there was no such ಇದು ಅವ್ರ ಮನೆ ಮೇಲೆ ಏನೋ ಕೆಲವೊಂದು ಪಾರ್ಟ್ಸ್ ಇಟ್ಟಿದ್ರು. That was I visited, my lord, after what his complaint has given, my lord. That after, my lord, he made a complaint to the DCP, my lord, saying the DCP has issued notice on 22/23 R4, my lord. R4/23. May I read last second para, my lord?
Yes.
You are informed to appear before the date so and so, Alsur police station along with the available evidence. Lord, he did not appear on
complainant.
He did not appear on that day, my lord.
Yes.
He made one more complaint, that is, he said that it is not given to him. Lord, see item number 13, Lord, it is delivered to him, he signed and is taken.
Yes.
Lord, next page, my lord, R6, my lord. Lord, ನೀವು ಠಾಣೆಗೆ ಹಾಜರಿ ದೂರು ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ ಮೇ ರೀಡ್, ದಟ್ ಇಸ್ ರಿಲೆವೆಂಟ್. ಸದರಿ ದೂರು ಅರ್ಜಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ವಿಚಾರಣಾ ಕಾಲದಲ್ಲಿ ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಇಂದಿರಾನಗರ ಹೇಳಿಕೆ ಪಡೆಯಲಾಗಿದೆ. ನೀವು ಠಾಣೆಗೆ ಹಾಜರಾಗಿ ದೂರು ನೀಡಿದಲ್ಲಿ ಅಗತ್ಯ ಕಾನೂನು ಕ್ರಮ ಕೈಗೊಳ್ಳಲಾಗುವುದು. Lord, he has made a complaint again, my lord. After that, my lord, he has given some video records what was happened on that day, my lord. I have registered NCR, my lord. After that, registering NCR, my lord, this is very important, my lord. I have to show that how it was done and why this writ petition is filed. May I request, my lord, to turn at page, my lord, this honorable court order at page R18, my lord, 57. They have filed, the petitioner's mother has filed an habeas corpus, my lord, saying that something. May I read directly, my lord, page number 7, my lord, at page 62, ink page 62.
Yes.
Today, the learned SPP filed in counter affidavit stated that the ascertained made affidavit of the petitioner is totally false and not in a point in time. The police have neither abused nor manhandled the detainee. He submitted that after filing this writ petition, the Indiranagar police made hectic effort to trace the detainee who was staying in Marriott Hotel, so and so, Chennai. When the police informed him to appear before the court, he abused to the police officer such as they ought to have been held Chennai jurisdictional police station to produce the petitioner before court. However, the detainee assaulted one police officer, namely Vinod Kumar, PSI of Indiranagar police station. Hence, the case has been registered against the detainee in the said police station. The crime number so and so also has been registered. My lord, this is the whole motive of filing this writ petition, my lord. When he made a complaint, my lord, we have registered the case. Lord, earlier I agree, my lord, he has made a complaint saying that they are growing.
Produced and that was considered by the court.
And the petition is dismissed with warning.
The petition was filed for ulterior motive. Imposing 1 lakh cost.
ಹೌದು, ಕಾಸ್ಟ್ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅವರಿಗೆ. Lord, kindly pay see that 66, my lord, 1 lakh cost is imposed on the petitioner's mother. This is the whole motive to file this writ petition, my lord.
Court refrain from making further comments on the conduct.
Lord.
Yes.
My lord, the allegation is that he's,
Let him complete.
Lord, this is, my lord, we have taken his complaint, my lord, only on the first complaint, what he is given, it is only saying that there was a ganja something, my lord, I visited, that was not there, I did not do because there must be some evidence to register FIR, my lord. After that, his complaint, my lord, I registered in NCR, my lord, these are the matters were non-cognizable, my lord, because of that reason, I give an endorsement at page 29, my lord.
Yes.
29 Rahul Kotiyan Swami, sorry. Kriplanigi R11, my lord, 35. Are page 35 and 37, my lord. These are the registered, my lord.
Yes. Anything else?
No.
Yes.
my lord, the allegation that the assailant is involved in cultivation, consumption and distribution of ganja, my lord. And the provocation is at about 2 o'clock in the morning of 6th April. Without any provocation, he has intruded into my house. He has broken the pots. He has caused dislocation of my shoulder, my lord. He has caused grievous injuries. And in the presence of my mother, he has abused me in filthy language. So at about 6 o'clock, same day, it was a Sunday, my lord, I go with a complaint. It was, the police have advised me to receive the FIR on the next day. My lord, Annexure B. My lord, Annexure A is the complaint. This was not accepted. My lord, I have Annexure B, my lord, I have specifically stated, my lord.
Mr. Counsel, this is like road rage, house rage. One small issue about high sound radio blaring. You reached this stage today. You want to progress it further?
I'll take instructions. I'll refer to the.
There will be no end to this. It only started with one complaint of the volume being high. Then counter to counter to counter to. You've already been asked to make payment of 1 lakh of rupees. Where do you want to take this to?
Lord, I'll take instructions. I'll discuss.
Vasu.
Serial number 7. Venkataramanappa.
To appear for petitioner in this case.
I appear for the respondents in this case.
Yes.
Because this is a matter wherein we had taken notice the day before.
Yes.
Perhaps
Your name was wrongly printed, which was shown.
Yes,
so.
yes, perhaps, yes, yes.
Otherwise, notice was nearly 10 days ago.
Yes, and
But
we
anyway, yes, Mr. Joshua, what does your client say?
Well, we have sent the writ petition copy to them. They asked us to take a short accommodation. We'll file a counter, my lords. What has happened is, he was earlier, his representation was rejected on 29, and he reported to Mangalore Airport, and he has assumed his duties in Mangalore Airport. And thereafter, on the same day, he gives another representation. We just told them, look at it from a humanitarian point of view. But they said if the rules so provide, then we can do it. But otherwise, we will not be able to. Because it should come within the provisions of the rules, my lords. That's what my instructions, oral instructions are. I'll file a short counter, my lords. By Monday, Tuesday, I'll file it.
You're free to do that.
My lordship,
We'll have it on
there is
Tuesday.
an
Let us see what their objection comes. We'll deal with their
short
objections on that.
accommodation, my lordship. It's already fifth month is running. She is alone, my lordship. That's
We'll have it on Tuesday.
much obliged.
We're not going to give them any more time. Tuesday, 2:30, we'll have it.
Much obliged.
But be careful before you file it. Think about it and file. The counsel for respondent number 1 and 2 seeks fund is granted 4 days time to file a statement of objection. Released on 9th at 2:30, it is made clear that no further adjournment would be granted.
Obliged.
Serial number 8.
For the petitioners, my lord.
You are the CMP. Notice issued to respond number 4 has been returned with the endorsement unclaimed. In view of the amendment to the CPC, unclaimed, a postal article returned unclaimed is deemed to be service. And service in respect of respond number 4 is held to be sufficient. Registry direct print the name of respond number 4 with the endorsement service held sufficient and relist on 12th December.
Serial number 9.
Because I don't have the originals of the compliance affidavit, but I received the soft copy as a class type. Manoj, what I've done is, Manoj, I've also taken screenshots of how we've complied with it. Manoj. May I pass it?
So you verified.
I have, Manoj. Manoj, what was required of us, Manoj, was to strengthen the admission process, Manoj, because the list before my lords was that certain students who did not participate in the counseling authority were getting enrolled in colleges directly. And thereafter, my lords, they were being discharged. And these students had moved this honorable court, my lords.
Yes.
And my lords, by order dated 26th of March, my lords had directed us to strengthen the admission process. So we came up, my lords, with a detailed project report where we said that we will create a common web portal where universities as also counseling authorities will immediately have to verify the credentials of the students. And thereafter, the college is notified and the college will discharge them. Because otherwise, my lords, what would happen is college would send us a list. And by the time we ascertain these details, my lords, it would take about a year or two. And then equities are pleaded, my lords. So what we've done is, if my lords has the second memo, my lords, for a moment.
Second memo. Yes.
My lords, this is the DCI website as it stands today, my lords. On the right-hand top corner, my lords will see DCI portal login new. My lords.
Yes.
My lords, over the page, my lords, at page number 2, my lords will see that we've also developed a mobile application. At page number 3, my lords, we mentioned what are the total number of MDS seats, BDS seats, I mean the colleges and the permitted seats in each college, my lords, faculty as well. At page 4, my lords, we have, my lords, included something called as a college search, a faculty search, and an Indian dentist register, my lords. I will come to college search, my lords, in a minute. But, my lords, and then again, my lords will come directly, my lords, to page number 7, my lords. This is, my lords, the implementation of the DPR. My lords, at page 7, my lords, again, DCI portal login. This is, my lords, another replication of the first page I showed, my lords. Over the page, my lords, is 8. This is the login page, my lords.
Yes.
My lords, then after that, my lords, this is the university view, my lords, will see at page number 9. And my lords, how this takes place is at 10, my lords. So once the colleges, my lords, upload the names, my lords, there are two options which are given to the university, either to verify them or not verify them. Now the question of verification comes, my lords, in categories as to whether a student belongs to the general merit, so and so, my lords. Now, if I do, my lords, say verified, my lords, which is at page 11, and then at page 12, my lords, is the verification that the registrar, as the registrar of universities, carries out, my lords. So this is displayed to the college. I'll come to that also, my lords, shortly. Now, my lords, at
So it is transferred online, the application, and online verification is done immediately.
Yes, my lords. So it has to be done within 7 days of counseling, my lords, after counseling concludes. So at page 13, my lords, is not verified, where we basically also ask them to give comments, my lords, as to why you're not verifying it, my lords. Now, over the page, my lords, is the counseling authority's login view, my lords. Similar situation, my lords, verification not verified. Then, my lords, if my lords comes straight away to page number 19, my lords. Now, my lords, at page 19, this is what the college will, my lords, view. To say that whether the verification has been conducted, my lords, by the university as also the counseling authority. And over the page, my lords, is what, my lords, at page 21 is, my lords, the final verification status that is showed, my lords. Now, my lords, will for a moment come to page number 19, my lords. If a student's details are verified, my lords, both by the university and the counseling authority, my lords, may just come to page 19 for a moment, please.
Yes.
At the bottom of page 19, my lords will see there is one RP20250, which is, my
Unique
lords,
ID.
in a box. That's a unique ID, my lords. Now, this unique ID, my lords, will also be a part of their final certificate to state that these students
So
have.
it will be the ID for the student throughout the course.
Yes,
that particular course.
Please, my lords. My lords, and one last thing, my lords, if my lords comes to page number 22, my lords, for a moment. Now, my lords, I had earlier on showed my lords that our webpage consists of college search, faculty search, and Indian dentist register. Now, in respect of a college, because my lords had last time orally remarked saying, what information do students get from the website? So if my lords comes to page 23 minutes. So this is one of the colleges which is also before my lords. So we basically provide all the details, my lords, to state that when was it established, and then, my lords, on the right-hand corner, my lords, or the rightmost column, view more details, my lords. And over the page, my lords, at 25, my lords, is the complete details of what the college has. My lords. Now, my lords.
So these recognition letter can be clicked and the recognition letter can be seen, or it is only?
No, my lords, we've given the referencing to it because these recognition letters, my lords, year on year also get renewed. So if at all, my lords, anyone has any difficulty at a later point, my lords, it can always be applied for and taken.
Since each recognition letter is uploaded,
please, my lords.
Would you be uploading the details have been filled in? Would you be uploading the letter so that the letter is available on the website?
My lords, I would think that they're not, my lords, but we've given the referencing because
You
our
can
DPR,
do that also.
DPR didn't include the scope of that, my lords.
It's all a trial and error. You keep on improving. So that could be done. So all these documents are available. So now you are given the total number of seats which are available. Now, when it is showing 100, people may think that 100 seats are still available. So you should probably have a column saying that total sanction strength 100.
My lords,
Total admitted 98, vacancy 2.
I would bow down to what my lords is saying. But my lords, when I go to the counseling authority as a student, I'm also, my lords, intimated of the total number of seats that are available. So my lords,
The problem is not with counseling. The problem is with the direct admission. So when a student goes for direct admission and he sees in the website that it's 0.
my lords, that would, my lords, I understand what my lords are saying. Now, my lords, that would be updated, my lords, only after this process of DCI portal login is completed.
Keep that updated.
So
the 2 columns are not there. Add those 2 columns. A very easy thing to do.
to say upload every document, my lords, of the recognition.
One is upload the document so that they can verify it, so that there's no hanky-panky done on that. Number 2 is the sanction strength.
My lords, that's there at page 26. My lords.
26.
Yes, my lords. So academic year, approved seats, recognized seats, intake capacity, permitted seats, and admitted seats. So that is provided for.
So this is the most important part of it.
My lords will see, my lords, we've updated up to 25, 26. So we've carried it out for all colleges. But on one aspect, I must be candid, my lords. Now the MDS counseling concluded on the 8th of September. Now the BDS counseling, my lords, is concluded on the 20th of November. I'm given to understand that there is some stay as well on it. Now, in respect of the MDS, my lords, students who've been admitted, my lords, we've already started the process because it fell from my lords on the last occasion because 2 universities have not submitted their login credentials. But nonetheless, my lords, in respect of MDS, we're concluding as we speak, my lords. BDS will begin as soon as, my lords, the last date for counseling is announced.
So all universities in Karnataka are...
All universities in Karnataka have, my lords. Only one counseling authority somewhere in Punjab and 2 universities in another part of the country have not given.
All universities across the country.
Please, my lords, this is for 66. This is pan-India. We've implemented pan-India.
So hopefully this solves all those issues.
It should, my lords. Ideally, it should, because now, my lords, it's available in the public domain, and most of them also have an application on the phone. So it would be of convenience to students, my lords, even if they don't want to log into the web page, they can look at it on their phone. So the information is out in the public domain.
So all the suppression and doing
That
it will not, hopefully.
I'm grateful.
An affidavit of the Deputy Secretary Dental Council of India, National Dental Commission has been filed, which reads as under.
My lords, before my
Along
lords
with the
dictates, my lords, on the 27th of November 2024, my lords had approved the task force committee report. That may also be reflected in the
basis of the said affidavit, learned counsel for The dental council submit that the DCI has successfully has implemented a new web portal with a login for all colleges to upload the details. Colleges stroke counseling authorities to upload the details and verify the students who have sought for admission. A unique number is now being granted to each, a unique number is allotted to each of the students. And the details of the total intake capacity, admitted students, and the vacancy is also uploaded onto the website. And these information being available to the students and the parents, there's a clear, there's transparency which is sought to be brought about in the admission process to dental colleges across the country. The submission is that all the details being available and the application stroke request being processed more or less on a real-time basis. The question of any wrongful admission or otherwise would probably be taken care of by the changes which have been made. The said submission, along with another memo, the screenshots of the website which has been implemented has been produced. The same indicates and supports the submission of Learned Counsel for the DCI. What is that task force order?
Manoj, the task force was constituted. Manoj, we'll see the memo dated 8/7/2024. I have a copy with me, Manoj.
Yes, go
This is my marked copy, Manoj. Manoj, where we had decided, Manoj, to take some action against the erring colleges. Manoj, we decided to impose penalty of about 3 times the admission fee.
Yes.
As a first time penalty. Second time, Manoj, we would debar them under 16. Now, Manoj, all 3 colleges have been issued with notices. In fact, one of them have also challenged the issue.
So forfeit equal number of seats for next academic year. And if there's a repetition of the same mistake made for the second time, a penalty of derecognition of college and disapproval of the admission would be made. The said submission is also placed on record. The directions which had been issued by this court have been implemented in terms of the website being revamped and the data being available. Compliance with the general directions is complete. We'll close the matter.
And task force as well, Manoj, because then.
Task force we mentioned.
Please, Manoj, if that is approved.
The task force shall keep track of the details on the website,
No, Manoj.
as also any complaints that may be received.
No, Manoj, the task force was constituted only in
Only for
respect
these
of
3
these
colleges.
3 colleges, Manoj.
Not for any
And
violation.
then the task force recommended that this is what we will do in the future. So, Manoj, whatever the task force has suggested, now we're also incorporating it in our regulations, Manoj. So it should not be that.
The submission is that the recommendation of the task force is being included in the regulations. The submission is placed on record. The directions issued by this court from time to time have been complied by the DCI. The petition stands closed. This court places appreciation and thanks to Sri Aditya Bhatt, Learned Counsel for DCI, who has taken pains to see to it that the implementation is done in a proper manner.
I'm ready.
Serial number 10, Rina DA.
Lord.
Yes.
That is pertaining to, my lord, the matter is pertaining to allotment of an industrial site.
Yes.
to the petitioner in the reserved category. But the same site has been allotted without cancellation of his previous allotment
Yes.
to the respondent. And my lord, since the AIDB has not placed any record before your lordship, I have made a synopsis of entire this one, my lord.
Please.
Yeah, my lord, I produced note sheets of the proceedings of both the respondent and the petitioner. My lord, it is in my rejoinder. But here, my lord, I am placing the typed copies of it, my lord. In rejoinder, I have placed it annexure P and S. Annexure P is the, my lord, the proceedings about the allotment of the petitioner. Annexure S is the proceedings about the allotment of respondent number 5.
Yes.
My lord, here I am placing the typed copies.
Okay.
Whereas, my lord, the original.
So this is a convenience set.
Yes. Original copies are there, my lord, in the rejoinder, along with.
Yes, please.
Yes. My lord, may I have to take your lordship, my lord, looking at the decision-making process, my lord. As we're looking at decision-making process, may take some factual, this one, my lord.
Please.
My lord, out of the, my lord, during 2015-16, my lord, acquisition had taken place for the industrial purpose, my lord. 331 acres had been acquired. My lord, out of which, my lord, 22.5% has been reserved to SC/ST category, and that being, my lord, 75 acres. My lord, that is reserved for SC/ST category, and in that reserved category, my lord, the site number 2/69, it is measuring about 3.74 acres. Also, my lord, reserved for SC/ST category because it's part of survey number 95 of Vadakanelli village.
Yes.
My lord, that aspect is clear. And my lord, total extent of land in my lord, that plot is 3.74 acres, whereas granted to me, allotted to me is 2 acres. My lord, no, my lord, on 1119, number 2, my lord, on 119, my lord, a list, my lord, submitted by the subcommittee of district level single window clearance committee, my lord, which is a subcommittee, stating the extent of land. Category wise. My lord, this is
But
a land.
95 is 5 acre category.
Yes.
In which you have been given 2
extent
acres.
available 2 acres ಕೊಡ್ಬೋದು ಅಂತ.
Yes.
My lord, all this is about on 1119, my lord. Whereas
been reserved for SC category is cell number 8, 9 and 10.
ಅಲ್ಲ ಎಲ್ಲ ಇದೆಲ್ಲ SC/ST category.
Only I'll mark ಮಾಡಿರೋದ್ರಲ್ಲಿ 8, 9 and 10 mark.
ಅದು ಯಾಕೆ ಎಲ್ಲಿ my lord, this is because ಇದೆಲ್ಲ ಆವತ್ತಿಗೆ SC/ST ಗೆ ಅವೈಲೇಬಲ್ ಇರುವಂತ out of 75, my lord, out of 75 acres reserved. That was reserved long back in 2016 or so, my lord. Thereafter, after on 1119.
According to you, is this the reserved list?
Yes.
Or is the complete list?
Reserved list, and on 1119, this much is available for allotment, further allotment.
For all category, my lord, this is not only in respect of general. It is
No, this is the SC/ST category, my lord, this is available, it's a recommendation by the subcommittee. My lord, thereafter,
So this is a list you are giving us, Mr. Anand Pujari.
yes,
8, 9 and 10 to be reserved for SC
Yes.
category. There's nothing for ST category, there may be something else. And there's also general category which has been indicated. Survey number 95, sale number 74, it is not marked for or reserved for SC category.
my lord, this is my instruction, my lord, total, this is the available land out of 75 acres.
Available, yes, there's no
Yes.
problem.
My lord,
Reservation for the category, what you said as a second submission,
yes,
that doesn't appear to be borne out by this document, unless you have any other document to indicate that these plots have been reserved for so on.
my lord,
And more importantly, I don't know, you should examine it. Sale number 74 of 95 is not reserved for the category. And it's a 5-acre plot.
that, my lord, according to my submission, that is so, my lord, let them clarify it. If that is so, my lord, let it be then, Lord. But my lord, 95 is reserved, that is survey number 269/1. If you last get it on page number 25, it is very clear. 95 is 269/1.
Page
25 ಅಲ್ಲಿ ಗೊತ್ತಾಗುತ್ತೆ.
25.
ಅಲ್ಲಿ 83, ನೋಟ್ ನಂಬರ್ 83 ಅಂತ ಇದೆ.
83.
ಎಸ್. ನಿವೇಶನ ಸಂಖ್ಯೆ 216/1 ಅನ್ನು ಅಡಕಲಿ ಪ್ರದೇಶದ ಗ್ರಾಮ 95 ರಚಿಸಲಾಗಿದ್ದು. ಸರ್ವೆ ನಂಬರ್ 95 ಅಲ್ಲಿ ಕೊಟ್ಟದ್ದು ಕ್ಲಾರಿಫೈ.
95 ಮತ್ತು 96 ಭಾಗದಲ್ಲಿ ರಚಿಸಲಾಗಿದೆ. ಸದ್ರಿ ಸರ್ವೆ ನಂಬರಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ
that is acquisition.
So and so. ಬೆಂಗಳೂರು ದಿನಾಂಕ so and so. Yes, 28/4. 269-1
ಅದರಲ್ಲಿ ಬಂದಿದೆ ಅಂತ ಹೇಳಿ
95.
Yes, my lord. Your kindly see the seniority list submitted by the committee, my lord. Committee, that subcommittee to the DLS window committee, my lord. You are last to get it, my lord. Page in my rejoinder. Kindly look at, my lord, annexure W.
That is part of this
no,
convenience set.
No. Rejoinder.
Convenience set ella. Rejoinder, yes.
Yes.
Page?
My lord, rejoinder, page of 113 ಅಲ್ಲಿ.
113.
Yes.
Rejoinder is bigger than the petition.
ಅಲ್ಲ, ಅವರು ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಯಾವುದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ, ರೆಕಾರ್ಡ್ ಇಲ್ಲ, ಅದಕ್ಕೆ ನಾನು ನೋಟ್ ಶೀಟ್ ಅನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ವಿ. 113 ಅಲ್ಲಿ this is the proceedings on 2519 by the district level single window committee. Fourth respondent is the party to that. He is a member secretary. Fourth respondent is the, my lord, head in the zonal level.
Yes.
Number 4 is the Abhiruddhi Adhikari. Fourth respondent is head of the department, my lord, in the zonal level. My lord, here page number 118 in the same compilation, my lord. Subject number 3, 12/2/19 ನಡೆದ ಜಿಲ್ಲಾ ಮಟ್ಟದ ಉಪಸಮಿತಿಯ ನಡುವನ್ನು ಅನುಮೋದಿಸುವುದು. 12/2/19 ಜಿಲ್ಲಾ ಮಟ್ಟದ ಸಮಿತಿಯ ನಿರ್ಧಾರವನ್ನು ಮಂಡಿಸಲಾಗುವುದು. ತೀರ್ಮಾನವನ್ನು ಟೇಕನ್ ಮಾಡಿ ಖಾಲಿರುವ ನಿವೇಶನಗಳನ್ನು ಮಾಹಿತಿಯಂತೆ ಆಯ್ಕೆ ಮಾಡಿ ಕೊಡಬೇಕು ಅಂತ ಹೇಳಿ ನಿರ್ಧಾರ ಮಾಡ್ತಾರೆ. My lord, there even respondent number 4 was a party, KDB. Then, my lord, the list of seniority was provided of SC/ST category, my lord. Last, kindly see page number 104 there.
104.
Yes, annexure V. This is a list of seniority, my lord, of SC/ST category. My lord, various extent of land.
Yes. Where is your name?
My lord. My lord, may I request your lordship at 110, my lord. 110. Page number 110, my lord.
Page 110.
Yes, 110. Yes, annexure W here, page number 10. Annexure W, serial number 10. Lord, serial number 10.
Yes.
22, my lord, candidates have been applicants from SC/ST category. This is exclusive SC/ST seniority.
Yes.
22 applicants, kindly look at the other page, my lord, 111. Up to 2022, that was the list during on, my lord, particular meeting, 12/12,
Yes.
12/2. Lord, I am serial number 10, though in that overall category, in two acres category, my lord, I am senior number 1 in the seniority. 2 acres category.
Yes.
My lord, after that, in my writ petition, the committee, single window committee has taken a decision, and my lord, it is communicated to me. It was communicated to me, my lord, at annexure C, my lord, page number 13 in my writ petition. Writ petition. Annexure C, my lord.
Yes.
My lord, it is informed that you have been in the 130th single window meeting held on 2/5/19. You have been allotted industrial plot to the extent of 2 acres in a industrial area for the establishment of the proposed project. Thereafter, my lord, petitioner was informed, my lord. Then petitioner has identified the plot, has submitted his plan and all. And on 19/4, my lord, on 19/4, annexure D. 19/4, annexure D, page number 14, my lord. Initial provisional allotment was made. In my lord 269-1, that is my lord serial number 2 only, the plot number.
Yes.
It was modified subsequently, my lord, as per annexure E, page number 15.
Yes.
Yes, ma'am. This is modification because of the changes, variation in the rebate.
Modification, recalculation.
Of the recalculation, the modification.
Amounts were recalculated.
Yes, rebate rate ಅಲ್ಲಿ variation ಆಯ್ತು ಅದಕ್ಕೆ ಕೊಟ್ಟಿದ್ದಾರೆ. So my lord, this is what my lord I am supposed to pay. My lord, regarding payment, there is no dispute. The last occasion also I submitted. There is no dispute. Of course, there was 13 days delay in paying it. My lord, it was accepted by them and they have executed the receipt. My lord, I have produced the receipt also, my lord, in my this one synopsis. I produced the receipt, my lord, at annexure doc number 4 in my synopsis, my lord.
These are all documents which have already been produced or new documents you have produced?
Already been produced. Typed copy ನಾನು ಕೊಡ್ತಾ ಇದ್ದೀನಿ.
Page?
Page number, my lord, 77. ಇದು ಮಾತ್ರ ಹೊಸ್ತು. This is the receipt for having accepted the money. And in even the note sheets also, they have accepted it, my lord. Payment made, accept ಮಾಡಿದ್ದಾರೆ. ಅವರು time extend ಮಾಡಿದ್ರು. Thereafter I paid it, my lord, with 12 days delay.
Yes.
And my lord, it was accepted. There is no dispute about it, my lord. I can show you to lordship. Then, my lord, after that, my lord, it was processed further. My allotment, provisional allotment, processed further and accepted by my lord for further confirmation. My lord, it has to be confirmed within a time bound limit, my lord. Then they have to execute the lease deed. I produced a circular of the government showing within what day, how they have to proceed further. Also there, my lord, in my rejoinder, I have produced how it should be proceeded further.
Writ to rejoinder synopsis you are making.
ಅಲ್ಲ ಯಾಕಂದ್ರೆ ಅವ್ರು ಏನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ.
ನೀವು ರಿಟ್ ಪಿಟಿಷನ್ ಏನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ ನಮ್ಗೆ ಯಾವತ್ತು ಮೆಲಾಡ್ ಅಲ್ಲ ಅದು ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ
ಆಯ್ತು ರಿಜಾइंडर ಪೇಜ್ ನಂಬರ್
ಅಲ್ಲ My lord, page number 53 ಅಲ್ಲಿ
53.
I am troubling you lots because my lord, they are not producing anything. ಅದಕ್ಕೋಸ್ಕರ ಈ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಾ ಇದೆ. 53 ಇದು ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲಿ ಟೈಮ್ ಲಿಮಿಟ್ ಎಲ್ಲ ಫಿಕ್ಸ್ ಮಾಡಿದ್ದಾರೆ. ಪೇಜ್ ನಂಬರ್ 54 ಅಲ್ಲಿ. This is how it should be proceeded further. Time limit ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ. So after my allotment on 15/5/2019, my lord, this is time limit. Only time limit, they have to do it expeditiously, that's all. Then, my lord, my allotment was further processed on 25/11/2021, my lord. Even the development officer, that is force responder, who is the head in the zonal area, my lord, has accepted the proposal for confirmation. You'll have to get it, my lord, at page number 26 in my synopsis.
Synopsis.
Yes.
Yes.
Note number, my lord, 84, 70, 80 ಇಂದ ಶುರು ಆಗುತ್ತೆ. My lord, it is acceptance of my payment. 16 lakhs ಅಂತ ಹೇಳ್ತಾರೆ. That, my lord, I am supposed to pay only 10% initially. I paid. Then, my lord, 83. ಅದರಿಂದ ಪರಿಶೀಲನೆ ಇದಾಯಿತು. My lord, kindly see 85. ಅದು ಪೇಜ್ ನಂಬರ್ 26. ಮುಂದುವರೆದು ನ್ಯಾಯಾಲಯ ದಾವೆ ಇತರ ತಾಂತ್ರಿಕ ಶಾಖೆ ಯಾವುದೇ ಇದ್ದಲ್ಲಿ ಉಳಿದಂತೆ ಹಂಚಿಕೆ ಇಲಾಖೆಯಲ್ಲಿ ಯಾವುದಾದರೂ ನ್ಯಾಯವ್ಯಾಜ್ಯ ಇದ್ದಲ್ಲಿ ಪರಿಶೀಲಿಸಿ ಹಂಚಿಕೆ ಶಾಖೆಯವರಿಗೆ ಕ್ರಮ ವಹಿಸಬೇಕಾಗುತ್ತೆ. ಅಲಾಟ್ಮೆಂಟ್ ಹಂಚಿಕೆ ಶಾಖೆ ಡಿಫರೆಂಟ್, ಅಲ್ಲಿ ಕಳಿಸ್ತಾರೆ. ದಟ್ ವಾಸ್ ಸಬ್ಮಿಟೆಡ್ ಅಂಡ್ ಮೈ ಲಾರ್ಡ್ ಇಟ್ ವಾಸ್ ಕ್ಲಿಯರ್ಡ್ ಬೈ ದಿ ಮೈ ಲಾರ್ಡ್ ಜೋನಲ್ ಲೆವೆಲ್. ಕೈಲಿ 87 ಖಂಡಿಕೆ 85ರಲ್ಲಿ ತಿಳಿಸುವಂತೆ ಪರಿಶೀಲಿಸಿ ಕ್ರಮ ವಹಿಸುವುದು ಡಿಒ ಡೆವಲಪ್ಮೆಂಟ್ ಆಫೀಸರ್. 85 87 ಪೇಜ್ ನಂಬರ್ 26. This is in the zonal level. Then, my lord, in the same compilation, page number 38.
Yes.
My lord, further it was accepted, approved by the head office. That is respond number 1 in the central office. 135 note. ಅನುಮೋದಿಸಿದೆ ಡಾಕ್ಟರ್ ಶಿವಶಂಕರ್, ಚೀಫ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಆಫೀಸರ್. That is, my lord, page number 38, note number 135.
Yes.
So, my lord, after my provisional allotment, as per annexure E, it was proceeded further, and the highest level of authority has approved my final allotment.
Yes.
But still, my lord, the zonal level, no action has been taken for almost 3 years. So they kept and sat over the matter. Now, my lord, after that, my own site, my plot, without cancellation of my plot, without return of money, my lord, the respondent number 5, who is the general category, he belongs to, with great respect, general category, my lord, had applied for a site in Imau industrial area. His application to Imau industrial area, not about Adakanalli at all. The application also I have produced. Kindly look at, my lord, in my compilation, in the rejoinder, page number 57. He had not applied for this site at all. That's my submission, my lord. Page number 57, man.
Yes.
Yes, kindly come to, my lord, 58. Last, Veerabhadraya Industries, Imau, 2 acres at Imau industrial area, Mysore. Last line, my lord, last box.
Which is your industry area?
My area is, my lord, at Adakanalli.
Adakanalli.
He had not applied. He has applied for, my lord, Imau area in the general category. My lord, least it was executed.
When was the application made?
My lord, application date. Application date. My lord, this is the, in a meeting it was considered. District level, the state level, a single window committee meeting, my lord, not district level. Ali, the application irude IMO.
Yes.
These are all, my lord. Now, pursuant to that, my lord, he was allotted that plot at IMO. He was allotted that plot at IMO, my lord. Kindly come to my lord. Now I am dealing with the proceedings in respect of, my lord, the response number 5. That is annexure yes in the rejoinder, but document number 3 here, my lord. 3 in the synopsis.
You want to take the synopsis or rejoinder?
Synopsis. 95. Page number 66, man.
66.
Yes.
Yes.
ಕಾರ್ಯಪಕ್ಷ ಅಭ್ಯಂತರ ಮೈಸೂರು ದಿನಾಂಕ 6 ವರದಿಯಲ್ಲಿ ವೀರಭದ್ರ ಯೂನಿವರ್ಸಿಟಿ ಮಾಲೀಕರು ವೀರಭದ್ರ ಜಯವರಿಗೆ ಮೈಸೂರು ಇಮ್ಮಾವು ಗ್ರಾಮ ಪ್ರದೇಶದಲ್ಲಿ 2 ಎಕರೆ ಜಮೀನನ್ನು 22 ಹಂಚಿಕೆ ಮಾಡಿ ಪತ್ರ ನೀಡಿ ಹಾಗೂ ದಿನಾಂಕ 11/10 ಸ್ವಾಧೀನ ಪತ್ರ ನೀಡಿ ಹಾಗೂ 11/10 ಗುತ್ತಿಗೆ ನೆರವೇರಿಸಲಾಗಿರುತ್ತದೆ. He was given and, my lord, it was leased, it was executed. Leased, it was executed. My lord, kindly proceed further. My lord, page number 67, there only, my lord. Note number 99. He was not happy with that plot, my lord, for various reasons we do not know. 99. Orally, my lord, he makes a request at 99, my lord, saying that instead of 142 at Imau, he may be given site at, my lord, Adakanhalli. That is plot number 2/69. That is allotted to me.
Yes.
Then, my lord, this allotment was made to him, which is impugned before your lordship. That is on, my lord, 29/2/2024. Allotment was made to him, whereunder my plot was allotted to him, without, my lord, any approval by the state level single window committee, and without there being any application. My lord, under the Industrial Facilitation Act, my lord, the approval from the state single window committee is compulsory. That process is not there. My lord, this section 11, my lord.
Of the Facilitation Act.
Yes, Act. Section 6 in the Start Act. If it is 15 crore and above, my lord, state level.
Yes.
If it is less than that, my lord, district level. My lord, that's the provisions of the Act, my lord. Even otherwise, there is no clearance from even the head office and other things, my lord. And there was no application at all. Only on a demand, my lord, all these things have been done. And that order, my lord, I have challenged before a lot. On the very same day, my lord, kindly look at, my lord, in my writ petition, page number 12. Same day, possession certificate was given.
Yes.
Writ petition, adu rejoinder.
29/2/24.
Yes, 29/2/24 is the allotment on annexure A, at annexure A. And B is, my lord, possession certificate, very same day.
Yes.
My lord, here in the allotment letter, it says he is supposed to make payment within 10 days. Kindly come to my lord, page number, my lord, that is 11. There, he is supposed to make payment within 11 days. I don't know, he might have made, but I don't know. But very same day, my lord, possession certificate is issued. But kindly come to note number 135, my lord, document number 3.
Page.
That is, my lord, document number 3, my lord. Page 67.
Of. More question cover. Page number of.
Of my lord. Of my lord, synopsis. Synopsis.
67.
Yes.
Yes. Yes, 67.
Yes. My lord, now my lord, 72, my lord. 72. After that,
why are you referring to 67, 72?
67 ಅಲ್ಲಿ ನಮ್ದು ಕೇಳಿದ್ದು, ನಮ್ಮ ಜಾಗ ಕೇಳಿದ್ರು. ಅವನು ನಮ್ಮ ಜಾಗ, he has my plot.
67 you took us to note 99.
Yes. ಅದು in that he has already demanded our side.
Yes.
Now my lord, 72. ಅಂದ್ರೆ 135 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ, but page number 71. 135 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ. Now he realized that it was allotted to me, and then he asked my lord another side at page number 72.
Yes.
Asking 2/67.
Yes.
That is what my lord, lordship was talking about compromise. ನಾನು ಕೊಡ್ತೇನೆ ಅಂತ ಹೇಳಿ ಅವರು ಆಫರ್ ಮಾಡಿದ್ರು.
They have offered you 267, you don't want to take it.
Yes. Now this was asked by him earlier. So my lord, he changed his mind, saying that
267 is available.
Not
Industry
available.
is already set up in 269.
Yes.
So
give me 267.
In the interest of continuing both the industries, they have offered you 267, which you are not willing to take.
Adhaudu. But ಇಲ್ಲಿ ಅವರು, he has changed his mind. He asked for, yes.
The question is whether you want 267 or not. You don't want.
My lord, that is because my lord, ಅವರಿಗೆ ಅದು suitability ಬಗ್ಗೆ, that's the issue.
Yes.
Then my lord, once again,
Mr. Pujari, you have to remember that there is already an industry in 269 established.
Established ಅಂದ್ರೆ 6.22 square meters ಅಲ್ಲಿ ಲಾರ್ಜ್ ಏರಿಯಾದಲ್ಲಿ 1.5 acre ಅಲ್ಲಿ ಕೇವಲ 1,000 square meter ಅಲ್ಲಿ ಮಾತ್ರ ಮಾಡಿದ್ದಾರೆ ಒಂದು ಶೆಡ್.
At the most we can direct them to consider your application and give you a allotment in a seniority.
ಹಾಗಲ್ಲ.
ಅದಕ್ಕೆ ಬದಲು they are ready to give you 267, which you are not acceptable.
ಅಲ್ಲ ಹಾಗಲ್ಲ. My lord, that is not.
We can't demolish a industry which is already.
Demolish ಅಂದ್ರೆ ಒಂದು ಪೋರ್ಷನ್ ಕಟ್ಟಿದೆ, ಅದು ಹೇಳ್ತೀನಿ. ಒಂದೇ ಪೋರ್ಷನ್, ಸ್ಮಾಲ್ ಪೋರ್ಷನ್ ಕಟ್ಟಿದೆ.
ಅದು ಅವ್ರು ಕಂಟಿನ್ಯೂ ಆಗ್ಲಿ.
ಕಂಟಿನ್ಯೂ ಅಂದ್ರೆ ಹೇಗಂದ್ರೆ ಅದು ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ವಾಸ್ ದೇರ್.
I complete ಮಾಡಿ.
But now my lord, serial number, there are once again page number 73 ಅಲ್ಲಿ. My site was numbered as 269A.
Yes.
ಅವರಿಗೆ ಕರಾರು ಪತ್ರಕ್ಕೆ ಹೋಗ್ತದೆ. ಕರಾರು ಪತ್ರ ಮಾಡಬೇಕು ಅಂತ ಪುಟ್ ಅಪ್ ಮಾಡ್ತಾರೆ ಅಸಿಸ್ಟೆಂಟ್. Then my lord, without any, my lord, it was proceeds further. Kindly look at my lord 74. 146. So till 15/3/24, my lord, till 15/3/24, it was under consideration only.
They had paid 1,22,77,574.
Correct. Avardu, my lord, what happened? Allotment, provisional allotment kottaddu, my lord, prior to that. That is, my lord, much prior to that. But he demanded later on. He changed his mind so many times, and then my lord, once again, idu kodo bagge, it was under consideration on 15/3/24. My lord, but ಅಲಾಟ್ಮೆಂಟ್ ಅವರಿಗೆ ಕೊಟ್ಟಿರುವಂತದ್ದು 29 to 24, much before that. Andre it was under consideration still.
Yes.
By the zonal office and all, and approval of my lord the chairman of state level single window committee is compulsory. That is industrial minister, my lord. That has not been done at all. Despite that, my lord, lease deed was executed.
Yes.
So, my lord, first of all, there was no application.
How many times will you repeat it?
Secondly,
Please
my
complete
lord,
your argument.
Secondly, my lord, there is no approval by the authorities as required under law. And my lord, the site allotted to my lord, a SCS ticket reserved for SCS category, my lord, has been allotted to a general category. It's not permissible.
Yes.
It is not permissible. It's my submission, my lord. So, my lord, the contention now they are taking, my lord, there is no lands are not available in the SCST category. That's
That,
all.
no, they have said they are going to give you 267.
Adalla. Why they are giving it to me? Because the contention in legal contention taken is that, my lord, in the SCST category, 75 acres has been exhausted.
Irrespective of that, they are willing to give you 267. Is what the submission has been made.
How the compromise ಬಗ್ಗೆ? That is about
Compromise alla.
doing a favor, my lord.
It is your
My lord, now I am on merit. I am on.
See, unfortunately, since you have taken a stand that you don't want 267, even in our order, we cannot say give you 267.
My lord, what I am saying, you know, their
Condition of your submission, please understand.
Lord, I am only submitting, my lord.
You are entitled to.
Yes.
You are not saying
I
no,
am not,
but
my
please
lord,
understand the implication.
I am not, my lord. I am not saying. I have, in fact, my lord, their submission is legally that in the SCST category land is exhausted, so that it cannot be granted to you, so that it will be granted.
Why are you arguing that when they are saying they are going to give you to?
Record ತಂದು ಕೊಟ್ರೆ ಎಲ್ಲ easy ಆಗುತ್ತೆ.
When you file this convenience set, you could have included everything in it. Instead of again producing new documents in that and asking us to do.
Certainly, my lord.
Yes, 104 ಹೇಳಿ.
Yes, 104. ಇದರಲ್ಲಿ, my lord, seal number 33. ಇದು, my lord, right from 1 to kindly see 101. That is page number 109. ಅಲ್ಲಿವರೆಗೆ allotment made.
Under the SC category.
SC category.
SC, ST, SCW.
Yes, yes.
Yes.
But kindly see the last page, 109 ಅಲ್ಲಿ, last allotment was on 16/5/24 in SSC category.
Yes.
But one essence in India was allotted land in the year 2024. But whereas to me it was denied, saying that 6.65 acres. Kindly see, my lord, this last column.
Yes.
66.65 acres ಮಾತ್ರ exhaust ಆಗಿದೆ as of during 2004 ಅಲ್ಲಿ.
Yes.
ಮಾರ್ಚ್ಗೆ. ಅಂದ್ರೆ still 9 acres. SC category ಎಸೆನ್ಸ್ ಇಂಡಿಯಾಗೆ ಅಲಾಟ್ ಮಾಡಿದ್ದಾರೆ. ಆಮೇಲೆ 89 ಸೀರಿಯಲ್ ನಂಬರ್ 89 ಅಲ್ಲಿ on 30/10/21 serial number 87 ಅಲ್ಲೇ
Hmm.
one RR enterprises ಗೆ allot ಮಾಡಿದ್ದಾರೆ. These two allotments are subsequent to my allotment. But if the lands are not available, there's no question of my lord there. Now I am not on his allotment. Question is why they are not allotted land to me? ನನ್ನ ನಂತರ ಇಬ್ಬರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
Here we don't know what to tell you. You are a senior counsel.
Yes, ma'am.
You have repeated it thrice.
Yes, ma'am.
They have said they are going to give you 267. They are going to allot ಅಂತ ಹೇಳಿದ್ದಾರೆ. After that also you are saying no land, they are not wanting to allot.
ಅಲ್ಲ,
If
ಅದು-
you keep on arguing that,
ಅಲ್ಲ ಅದು ಬೇರೆ.
when so many people are waiting, what is this argument?
ಅಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಲ್ಲ ನೋಡಿ. ಈಗ the contention taken in statement of objection is
Irrespective of that, the learned senior counsel has said they'll give you 2 acres.
that is
You
as
don't
a-
want that.
as a settlement formula, my lord. They are
Not
subject.
a settlement. What is a settlement? You are getting your 2 acres. You want your 2 acres, they are giving you 2 acres. Ashte. They are not asking you to reduce it. They are not giving you extra. Nothing is there. But we are unable to understand your arguments.
ಅಲ್ಲ argument
For the
ಅದಲ್ಲ,
simple
ಅದು-
reason, you are saying it is not there, they are not allotting, you want the allotment. But when they say they are going to allot, you don't want to accept.
My site was 269, my lord. My site was
We
269.
understood that.
Yes.
That much we understood.
ಅದು
You want only 269 by demolishing the
But
existing industry.
it is
That we have understood.
suitability ಎಲ್ಲ ನಮ್ಗೆ ಬಂದಿರುವಂತದ್ದು. My instruction that my client wanted the same thing, my lord. What I cannot, my lord, alter is this one, my lord. That's why I tried my best. Really tried my best, my lord. I am that way. Now, my lord, the allotments are made
We
subsequent.
don't want to say anything to that. If we say anything, you may feel bad about it.
I will not feel bad.
ಕೇಳಿ.
I will not feel bad.
Your client wants it ಅಂದ್ರೆ
Clients ಅಂದ್ರೆ
by
my-
demolishing and you are arguing that.
No, my lord. Clients ಅಂದ್ರೆ my instruction council's client.
ಆಯ್ತು ಹೇಳಿ.
So subsequently also, my lord, allotments are made in SC/ST category. And that apart, 3-4 categories ಅಲ್ಲಿ 3-4 allotments ಇದರಲ್ಲೇ ಕ್ಯಾನ್ಸಲ್ ಆಗಿದೆ. ಅದು ಕೂಡ ಜಾಗ ಇತ್ತು.
ಅದು ಕೊಡ್ಸೋಣ ನಿಮ್ಗೆ? Whichever is
ಅದು
cancelled, can you want
ಕ್ಯಾನ್ಸಲ್
that?
ಆಗಿದೆ, ಜಾಗ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
You want that?
ಅಲ್ಲ ಅದು that is about the.
Then why are you arguing this? Why are you wasting the time of the court and so many lawyers? Please, have some.
Yes, my lord. Then my lord, submission is that.
You don't want anything, but you are arguing that.
ಹಾಗಲ್ಲ, ನಮ್ಮ ಸೈಟ್ ನಮ್ಗೆ ಕೊಡ್ಬೇಕು.
ಹೌದು, ನಿಮ್ಮ ಸೈಟ್.
ನಮ್ಮ ಸೈಟ್ ಪ್ರೊವಿಷನಲ್ ಅಲಾಟ್ಮೆಂಟ್ ಆಗಿದೆ, ಆಮೇಲೆ ಫೈನಲ್ ಕನ್ಫರ್ಮೇಶನ್ಗೂ ಹೋಗಿದೆ, ಹೈಯೆಸ್ಟ್ ಲೆವೆಲ್ ಅಲ್ಲೂ ಕನ್ಫರ್ಮ್ ಆಗಿದೆ, ನೋ ಫರ್ದರ್ ಆಕ್ಷನ್ ವಾಸ್ ಟೇಕನ್ ಅಂಡ್ ಮೈ ಕೆಟಗರಿ ವಿದೌಟ್ ಕ್ಯಾನ್ಸಲಿಂಗ್ ಮೈ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes.
It is a general category. It is
Anything
not
else?
permissible.
Anything else?
That is my contention.
Without repeating, if there's anything else, please make your submission.
No, it's actually.
Now you don't create more problem. Let him.
Lord, if I am not, Lordship, I will not go to that availability, otherwise, now, my lord, my submission this, my lord. Once the land is
Allotted to you.
allotted to me
You
in
want
SCS
only that.
SCS category.
So
my lord,
restrict your
that-
argument.
Yes, there is no other, my lord, it was in the highest level, the component of that accepted it, my lord. Without giving me the lease deed, it has been allotted to a general category, my lord, without application and without approval of the competent authority. My lord, if your lordship saying that other aspect, my lord, I am not on that.
Yes.
No, the matter is covered by judgment. Same issue that once payments are not made on time, the cancellation is deemed. I'll just pass on my allotment letter. My lords, the
Come to you much later. Let KDB address.
please.
To the answer to my learned friend, my land is a landowner's land which we have acquired and we're seeking to make allotment. But his right comes, my lord, regulations 8 and 10 are relevant, my lord.
Regulation,
8 of 1969 regulations, my lord.
site allotment regulations.
Please, my lord.
KD Act. Adralli, the regulations.
Code of. There are two things, my lord. The Facilitation Act is there is the KDB Act. Under the KDB Act speaks about allotment of plots, my lords.
Yes.
And the Facilitation Act provides for approval of projects. So, my lord, the approval of project cannot be confused with allotment regulations, my lord. There only the project is approved. There is no allotment of land. So, for example, my lord,
It's only a nodal agency.
it's a nodal agency. If somebody wants concession, various things, my lord, it goes to the single window and eye level, and so that the project is
water,
approved.
all
So
those
therefore, my lord, what my learned friend saying that a project has, allotment is made under the Facilitation Act, single window, state level, district level, that doesn't apply at all. The facts of, in this case, what applies is the allotment rules, my lord, 1969 rules.
Yes.
I stand corrected, regulations. The procedure is, my lords, first 7 applications filed. In this case, my lords, they were allotted land, lease cum sale deed was executed in favor of fifth respondent. There was litigation in the property. In lieu of that litigation, this land is given to them. Because insofar as the fifth respondent is concerned. I'll come to the applicant, why it was cancelled. So therefore, to say that there was no application, there was no allotment, in fact, a lease cum sale was already there in favor of the fifth respondent. No, my lords, insofar as the right of the petitioner herein is concerned, there is no allotment letter at all. What is there is only a demand notice and non-compliance of the demand notice. What is the effect of non-demand compliance of demand? Automatic cancellation. That is as per Annexure D, Annexure G, page 17. It says that unless the allotment is of the year, my lord, demand is of the year April 2021. Amount time is extended till 9th September 2021. Amount is not paid. So therefore, by virtue of this communication at Annexure G, is deemed to be cancelled. So there is no allotment letter, there is no lease cum, there is no right vested in the applicant.
Is this plot in survey number 9567 reserved for scheduled caste?
Well, the plot, usually what happens in a layout, certain percentage of sites are allotted for, not site-wise, percentage of the.
In the statement that has been produced,
22.68% of any developed.
at Annexure E.
Annexure E, my lords.
Not Annexure E. Annexure E is there, this one.
Which one? Convenient compilation, my lord.
In the.
Which is 22.68%. L is there.
Page 10 of the convenience set.
Correct, my lord. Page 10.
According to Mr. Pujari, all these plots which are mentioned in this annexure
Please, my
have been
lords.
reserved for scheduled caste and scheduled tribe.
Only 3 in this, my lord. Your lordship may kindly see. On the right hand side, plot number 8, 9 and 10, my lords.
Yes.
It shows scheduled caste. All others are general category, my lords. And in a layout, my lord, as per the policy, 22.68% in any layout has to be reserved. The question in this case, I'm instructed, my lord.
His submission is that this particular plot
No, there's no such.
is reserved for scheduled caste.
No.
It could not have been
No,
allotted
that's
for
not correct, my
general
lord.
category. It should be only
That's
allotted.
not correct. And our case is over and above 22.68 of the whole project has been given. Therefore, this could not, over and above that could not have been reserved for under scheduled caste or scheduled tribe.
That is.
No, I'm trying to make out a case on.
Now you are also arguing the same thing as he said.
No, my lord, the question.
Now you.
No,
can't
this I'll
argue
put it. Well, it's not allotted.
with that once you say you are going to give him a plot, that is gone.
So there. Okay, I'll leave it at that. Man. Let's not.
That only 3 things are there now. One is that this plot is reserved for scheduled caste.
No, man.
And cannot be allotted general category, number
Please.
1. 2 is respondent number 5 had not made any application for allotment. Therefore, allotment could not have been made in his favor. 3, that allotment has to be approved by the SLSWC or DLS. No, this is SLS because it's more than 50 crores. Without that approval, you can't allot.
I
These are
answered
the basic 3.
So therefore, my lord, the question, first point is with regard to, he has filed an application, lease cum sale deed was there. Because there was litigation, it's an alternative allotment. So that
What document have you produced?
That is, my lord, the lordships will get it in convenient compilation, page number 64. It clearly says, my lord, that it is an alternative allotment. Page 60, convenient compilation.
You have a separate convenience.
No, my learned friend's convenient compilation.
Our 64.
63, my lord.
63. Yes.
Note number 83 at 60, page 63 starts at 63. At 64, my lord, the allotment was cancelled. Therefore, at 64 it says that, my lord, once lease cum sale date was 17/10/2023, there was litigation in that regard, my lord. So therefore,
ವ್ಯಕ್ತಿಗಳು ಒಂದು ಗಲಾಟೆ ಮಾಡಿ ಯಾವುದೇ ಅಭಿವೃದ್ಧಿ. Yes.
and second point, my lord, Facilitation Act and allotment rules and regulations are totally different. So the second point also answers your lordship. And so far as first point, there is no material to show a plot. There is no policy to reserve a plot, nor has this plot been reserved for a scheduled caste or a scheduled tribe. This demand notice was issued for this plot, I should admit, not thing. Therefore, he not complying, automatically rights ceases to exist. That's all.
That you rely on. Kamala.
Kamala is, my lord, there was, in fact, I had appeared in that matter, my lord. The case of allotment, that is clause 6 of the allotment letter was in issue. Here, in this case, there is no allotment letter, my lord. The lordship may kindly see condition number, if I'm correct. No, in this case, that's a far, but in this, my lords, it was allotment letter was given, violation of the conditions of allotment letter, my lords. Here, there's no allotment at all. Your lordships will get it at the issue that arose over there is whether you have to resume under 34B or automatic cancellation. Court says that even in a case of allotment, if you do not comply, it's automatic cancellation. Here, this is pre-allotment, even worse. My lord,
Yes.
there is, on fact, there is no allotment letter, my lord, because Form 1, along with the regulation, speaks about procedure for allotment letter is draft is there. Form 3, lease cum sale deed is there. There is no such document on record. Even though the word may be said allotted, it is only a demand notice. So therefore, my lord, as per regulations 5 and regulation 10, there is no allotment letter. In Form 1 and Form 3, there is neither allotment or lease. So there is no vested right in favor of the petitioner herein. In fact, my lord, in the other Kamala judgment, my lord, they had a allotment letter. So therefore, my lord, in this case, there is no allotment letter. Your lordship may kindly see Form 1, my lords.
Form 1 of the regulations.
Please, my lords. This allotment letter. Form 1 is application, my lords. Then Form 3. Before that, can your lordship may kindly regulation 10, my lords?
Yes.
The board, on being satisfied that the person, firm or company has made an application likely to start production within a reasonable period and not is one declared its objection, the board may constitute subcommittees so and so for considering allotment of the plots and to delegate the power to the executive member.
Yes.
Your lordship may kindly see the.
So without SLSWC, you can do the allotment.
No, here the 10B says the may constitute a subcommittee and delegate its power to the executive member if necessary. Your lordship may see Annexure D is given by the assistant secretary of the office. So therefore, my lords, clause C also of 10, regulation 10, the executive member shall notify such application from whom that allotment is made to the to execute the agreement in Form 3, 4 and 5 as the case may be with such modification. So under this form, my lord, there should be an agreement. There is no such thing in this case. So there is a question of no allotment. So therefore, reading Annexure D, which my learned friends says D and E, which he says it's an allotment under regulation 10 is not correct because it should be under Form 3, 4 or 5, my lord. And second thing, my lord, it's only a demand amount, demand for deposit under regulation 8.
No allotment made.
No allotment has sought to be made. Therefore, on all three counts, my lords, to say my plot does not arise, my lords.
I just pass on my allotment letter, my lords. Which has not been, it's not been produced. That is only a demand note similar to what has been produced on behalf of the petitioners. In this, my lords, at Annexure A and Annexure D, the demand notes have been produced for both parties. Whereas what I am producing is the allotment letter issued in my favor. In every allotment letter, my lords, kindly see condition number 4A. This condition is stipulated in case of your failure to pay the amount mentioned in para 3A2 before the expiry of the time stipulated, then this offer of allotment stands automatically cancelled. This is the finding in that judgment, my lords.
Yes.
That when there is an allotment, if you don't comply with the conditions, there is
When there is no condition.
There
how
is
do you-
no.
If there is no condition of allotment.
If there was allotment, there would have been a condition. There is no
No
allotment.
allotment, so this condition cannot apply.
So even in the compilation at Annexure G, they say that steps to cancel will be taken if you don't pay within the stipulated period. No, the extensions will be granted.
Shri Tarnath Pujari, learned senior counsel for the petitioner. Shri Shashikaran Shetty, learned senior counsel for
Respondent.
respond number
135, 134.
1,
3, 4.
3,
And 4.
4. Shri Anup Arnalli, learned counsel for respond number 5, learned AGA for respond number 2, reserved.
It would have been better if they say that SC/ST has enough reserve agile until they should state on, my lord, at least on both, my lord, oral, they say it's not.
The document that you have produced itself does not indicate that it is reserved. Only allotment which has been made is for 3 of the plots in that list that you are given.
My lord, actually, it is reserved.
No.
Yes.
Let them, my lord, they have to
It
state on.
is for
both.
you to have produced that.
Secondly, my lord, payments acknowledged agide. All payments are acknowledged. Lord, I have produced documents also.
One request.
Payment is acknowledged and reservation is done, my lord. All last we call for records and we will look into it.
Not necessary.
Records are there. This is reserved for SC/ST category.
The, yes.
My lords, one request, my lords.
Hmm?
May be permitted to operate, my lords. Will not interfere with my operations. The factory is closed down because of their interference.
No.
Wait for some more days, that's all.
Please.
May make one serial number 4 p.m. tender matter, my lord. Rashid may have it next week if I may request, my lords. That,
Which tender matter?
That is
The tender call for
BMRCL. So they let the interim order continue.
Till number 12.
They are entitled to extend it, right?
Huh?
Where is Mr.
My love friend is here only, my lord.
Mr. Kamath is also.
No, I appear for.
Kamath is disabled now.
The instructions are here, my lord.
So therefore, your lordship, may I have it next week? Permit us to extend that tender period also, my lord, and it can be.
Of course, tender has to
Sir,
be
appearing
kept alive,
for-
otherwise the writ petition becomes infructuous. We want to take 2-3 hearings.
Which you filed today, morning.
Let it be tagged
We
along.
will tag it.
34818.
Only 2 petitions. You're lucky, only 2.
As of now, my lord.
Finish it before.
That's what.
11th,
Well,
would it be on 11th or 12th, my lords?
Please, my lord.
9
11th or 11th.
11th we can have.
11th, please.
12th, no.
We'll finish the pleadings.
12, connect WP number so and so, end of the list matter. What is the number?
34818. 25.
ಒಂದೇನ ಇರೋದು ಇನ್ನ ಯಾವ್ದಾರು ಇದೆಯಾ ಅದು ಮಾತ್ರ ಕನೆಕ್ಟ್ ಮಾಡಿ ಕನೆಕ್ಟ್ ವಿತ್ ಸೋ ಅಂಡ್ ಸೋ at the request of the learned advocate general relist on 11th at 4 p.m.
4 p.m.
You have received your instructions.
Interim arrangement may continue, my lords, your lordships.
They permit us to extend the.
That of course, that is there. If it is
Interim
continued,
arrangement shall continue until the next date.
lordships.
Serial number 11, Sagar B.
Lordship
Shastri.
may kindly issue notice and serve a copy on the.
ಅದರಲ್ಲಿ ಕೊಡಿ ಅದು
Because
ಶಿವತ್ ಸಾವಿರ list 4 sale number 1 IA 1 of 25 is allowed. Sri Mahesh Arkalgud accepts notice for respond number 1, Ms. Swati Panduranga for respond number 2.
Sir, in this case, I appear.
Why NHA? Why
Because
not
there is a
NHA?
restriction on the advertisements by the NHAL under the National Highways Authorities Act.
Sri Shanti Bhushan for respond number 2. NHA, yeah, who has appeared. The NHA is not a party in that matter. Ms. Shilpa Shah for respond number 3. Shri BL Sanjeev for respond number 4. Counsel for the petitioner to furnish 2 sets of the petition along with annexes on the said petition. Connect with WP number 32551 of 2025 and released on 11th at 4 p.m.
Please.
Sagar V. Shastri.
Serial number 11.1, 11.2, 11.4, my lord. I have filed the statement of objections. Insofar as 11.3 is concerned, my lord, since the prayers are similar to the other, I'll just file a memo adopting the statement of objections.
Statement of objections have been filed by the learned AGA.
In which are we filing amendment?
In WP 29656 of 2024, 16251 of 23, 19980 of 23, and 33767 of 2025. Learned Additional Advocate General submit that the said objections may be treated as objections in WP number 29690 of 2025, and a memo in that regard has been filed. The said objections are treated as objections.
11.4 objections may be treated as objections in 11.3.
In 11.4, not all the others.
No, my lord, I have filed SOB in all matters now, my lord, except 11.3, my lord.
So
My request is
11.4 you want to be treated.
adopt it for the 11.3. I'm filing a memo.
Learned AGA submit the statement of objection filed in WP number 33767 of 2025 may be treated as objection in WP 29690 of 2025. Accepting a submission, it is so treated.
Only thing is, my lord, ಇನ್ನೊಂದು petition ಏನು objection ಹಾಕಿದ್ರು ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. I am not,
Copy,
I don't
yes,
appear
sir.
there.
Copy you have to give it to Mr.
Where
Vijay.
87 petitioners, my lord.
No, no, I am not there.
That is, I appeal.
I think Mr. Manmohan is appearing.
In which one? In which one? No, no, in which one?
There's one difficulty, Lord. I mean,
all right.
I'll go on with the
We'll
matter.
serve, serve.
They have not, yesterday served not the objections. The objections contains an order that is passed not on 17th of October 2025. The order was never given to us. It is given to us yesterday. Now that order is passed, Lord, after, Lord, in fact, not for kindly, Lord, recollect, I had commenced arguments several, Lord, at 2 hearings before. The order was not given to us. Even it was not even communicated to us. But I'll formally.
What do you want?
No, I'll go on with the arguments. I would request not the leave, not I'll file an application to challenge that as well.
So challenge it, then only we can take it up, because then pleadings have to be completed on your challenge.
No, because not it'll fall, not it is based on the 1920 notification.
Now
which is
Mr.
challenged.
Vijay wants his objections. So it has to be adjourned. You file your
Look,
application.
may I make one submission? Now, the primary, the main prayer today, my lord, is that the 5th of February 1920 notification, which has been issued under section 4, is deemed to have lapsed and abandoned. If that prayer is allowed, then all the proceedings of the FSO also falls to the ground.
Very well.
So now, my lord, this, the forest.
What about Mr. Vijay?
No, my lord, there also, similar prayer, my lord.
Then very
So
well.
that is the actual question that now falls for consideration.
Very well. Then
my
but
lord.
I'm grateful if that submission
If-
is recorded. If this writ petition is
Correct.
allowed, that is allowed, then Lord, I have no difficulty.
Yes.
Because Lord, the entire thing is based on that, but it should not be.
Writ petition.
Lord, they have,
In which writ petition is that prayer sought for?
but is challenged in all.
All
Lord,
the- in all the petitions.
prayers, in all the writ petitions.
Could
It
be
is
a
in
prayer
writ
then.
petitions where Lord, I am appearing. Give me the list. Because tomorrow, Lord, they should not say it is not challenged.
We'll record his submission.
But in 11.1,
Once the additional advocate general is submitted, he
Yes,
won't
that is
say
all.
that. Nobody will say that. We'll
Very
record the submission.
To the extent that is applicable to the petitioners.
Obviously.
please.
Nobody else is before us. So your submission is that 26/7/22.
Lord, what is now the prayer, my lord, if my lord sees
Lord.
the prayer, there is only one notification issued under section 4, my lord. That is on 5th of February 1920, my lord.
So 9/11/23, if it is quashed, your proclamation.
Look, they are all
Not
based
only
on
that-
the 5th of, that is based on the section 4 notification itself. And the FSO's order, which,
Your contention is 5 to 1920.
Please.
yes,
Is quashed, nothing else survives.
because the FSO Forest Settlement Officer, my lord, has initiated proceedings based
Well,
on
I am
the,
grateful. Not difficult.
ಏನಪ್ಪ ಕಾಪಿ ಬೇಕಾ ವಿಜಯ್?
ಜಿ ಮಾಡಿ ಮುಗಿಸೋಣ ಬಿಡಿ.
ಬೇಕಾಗಿಲ್ಲ.
ಮಾಡಿ ಮುಗಿಸೋಣ.
ಕಾಪಿ ಬೇಕು ಅಂದ್ರೆ ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಬೇಕು. Submission of learned additional advocate general is that the entire matter hinges upon the notification, challenge to the notification dated 5 to 1920, which has been challenged in all the above petitions. And as such, any other consequent order which has been passed does not require challenge for now, inasmuch as it is only if the notification dated 5 to 1920 is held to be valid, then the question of such challenge would arise.
and their appeal remedy now lies to Kate in the event.
And in that event, he submits that the subsequent orders would have to be challenged before the Karnataka Appellate Tribunal and not before this court, since the alternative efficacy remedy is available. His submission is placed on record.
In the event, Lord, we don't succeed, that appeal will come. That is what. In the event, Lord, 1920 notification is not set aside.
Yes.
We will reserve liberty to you to go to.
I hope it doesn't come to that.
We don't know.
Lord,
So which matter do you want us to take?
Lord, it is WP 16251.
11.1.
11.1.
No, ಇದೆ 16251. Notes is it? Notes.
Comparative chart.
Yes.
But I've made a comparative chart between few of the provisions of the 1920 regulations and the Karnataka Forest Act.
Give us that.
Where's the chart? But I'll just take my lots to the very short. Okay, that's why I made a chart. Lord, I'm sorry, I'll pass on my copy itself. I'll give you airdrop.
Yes.
Not this chart depicts relevant provisions of the Forest Act and the Mysore Forest Regulations. Between the two, this difference between the two is when is issued under the Karnataka Forest Act, but there is a decision made that it should be declared as a forest. But insofar as the Mysore Forest Regulation is concerned, there is only a proposal. There is no decision. But please permit me to take notes to the first section, section 3.
Yes.
Section 3, the state government may constitute any land which is the property of the government or over which the government has proprietary rights, or to the whole or any part of the forest produce of which the government is entitled, a reserved forest in the manner hereinafter provided. But please now turn to section 3 of the regulations. Any land at the disposal of the government may be constituted a state forest in the manner hereinafter provided. Now, my lords, the next section 4 becomes very important. But I'll first take my lords to section 4 under the regulations. Section 4, whenever it is proposed to constitute any land a state forest, the state government shall publish in the notification in the official gazette, specifying as nearly as possible the situation limits of such land, declaring that it's proposed to constitute such land as state forest. It is only a proposal. Now, let's please turn to section 4 of the 1963 Act. Whenever it has been decided to constitute any land a reserved forest, the state government shall issue a notification declaring that it has been decided to constitute such land as reserve forest. Therefore, there is a sea of difference between the two provisions. Specifying as nearly as possible situation limits of such land. Then let's skip the rest of it. There's not much of difference. Then please turn to section 5. Section 5 not under the,
Now, the distinction when we come to C goes
Please.
away because the process after the submission of the publication of notification,
please,
either as proposed or decided,
please,
is to be followed by action under clause C.
True.
So that action is the forest settlement officer determining
Yes.
the rights
Yes.
of the parties.
Yes.
So irrespective of decided or proposed, the net effect is more or less the same.
No, my lord, it is not. I'll take note section 6. Because my lord, the language under section 6 says, once a proclamation is issued not under section 5, then my lord, there is a bar for accrual of rights, etc. Whereas under section 6 of the 1963 Act, moment section 4 notification is issued, then there is an absolute bar. Now, please permit me to
Then
not.
let us see all the provisions then. See.
Very well. Now, should I read clause C as well?
Not necessary. It's
Very
more or less in perimeter.
Please. Note section 5. Let's code copy. When a notification has been issued under section 4, the forest settlement officer shall publish in Kannada and in any other regional language of the area at the headquarters of each taluk in which any portion of the land comprised in such notification is situate, and in every town and village in the neighborhood of such land, a proclamation specified nearly as possible, but in setting forth, then B says setting forth the substance of the provision section 6 and consequences as hereinafter provided will ensue on such forests being constituted reserved forest. Not insofar as the regulation, not the only changes, it says not in canneries it will be published, and not bottom C, it will be considered as a state forest. Now let's please turn to section 6.
Yes.
Not section 6 under the 1963 Act says, after the issue of a notification under section 4, no right shall be acquired in or over the land comprised in such notification except by succession or by grant or contract in writing, etc., etc. But I'll skip that. Now please turn to the right hand side. During the interval between publication of such proclamation and the date fixed by the notification declaring the forest to be a state forest, as hereinafter provided, no right shall be acquired. So, not the language is proclamation is issued only under section 5.
Yes.
Whereas the 1963 Act refers to section 4 notification itself.
It traces back to 4.
Yes, Lord. This does not trace back to
The
4.
goalpost shifts to 5
Yes, Lord.
in the 1920 regulations.
Yes, Lord.
Goalpost was at 5.
Please.
In 63, it shifts to 4.
Yes. Therefore, my lord, there is a sea of difference. That is why, my lord, the language used in section 4 is a proposal. Whereas in section 4 of 1960,
Decided.
it's decided. But there's a sea of difference between the two.
Yes.
Now, my lords, can I request the court to now turn to Lord section 23 of not the Act, but I have not extracted it there. But can I request the court to kindly take not the Karnataka Forest Act?
Yes.
Lords, on the last occasion I pointed out, Lord, section 4, 5, 7, inquiry, Lord, how it is to be conducted, and an extinction of right not under section 9.
64A, 117.
Please. But I think I skipped not section 23 on the last occasion. Not can I request the court to please have a look at it. Any forest which has been notified as a state forest under the Mysore Forest Act 1900.
Mysore, Karnataka Forest Act 1900.
Illa, Mysore Forest.
Our book says Karnataka. Karnataka was not there anyway, so it has to be Mysore.
Along with IA.
There's a mistake in our book.
Idrili Karnataka antide. Soft copy says not Mysore Forest Act.
This publication.
I think
has
it's both the same. Because
can't
both are
be
1900.
It can't be Karnataka Forest Act.
How it has to be Mysore. It has to be Mysore.
Yes, go ahead.
But any forest which has been notified as a state forest under Mysore Forest Act or as a reserved forest act under the Indian Forest Act 1927, Madras Forest Act 1882, or Hyderabad Forest Act 1355, prior to the date on which
Hyderabad Forest Act 1355.
Hyderabad Forest Act.
There's another mistake there. These publications are a problem.
Maybe Hyderabad Karnataka region.
Must be 1855. Typesetting ಅಲ್ಲಿ 1355 ಆಗಿಲ್ಲ.
Maybe 1355 F1 ಹಾಕಿದ್ದಾರೆ.
1355, no possibility.
No possibility.
There's no Hyderabad then. Yes.
Prior to the date on which this act comes into force shall be reserved forest under this act, provided that if the rights of private persons to or over any land or forest produce in such forest shall not have been inquired into, settled and recorded in a manner which the state government deems sufficient, the same shall be inquired into, settled, recorded in a manner provided by this act, and until such inquiry, settlement and record has been completed, operation of this section shall not abridge or affect such rights. So, my lord, what is then, my lord, all questions decided, orders issued, and records prepared in connection with the constitution such state forest as a state forest or reserved forest shall be deemed to have been decided, issued, and prepared under this act, and provisions of this act relating to reserved forest shall apply to forests to which provisions of subsection 1 are applicable. Therefore, my lord, where it is notified and settled, then only, my lord, it is saved.
Notified,
Admittedly,
inquired into, settled and recorded.
yes. Now, my lord, admittedly here, it has not been done because they have initiated not, or the proclamation has been issued in 2023 after lapse of more than 103 years. 1920 is a notification. According to us, not that notification was dropped.
Mr. Manan, what is your contention that because it has not been done, your rights are preserved, or that until that process is done, you cannot be interfered with, or that after 103 years, it cannot be done?
But my first submission is 1920 notification was dropped.
Dropping is
Yes.
an order passed. or
Yes,
is
there is an
deemed?
order. There is an order passed, not in 1924 also, which I took my lords on the last occasion. Where, my lord, I'll just take my lords, Lord, just show that as well, because I took the court through various proceedings, my lord. I produced the report of the assistant commissioner.
Where is that order?
Please.
Of dropping?
Wait a minute, I'll just show the court. Not page 84 of the petition.
'84.
Please. What did the typed copy is at page 85.
Yes.
But 85, not the type copy. 271, Murkan Gudda Forest Block directs that the proposal to constitute certain lands in Manjarbad Taluk into a state forest under the name of dash be dropped to the conservator of forest with records, Revenue Commissioner, Deputy Hassan. Then, Lord, there was also, Lord, steps taken with regard to acquisition. Lords have already seen, Lord, the provision required and it is to be a state property. And not if any property is to be acquired, then necessary action had to be taken. So in that regard, the second portion says, Murkankuda State Forest notifies under section 48(1) of the Mysore Land Acquisition Regulations, the withdrawal of the properties declared for acquisition in notification number so and so, dated so and so, as required for constitution of the dash. So what was done was, Lord, notification was issued, section 4 under the regulations, after which, Lord, they themselves dropped in 1924. And Lord, in fact, I took my lords through multiple proceedings, Lord, that was recorded, where the conservator of forest also says, this is not feasible, let us drop the proceedings. All that also, Lord, I placed on record. Lord, please turn to page 86 for a moment. Even there, Lord, this section notification is not set out. Dropping of the proposal for acquisition. Under section 48(1) of the Mysore Land Acquisition Act, the government of His Highness Maharaja of Mysore are pleased to withdraw from the acquisition of the properties declared for acquisition in their notification, as requested, Constitution Murkanguda Forest Area in Hassan District. Lord, then, Lord, please turn to page 88. But all this was available in the archives of the government. Page 88, not this is the government file, not to get it page 87, which is handwritten. This is General and Revenue Secretariat as then. But the type copy is at page 88. But I'm sorry, can I request the subject that is provided there? This is January 2024, page 88. It says cancelling the reservation of Murkangudda State Forest in Hassan district. Then bottom lot it says to the conservator of forest so and so directs that the proposal to constitute the area into state forest may be dropped.
To the conservator of
Revenue Commissioner, Deputy Commissioner of Hassan. It's given to everybody. This is by the Secretary. It says General and Revenue Secretariat.
of FR, the forest.
How?
Revenue Commissioner, Deputy Commissioner of Hassan District. Proposal of.
Directs that the proposal to constitute the area into state forest may be dropped.
May be dropped.
Yes. So this is followed, my lord, at page 89.
So this was 11/1/24.
How?
Same date.
Please. In page 89, this not the handwritten itself not permit me just show because I think the type copy it is not there. But file heading, not kindly see at page 89, cancelling the reservation of the Murkangudda State Forest in Hassan district. That's the name of not the file itself. Then not the type copy page, the next page, brief abstract of the letter.
This is from the conservator of forest.
Yes, not. This is not. I'll just. Oh, this no. This again says General and Revenue Secretariat. This is a file heading
from the conservator of forest.
Yes. Abstract of the letter. It says recommends that no, it is not desirable to reserve the block to the detriment of villages concerned, and the proposal may be dropped in view also of the area being treeless. Notes and orders. These areas was proposed for reservation in July 1915. And the declaration under section 4 was published in February 1920 after sanctioning acquisition of about 69 acres under holding. Then the next continuation is at page 92. The cost of acquiring was estimated at rupees 4,900. The conservator now says the proposal may be dropped. 3. Before dropping with the proposal, it appears necessary to know if the lands have been acquired and compensation paid. If the department has taken any action to demarcate the area, whether FSO has not yet moved in the matter. So they wanted to check if any property is acquired, what is the cost incurred for acquisition in pursuant to 1920 notification. But clause 2 categorically says the entire thing has been dropped. Then page 92A. Says from the conservator, the next page, number so and so states that about 48 rupees, I think not the date is wrong, it is 13/10/73, it may not be, was incurred on demarcation line, ensuring that no lands were acquired. Under the circumstances, it is for order if settlement records may be called for dropping further proceedings. If no lands are required and not required for the block, land have to withdraw from acquisition. Reservation should be cancelled.
(24) 12/10/23.
Yes. Nobody would have kept quiet for more than 100 years, not if actually it was to be construed as a forest. But then, Lord, please turn to page 98. But this is again by the conservator of forest, adverting to the government, page 80, 98. No?
Yes.
Adverting to government order so and so dated 5th of February 1920, sanctioning the reservation of Murkangudda forest block in Manjarbad Taluk and issue of notification section 4 of the forest regulation. I have the honor to state that during my recent tour in Hassan district, I had an occasion to inspect the area in compliance with the protest petitions received by me. The area proposed for reservation comprised of treeless, grassy plains and without any vegetation whatever. As it is not worthwhile while conserving the block to the detriment of the villages concerned, I am of the opinion that further proceedings in the matter be dropped and notification issued under section 4 of the Forest Act treated as cancelled. Lord, the state wants to say that the cancellation notification is only insofar as acquisition. But Lord, this categorically says the entire Lord, section 4 notification is treated as cancelled.
It is his recommendation.
No, this is not.
There is a conservator of forests, it's not the state.
True. But there is that notification also says the proceedings to be dropped. That is a notification.
Yes.
But this letter is 1923. But I'm just giving a backdrop to point out.
Everybody wanted to drop it.
It is not. They wanted to drop it because 1924 is a notification dropping it. State now wants to say that dropping was not the entire thing. It was only insofar as a proposal for acquisition. But it's factually incorrect because the entire file Lord is with the state.
Yes.
And it shows 1923 itself, entire thing was to drop the entire reservation. Then Lords, please then permit to take the code to page 101. Lord, I'll not trouble reading not the entire thing, but the first sentence itself, I think the third line, it says, not asking that further action on the reservation of Murkangudda block in Hassan district may be dropped. I have the honor to submit here with the information to the government. Copy docket number so and so 27 September 1923 from the district forest officer. The last sentence, Lord, it says no compensation was paid as no lands were acquired.
Yes.
Then, Lords, the
demarcation line was cut at the rate of rupees 4 per mile.
Then bottom of page 102, there is an order of 1922, which refers to Lord about 2-3 survey numbers have been excluded from the state forest. It says the boundary line in tracing is also correct. As the conservative forest have instructed to exclude survey number 49 and 50. In Cardmane, survey number 167 of Agani and survey number so and so of Achanahalli, these survey numbers have been excluded from state forest. Other Hiduvali numbers noted C register herein are kept enclosed as to state forest as per the opinion of the assistant conservator. Hence, the question of acquiring any Hiduvali lands, the government order sanction acquisition may be caused to be cancelled. This is in 1922. But after this, all proceedings were towards cancellation of the entire proceedings. Then, Lord, please turn to page 105. But I'm sorry, I'll skip that, not be. This is again not with regard to the settlement report, etc. Please turn to page 107. Bottom of page 107, para 3. Correspondence ending with letter number so and so dated so and so from the conservative forest forwarding the records. Then at page 109, relating to settlement of the block and stating it is not worthwhile reserving the area as it comprises treeless grassy plains without any vegetation and that the proposal may therefore be dropped. Order. Government agree with the conservator and directed the proposal to constitute the area into state forest be dropped. A notification
by the revenue secretary.
by the Revenue Secretary. A notification
Government
will
order.
be published in the Gazette withdrawing from the acquisition of the properties referred to above.
Yes.
Two also may be seen.
Very well.
There
Two
itself.
also. Government order.
Relevant.
I'll read not from one itself. Let it not
No,
be
no,
that I have
just
not
the
pointed
last
out.
one.
Like, it should not be that I have not pointed out something, but I don't want, I thought I'll, very well. 107. Read government notification so
Come to
and
two
so.
only, not required one.
A notification will.
Notification authorizing acquisition of certain lands for the aforesaid purpose.
Yes.
The first one says declaring proposal to constitute certain lands in Manjarbad Taluk into state forest under the name of Murkangudda block.
Yes.
Not the page 112 also not is the notification in the 48(1). But I don't think this is required because it is already covered. Not this is a part of the record in that not archives which was obtained. But I had placed on record the entire report that was prepared by the Assistant Commissioner of Sakleshpur. I had placed it along with the memo. But what had happened was there was a meeting between the regional commissioner, including the forest officers, revenue department. They commonly have a meeting to whenever there's such issues. But in that meeting, a decision is taken saying that entire thing has to be closed because people are there. There are 50 odd resorts in the place. There are not hundreds of people residing here. Grants are made. People have developed.
When was that meeting?
But insofar as this petitioner is concerned, the grant to the erstwhile vendor in 1924.
Yes.
But there was, I have produced that document as well. But so entire thing has gone on the ground that this entire acquisition or the proposal to constitute the forest has been dropped by the government. But what happened here was they passed an order insofar as this petitioner is concerned under section 64A on the basis of this 1920 notification saying that you are liable to be evicted. To my knowledge, in fact, I've also filed an affidavit. To my knowledge, no other resorts have been targeted like this. I have been targeted. Section 64A is order is passed. My resort was I'll just show two photographs, but 40 odd.
You may be the starting point.
Section 64A is an order that is passed directing my eviction without there being a notification under section 17.
Yes.
But just to show the malifieds or the
your ground is basically no jurisdiction.
One is no
Unless
jurisdiction.
there is no forest, the question of excising 64A would not arise.
Yes. In the first is they have dropped the or the proposal to constitute. Two, in the alternative, if it is Honorable Court comes to a conclusion that the entire proposal was not dropped, even then, by virtue of lapse of more than 100 years, it is not open to them now to invoke the provisions of the Karnataka Forest Act to continue proceedings which has lapsed more than 100 years ago. 1920 is a notification.
Within a reasonable period of time.
Reasonable period principle. In fact, the division bench of this Honorable Court has held, I'll pass on that judgment itself. 3 years the time limit.
3 years.
3 years to not issue final the notification under the Forest Act.
For acquisition also, we don't say 3 years. No.
Please not.
For acquisition also, we don't say 3 years.
But that is the judgment of this Honorable Court, where the court said because this section 4 is the preliminary notification.
KDB doesn't have a time limit.
Yes.
Where there is no time limit prescribed.
I have suffered an
The
order.
division bench of this court.
Yes.
Only in respect of land acquisition, 2 years.
Yes.
If the proposal of acquisition is there and no time limit is fixed.
Then 100 years is too long a period for them to say that I'll now invoke.
100 sounds good. It's 1 century.
Yes, 1
Only
century.
one.
In fact, more than 1 century. I think 103.
Yes.
But I'll just show one. Can I request the court to please turn to page 113 for a moment?
113.
Yeah. Can I request 100
Photographs of the
photographs are there? I'll request the court. I'll request the court to please turn to 116 for a moment.
They come and locked it.
Huge number of people, they suddenly come, they lock my premises at page 117. As though there's an army of officers, 117. But what was so special that they had to come and with so many people? An interim order was granted by this honorable court that was not complied with. I had to again file an application before this honorable court seeking for further direction, and thereafter this honorable court directed them, if you don't comply, you have to comply with the letter and spirit of the order, and that is the second order that is passed now. Please see the order dated 10/8/2023.
Order sheet. In which matter?
Not in this writ petition itself. 16251. But I've been discriminated. It's only there are several, about 15 odd homestays or resorts in the place. But so far as I'm concerned, Lord, this order is passed.
Okay, we'll direct them to take action against everybody. Okay, what is the order?
Lord, this order dated 10/8/2023.
10/8/2023.
Lord, is the order. Lord, this court video. Lord's have it, Lord. 10/8/2023. Passed on IN number 2 of 2023. The first interim order was granted on 27/7/2023, but restraining them from interfering with the subject property and running of the business. Then, Lord, the learned counsel appearing for the petition complained the said order has not been obeyed in fifth and substance, and therefore the impugned order needs to be stayed. There is no reason to doubt this version. When an interim order is made by the court, the parties to the proceedings cannot keep their common sense in cold storage. They have to scrupulously do all that is required of them by intent and content of such orders that have not been that has not happened in this case. Petitioners need to be granted an appropriate modification of the interim order. In view of the above, order staying the impugned proceedings in terms of annexure J and J1 is accorded. Interim order granted is extended till next date of hearing with the above modification. Now, let's just pass on few judgments. I'm sorry, there's one more submission. But under section 117 of the Karnataka Forest Act, Mysore Forest Regulations has not been referred to. But this regulation is independent of the Forest Act. But only section 23 saves only such forests where it is notified. 117 the repeal and saving provision refers to Indian Forest Act 1927 as in force in Bombay area. Indian Forest Act, I'll skip that. Please then come down as in force in Madras area, and Karnataka Forest Act 1900. That is Karnataka Act 10 of 1900. Please see the regulations. The regulations is Mysore Forest Regulations of 1900. Karnataka Act 11 of 1900 it is. Both are issued on the same day.
But regulations have been issued under the Forest
No,
Act.
Lord, that is the difficulty. But the regulation does not say.
It is verbatim identical.
Yes, I have not compared 4, 5, 6. They look not quite similar. And it is a different enactment and it's published on the very same day. I'm thankful, Sir Kiran gave me a better copy. But I think last date, he passed on a copy to the court. It is regulation number 11 of 1900, passed on 16th of November 1900.
That they'll have to explain.
They'll have to point out what happened to this regulation, not whether it is it their case that this continues to exist, or is it their case that this has been impliedly repealed. Then I can address on that issue. Therefore, my submission is,
or despite the Karnataka Forest Act 1900 being in force, why did they take action under the regulation in 1920?
True. Not sign ಮಾಡಿ. But the first judgment is at page 3. Please turn to paragraph 5 and 7. at page 6. Yes. We have carefully considered submissions. Impugned order communication proceeds on the assumption that the subject land has been declared as a reserve forest only because notification to section 4 of the Karnataka Forest Act. The only ground for invoking the said Act 1980 is issuance of notification under subsection 1 of section 4 of the Karnataka Forest Act. We have perused the provisions of chapter 2 of the Karnataka Forest Act. For constituting any land as reserve forest, notification under subsection 1 of section 4 of the Forest Act is only a first step which is required to be taken before the state government decides to constitute a land as reserve forest. Therefore, elaborate process will have to be followed as provided in various provisions of chapter 2, and the land is declared as a reserve forest only after notification under section 17 of the Karnataka Forest Act is issued. Only on this narrow ground, the impugned communication will have to be set aside. But then section para 7, the court refers to the definition not under the 1980 Act, but I'll skip that portion. Then not the next judgment is at page 9, not para 7. But please turn to page 14. Not para 8 not refers to section 2 subsection 14 of the Act defines reserved forest as any land settled and notified as such in accordance with provisions chapter 2 of the said Act. Clause C of subsection 1 of 4 of the Act provides the appointment of forest settlement officer to inquire into and determine the existence, nature and extent of any rights claimed by or alleged to exist in the favor of any person in or over any land comprised within such limits, or in or over any forest produce, or to deal with the same provide so and so. Here he is a different person from a forest officer. It was expressly provided under subsection 2 of section 4 of the Act that an officer appointed as forest settlement officer shall be a person not holding any forest office except that of a forest settlement officer. But I'll skip that note. Please then turn to the next paragraph. We find that the respondent number 2 is a forest officer within the meaning of subsection 6 or section 2 of the said Act, therefore not competent to inquire and determine the existence, nature and extent of the right, title and interest claimed by the writ petitioner, inasmuch as may be determined by the forest settlement officer appointed under subsection 2 of subsection 1 of section 4 of the Act. We find that the order dated so and so that proceedings were initiated for purpose of ascertaining the rights of the writ petitioner proceeded on the assumption that the property was a reserved forest. The initiation of the proceedings and the inquiry by the respondent number 2, who has been a forest officer, is without jurisdiction. Thus, the entire initiative by respondent 2 is void ab initio. We therefore quash all subsequent proceedings. Then let's please turn to page 18. But in this case, at
This
page
judgment
18,
is attained finality.
but I have not checked this. Not the next one. Not I had checked. I think there was no. The court did not ultimately interfere in the next one at page 18. But I'll check both not these orders. Page 18 lots is another judgment. But from page 21 onwards, but the court extracts all these provisions. But please turn to page 29. Yes, but para 10. The object of the Act is to consolidate law relating to forest produce in state of Karnataka. Subsection 14 of section 2 defines state forest. Not, I'll skip this portion. I'll take not to page 32. I'm sorry, page 31, bottom, para 19. Notes me, please mark 10, 11 up to 14, then para 19. When any specific period has been fixed for making a claim and also filing an appeal by any persons, a corresponding time frame for adjudication of the claims and for issuance of a declaration ought to have been made. The absence of any specific time frame for the issuance of a declaration under section 17 would imply that such a declaration must be made within a reasonable time. What is reasonable time in the absence of any specific time frame mentioned in a statutory provision would vary from Act to Act and depending upon the object and scope of the Act. In the instant case, having regard to the scope and object and scope of the Act in question, we are of the view that a period of 3 years would be a reasonable period within which a declaration under section 17 ought to be made, excluding the period when steps are taken under the Land Acquisition Act 1894 as well as appellate proceedings if any. This period obviously would exclude any stay orders granted by any court of law. But in the instant case, the state is unable to point out any steps initiated after the order passed by the forest settlement officer excluding 366.so acres, which according to the petitioner also includes the area with subject matter of the quarry. Then Lord para 21, bottom, the court says in the instant case, though the preliminary notification was issued on 3/6/1991, the final notification is yet to be issued. In fact, several adjournments were taken in the matter so as to enable respondent authorities to take decision with regard to the issuance of declaration in section 17 of the Act. And even then, no steps have been taken to issue such a declaration. Therefore, we find the state government having not taken steps for over 2 decades after issuance of the preliminary notification, abandons its intention to notify survey number so and so is a reserved for. This becomes all the more clear by the fact that subsequent to the issuance of the preliminary notification, in so and so quarrying lease was also issued. But here, my lord, it's more than a century. Lord, the next judgment, page 34, Lord, I will only mention the para 25 at page 47. Lord, this is the, again, reasonable period principle, Lord. I will not trouble reading it.
Yes.
Therefore, Lord, my submission is that the entire Lord proceedings have been dropped. In the alternative, Lord, the proceedings, Lord, have lapsed by operation, Lord, of reasonable period principle. And thirdly, Lord, the provisions of section, that regulations of 1900, Lord, have neither been repealed nor, Lord, can they be continued by virtue of the 1963 Act, which has come into force. And Lord, section 23 also does not save. But if there is a provision which specifically saves a area which is notified as a forest, the necessary intendment would have been that because the rest of it is not notified, it will not continue to remain in force and cannot be proceeded further. That would be the intention. Otherwise, not the provision would have said, even if you have commenced, you can continue from there. It does not say so. On the contrary, it says, Lord, proviso says, if the government feels that you have concluded everything, that there is some issue with regard to the settlement, etc., you can still reopen it. But it does not save any notification which is issued under section 4 of the regulations as such. That is. Please, the proclamation also, Lord, we have challenged, Lord, in this petition. And this notification or this order has been now passed, Lord, in October 2025, without notice to me.
What is the order in October 25?
Not October, during pendence of this petition, not, of course, there was an interim order. Interim order was not specific to say don't conduct further proceeding. Lord, I'll have to point out to that court. But be that as it may, Lord, matter was pending before the court. They have proceeded, Lord, with the section 7 proceedings and passed an order rejecting the claims. But petitioners had filed their documents because they issued notice to us, the proclamation. We challenged the proclamation before this honorable court. We have filed the documents with regard to what are the properties that is, Lord, that is with us.
Yes.
Title deeds, because we have registered sale deeds. In fact, there is conversion also in this petition. There is an order of conversion that is passed by the deputy commissioner. Everything is available.
He did not know about it.
But that, Lord,
is what they will say.
Very well.
Vijay, anything? Granted by the government.
Produce the grant certificate. Annexure O and P.
WP 269690. Annexure?
Annexure O and P.
Page number?
Page numbers 131 to 144. I produce the Savali chips.
Annexure O and
O and P, my lords.
P. Yes.
And my lord, the other difference is that we are not running a resort there. We are not running any resort there. My lord. We are, it's purely coffee plantation which is going on there. There is no resort or no commercial activity as such.
Hmm.
And therefore, my lord, if this proposal, 1920 proposal, as my learned friend submitted, never fructified into a declaration for 103 long years. And my lord, my learned friend also took your lordship through the deliberations in the department, interdepartmental.
You adopt all of it.
Please. My lord,
Additionally,
if it was found unsuitable to declare this, the entire area as a forest 103 years back, for the reason, my lord, that it will affect the coffee cultivators. There is all the more reason, my lord, now when the population has increased almost more than 50-fold, to, my lord, not allow
now
this.
you have grown trees, so it's a forest. Earlier it was only plain land.
No, my lord, there was, in fact, those deliberations show, my lord, those notings show that there was coffee plantations everywhere, even 105 years back.
Hmm.
Merely because it would affect the lives of many people who are, my lord, doing coffee plantation work.
Those are the 3 petitions received by the chief
Yes.
conservator.
That is why it was shelved back then into 103 years back.
Hmm.
And now, my lord, the coffee cultivation, my lord, is widespread in the entire taluk. And there is all the more reason why it should not be declared as a forest in this age. Population has increased 100-fold, and my lord, human needs are also increased manifold.
So that means no forest in future.
ಅಲ್ಲ 103 years back as forest ಬೇಕಾಗಿರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ ಇವತ್ತಿನ
Ground may not be available. For population increase and a forest stop ಮಾಡು ಅಂದ್ರೆ, then what will happen?
Please, my lord.
You cannot say because of population increased, forests are not required.
Not that. I'm saying if we compare that era and now, because I have to refer to that as another era. And therefore, my lord, in the present day and age, my lord, this proposal, my lord, it is still remained a proposal for 103 years without any declaration being issued. Therefore, my lord, the forest department, my lord, cannot proceed with this declaration.
Yes. Yes, Mr. Ron.
Sorry, the other petition lots, that there are about 80 odd persons who filed the petition. But last time I'd made a request that not the interim order may be considered, because insofar as they are concerned, not section 64 also is issued. But many of them not have sale deeds, some of them have been regularized.
It's been listed today.
Yes,
Last
it's
time it was
listed.
not there.
Yes, yes.
We'll extend that order till the disposal.
Yes, now, Lord, I'm told that some of the cases they have passed the order also. Please.
As Mr. Ron submitted, it's 1920, which is the crux. Yes, Mr. Ron.
No orders are passed on 64, and will not take any precipitative action, even if it is passed now.
Yes.
Matters need to be heard. Monday, my lord, may I request? What has
Heard
happened?
everybody,
No, no,
how long will you take?
No, I won't take more than 20 minutes. My lord.
Finish it.
No, I just need to, on the 2 acts of regulation of 1900, Lord, I'm taking instructions in that behalf. Monday, my lord, if my lords, if the
Monday ಇದೆಲ್ಲ ಯಾವ್ದಿದೆ?
Tuesday, anyway, we have, no, Tuesday, we have the forest lease matters. Coorg, my lord. If I can be given some time.
Every day we have something other than now it is next 2 weeks is not going to be.
Or
Monday, let us see at 4 o'clock if we don't know. See.
make a beginning.
Don't make a beginning if you don't want to close.
I want to, because
Then
clarify
get your
all that.
instruction and close it on that day.
Yes.
We'll anyway sit till late. So
Monday, my lord.
Monday.
Yes.
Heard Shri P.N. Manmohan Learned Counsel, Shri P.N. Manmohan and Shri A.M. Vijay Learned Counsel for the petitioners. Shri N. Vinay adopts the arguments of Shri P.N. Manmohan. For arguments of the Learned Additional Advocate General, relist on 8th at 4 p.m.
Yes.
The interim order insofar as
Interim order
11.4.
in WP number 16251 of 2023, is extended to the benefit of all other petitioners till the next date of hearing.
So there,
Extended to everybody.
everybody.
Same order, Tan.
Wait.
Agenda of the smooth matters. Venugopala J, party in person.
Yes.
My lordship, I'm the petitioner, is the victim of fraud on court and illegal eviction, my lordship, which is observed and considered by
To register FIR, what is the urgency for you to move at the end of the list?
my lordship.
And AGA accepts notice for respond 1 and 2. He seeks and is granted a week's time to obtain instructions and make a submission. Relist on 16th December.
Thank you.
Ajay Kumar.
Please.
Jay,
It's filed by BDM, my lords.
court fee not paid.
Court fee is
10.
paid, my lords. Court fee is paid.
And counsel for the petition submit that court fee has been paid, registry to verify.
Please.
Yes, what is this?
My lords, complaint has been made before the Commission for SC/ST, my lords, Annexure J. Objections were filed pointing out, my lords, that the land, my lords, survey number 26/2 is part of Arkavati layout, my lords.
To allot,
Been acquired.
allot a site.
My lords, towards, my lords, compensation, my lords.
Yes.
There are about 5 complaints which are before the Justice
AC
Station and a
Manjunath is
committee.
directed to accept notice for respond number 2. Issue notice to respond number 1 returnable by January.
27 January.
The further proceeding complaint number 20 of 23 pending on the file of the Karnataka State Commission for Scheduled Castes and Scheduled Tribes, Bengaluru. Is stayed till the next date of hearing.
I pray for hand delivery. Tomorrow matter is listed. Hence
At
I'm moving.
5:30, if you say hand delivery,
Please.
I think
we'll
for-
only shake your hand at time.
For States Commission, my lord.
Serial number 80, please.
State Commission.
I think AC Manjunath is for National Commission.
AC Manjunath State Commission. National Commission ಬೇರೆ ಯಾರೋ ಇದೆ. ನ್ಯಾರೋ.
B. Basuraja.
ಅಷ್ಟೇನಾ?
Fast
My lordship, serial number 18, list number 1, my lordship, there is extreme urgency, my lordship. The bank council is present.
Bank council?
Yes, my lordship.
Why is, what is the bank?
Earlier on first of this month, my lordship.
Bill number?
Serial number 80, my lordship.
80.
80.
Surface matter.
No, my lordship, defreeze matter. GMRES, defreeze, my lordship.
Defreezing.
Defreeze. A notice has been issued and instructions has been given by the head office, my lordship. Even in spite of that, they are not defreezing the petitioner's account.
And you are permitted to file objections, my lord.
Filing objections. Survey.
I have received, my lordship.
80 learned counsel for respondent has filed his objections. Copy thereof has been served on the petitioner, released on 10th December.
My lordship, already the date has been fixed.
Serial number 67.
98.
ಇಲ್ಲ password ಕರೀತಾ ಇದೆ.
ನೀವೇನ್ರಿ ನಿಮ್ಗೇನ್ ಅರ್ಜೆಂಟ್ ಅವ್ರು ಹೇಳ್ದಾಗ ಹೇಳಿ ನೀವು ಬರ್ಬೇಡಿ ಗವರ್ಮೆಂಟ್ ಸೈಡ್ ಇಟ್ಬಿಡಿ ಎಸ್
128.
ಹಾ
My transfer order has been stayed by some court. All allegations against me.
128 awaiting service on respond number 5.
The respond number 5 is the management committee and petition is the member of management committee.
So who will appear for respond number 5? We'll have to wait for service to be completed.
Now lordship, 6th respondent.
Awaiting service on respond number 5 released on 16th. IA 2 of 25 will be considered along with the main.
Serial number.
Released in second list, lordship. Serial number 126, the exhumation matter. Interim order, serial number 126, man. The exhumation matter, the interim order was not complied with. Passed by my lord, where the washroom was constructed over the mortal remains of the grandparents and the mother.
Yes.
Interim order was not complied with. If the
What
matter may be
happened?
taken up.
Why it was not complied?
They
Customs
were told by
continue.
the Tahsildar that the word if was used in the order, and so they
No,
believed
are
it
the
was
mortal
condition.
remains there or no?
They have not done, the mortal remains according to me are there. I have produced photographs. They believe that the word if has been used and so it is conditional.
Required to,
May I request
statement of objections have been filed, we can't take it
by
up.
the private respondent.
Now anyway, there is no urgency,
No, if it may be taken up on Tuesday, subject to a convenience.
no urgency now to be taken up.
The toilet is fully functional.
Serial number 55. Serial number 55.
Huh?
My payments are held up due to inquiry, my lord. Now there is no recovery proposed, my lord. It's taken up.
ಏನಪ್ಪ ಇವಾಗ ಅರ್ಜೆಂಟ್ ಏನು?
My lord, for 2 years, no payments have been received in all contracts, my lord. And my
2 years, no, another two, my lord.
Serial number 98, my lord, is an interim order which expires today.
What is that? Why somebody is not accepting money?
It's not correct.
My lord, may
K2 ಚಲನ್ ರೈಸ್ ಮಾಡಿ ಪೇಮೆಂಟ್ ಮಾಡಬಹುದು. K2 ಚಲನ್ ರೈಸ್ ಮಾಡಿ ಪೇಮೆಂಟ್ ಮಾಡಿಲ್ಲ ಅವರು.
ಅಲ್ಲ ನಾನು representation, my lords may take my IA, my lord.
K2 ಚಲನ್ is RTGS.
ಅಲ್ಲ ಯಾವ ಹೆಡ್ ಕೆಳಗಡೆ ಏನು ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರೆ ನಾನು ಮಾಡ್ತೀನಿ. I've given 3 representations, they don't respond, my lords.
98 relist tomorrow, 98, 99, 100, 101, 102 connect to each
My
other.
lords, 101 I don't think is mine.
101 is also your 101 illa, sorry. 98, 99, 100, 102 connect to each other, relist tomorrow, learn AGA is directed to furnish the details of the challan to be generated for payment.
I'll pay, my lords, I'm willing to pay. Preliminary hearing.
Tomorrow we'll give you the challan.
Preliminary hearing.
At 2, 1 ನಿಮಿಷ ಇರ್ಲಿ, at 2:30 PM.
Serial number 57, my lord. Petitioner is 98 years old, my lord. He has been thrown out from the house, my lord, by obtaining a fraudulent gift deed, my lord. We have
57.
57, my lord. There is extreme urgency, my lord. He is on streets, my
Relist on 8th at 2:30 PM.
lord. My lord, serial number 75, my lord.
Just a moment, madam.
Serial number 75, my lord, tender matter. There is no stay, my lord, sir. In this selection process, they are not, they are finalizing the tender, my lord. But if they finalize, my lord, my tender become infrastructure.
If anybody interrupts in between, their matter will go to March 26 or 27.
My lord, 75, my lord, there is some urgency, my lord. the matter.
Already the matter is.
ಏನಪ್ಪ ಯಾವ
Serial number 42, my lord. In this case, already survey has been, everything has been done, my lord. As per this-
Taken up next week.
Next week, any day.
There is no stay. So what's your problem?
Next year we need.
42.
My lord, serial number 67, the compensation has been enacted by this court, but the advocate on record in the trial court is objecting to the same. I am not able to release the compensation amount and take treatment at demands. I had met with an accident.
My lord, I'm appearing on behalf of the panel advocate for responding number 1. Taken up next
Why are you objecting to the compensation which has been enhanced by this court? We'll take it up. But if we find that you are objecting to what has been ordered by this court, then you are in trouble.
But this
Please
court
take
in
note.
December
67 relist on 8th at 2:30 PM.
Oblige, my lord.
Yes.
88, my lord. 88, my lord. Serial number 88.
Ah.
My lord, managing committee, my lord, has been stayed, election result of managing committee has been stayed.
We have to hear you. It can't happen.
Serial number 18 passed over, madam. Tomorrow, my lord.
18 Monday.
Serial number 63, my lord. I run an education institute, my lord. I have filed memo regarding the expense, my lord. That needs to be released, my lord. Shall be paid, my lord. My freezed, my lord. Unauthorized.
Serial number?
63, my lord.
91.
Respond number 2 in that matter.
91 recalling because it was not complied. Pending consideration of 25, petitioner is permitted to comply with the office objection.
My lords, the small submission, my lords. We had obtained interim order without serving a caveat on it.
Now there is no interim order, madam. We are not extending any interim order.
Please, my lord, but the petition cannot be restored, my lord. He was given sufficient opportunity to comply with the office objections.
Madam, how can you say that?
My lord, it may be taken upon 10th, my lord, so you'll object.
In future, in any matter that your matter gets dismissed, it won't get restored.
My lords,
You give us that undertaking.
my lords, my lords.
Don't make that kind of a submission. Let him comply with it, then we'll consider restoration. We have 1 week's time. 116. ಹೇಳಿ. There's some impleading application filed.
Yes, Malaj, I appear for the impleading applicants in 116.
There's some objections.
ಕಾಪಿ
ಸರ್ವ್ ಮಾಡಿಲ್ವಾ?
ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ. ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ, ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ.
ಯಾವಾಗ ಫೈಲ್ ಮಾಡ್ತೀರಾ?
ಅಲ್ಲ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ, ಆಗಿದೆ.
ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ದೀನಿ. ಅದರಲ್ಲಿ
Counsel for the petitioner confirms receipt of copy of IA 2 of 25, hence office objection raised thereon does not survive for consideration. We list on one date.
My lord,
Lords, may I make submission?
ಆ ಮೆಟೀರಿಯಲ್ಸ್ ನ ಫಾರ್ಮರ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ ಸುಮ್ಮನೆ, ಅದು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಆದ್ರೆ ಅದು ಮ್ಯಾನುಫ್ಯಾಕ್ಚರಿಂಗ್ ಡೇಟ್
Nale is CMP day. We already have 117 CMPs listed tomorrow, apart from fresh matters, which are around 30-40. ತಗೊಳಕ್ಕಾಗಲ್ಲ ನಾಳೆ.
Pertains to fishing lease rights. Lordships has passed an order like not to be precipitating. There is an ambiguity minutes we have approached the Chief Justice Miller. The approach, the Chief Justice got all remanded matter to the
27.
The ambiguities minutes not to drop any fresh fingerlings. Now what they are doing the respondents minutes, they are catching the fish minutes. They already 1 crore is lost minutes. Can you have it tomorrow? This is the ambiguity minutes. We have been in loss.
That order was passed by a coordinate bench. So you'll have, if that ambiguity has to be clarified, it has to be clarified by the coordinate bench, not by this court.
Please, madam.
So you'll have to move an application for modification or clarification before the coordinate bench which passed the order, not before us. Move that there.
Until then there is.
How can we clarify another coordinate bench's order?
Until
It has to, it will go back before that. Remand agare, it should go back. Move that there.
Lord, that the procedure for Lord registration that I brought, Lord, I will place.
40?
48.
8 released on 10 December. Willfully. We can't consider it now. Yes. IO will be extended in all matters. Huh? We won't have time to hear you and pass orders. There are already a lot of bigger matters pending. When do you want to take your chance? Next week. Which day you want to take it? 47, Monday.
Lord, serial number 40, Lord.
Monday we got 217 matters already. Take your chance.
Lord, serial number 40.
Who has attached the property? Under Surface Act or under which act? No, attachment is under what act?
ಇಲ್ಲೇ ಹಿಂದೆ ಮಾತಾಡ್ತಾರೆ ಇವ್ರು ಕುಡಿಬೇಕು.
No, attachment is under which provision of which enactment, madam? That is why it is surface a matter. Check ಮಾಡಿ ನೋಡಿ ಯಾವುದು.
Serial number 40.
Serial number 103.
Lord. Fresh matter, Lord.
One not four, what is the thing? One not four relist on 10th.
My lords, 103.
10th at 2:30 p.m.
My 103.
Just a moment.
Serial number 94, my lords. My work order has been terminated abruptly, though it was in existence till 31/1/2026, my lords.
94 Monday.
75 minutes. Made a mention.
Monday.
Please plus on.
40 Lords. Tuesday.
Monday.
Tuesday. Any day. Plus 44.
Monday will be another 400 matters. Again, it will be same.
44 as well.
We are trying to tell you, please understand. We will try and schedule it such a way that we can take it up. That is the calendar management.
I will take it on Tuesday, my lord.
But if you are.
I will take it 40 and 44, my lord.
Tuesday, 198 matters.
Lords, we
217 go 198 is the difference. If there's emergency, we'll take it up. Thank you, madam.
Respondents, 3 to 5 have filed IAs 1 to 3 of them.
Yes,
They have
madam.
not served copy to us. And we made
Who is that council, madam?
Respondents 3 to 5.
What is the name of the council? Is he around? You can't direct them.
Serial number 103. 103 serial number. January date vacation ಆದ್ಮೇಲೆ.
Whichever date ಆಗತ್ತೆ.
103.
Madam, it won't reach on Monday, Tuesday. There's a possibility of 10th. List 2 alone. Serial number 15. Petitioner is before this court seeking for the following reliefs. After arguing for some time, learned counsel for the petitioner has filed a memo which reads as under accepting said memo, petition is dismissed as withdrawn. Escape, just escape. ಕೊಡಿ ಕನೆಕ್ಟ್ ಮಾಡಿ ಕನೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಅದು ಯಾವತ್ತಿದೆಯೋ ಅದು ಬರುತ್ತೆ.
Court officer, madam.
Sir, 103.
ಮೇಡಮ್ ಒಂದ್ ಸೀರಿಯಲ್ ಆಗಿ ಬರ್ತೀನಿ, ಒಂದ್ ನಿಮಿಷ ಇರಿ. ಅವ್ರಿಗೂ ಹೇಳ್ಬಿಡ್ತೀನಿ ಅದನ್ನ ಮಧ್ಯ ಸೀರಿಯಲ್ ಆಗಿ ಕರಿತೀನಿ ಸರ್. ಡೇಟ್ಸ್ ಎಲ್ಲ 3rd February. ಸೀರಿಯಲ್ ಆಗಿ ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿ. 40 ರೀಚ್ ಆಗಲ್ಲ, ನೀವ್ ಹೇಳಿದ್ರಿ ಯಾವತ್ತಿದ್ರು ಕಾಯೋದೇನೆ. 3rd February ಆದ್ರೆ ರೀಚ್ ಆಗ್ತವೆ ಅಂತ. ಅಷ್ಟ್ರಲ್ಲಿ ಹೊಸ ವರ್ಷದ ಹೊಸ ಫೈಲ್ಸ್ ಬರುತ್ತಲ್ಲ. 42 ಅಲ್ಲ ಬರ್ತೀನಿ, ಸೀರಿಯಲ್ ಆಗಿ ಬರ್ತೀನಿ. 42 46 44 ನೀವೇ ಹೇಳಿದ್ರಲ್ಲ ಟ್ಯೂಸ್ಡೇ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ. 46 51 52 53
Madam 52 petition.
ಯಾವತ್ತು
Shortest date ನಿಮ್ಗೆ ಯಾವ ಕನ್ವೀನಿಯಂಟ್
ರೀಚ್ ಆಗಲ್ಲ, ಹಿಂಗೆ ಕಾಯ್ದು ಡೇಟ್ ತಗೋತೀರಾ?
ಚಾನ್ಸ್ ತಗೊಂತೀನಿ.
ಯಾವತ್ತು ನೀವು ಕಾಯೋದು ಯಾವತ್ತು ಅವತ್ತು ತಗೊಳ್ಳಿ.
15 to 15th ಆಗ್ಬೋದಾ?
50 to 15th ರೀಚ್ ಆಗಲ್ಲ. 53 54 ಇಲ್ಲ, ನಿಮ್ ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ, ಯಾವ ಸೀರಿಯಲ್ ನಂಬರ್ ಅಂತ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ. 55 58 230 59 60 61
ಮೇಡಮ್
61
ಮೇಡಮ್
59 ಯಾವತ್ ಸರ್?
ಮೇಡಮ್ ಅದು ಕವರ್ಡ್ ಬೈ ಜಜ್ಮೆಂಟ್, ಅದು ಯಾವಾಗ
ಬಿಡಿ 3rd February.
ಮೇಡಮ್ ಅರ್ಲಿ ಡೇಟು
ರಜಾ ಇಲ್ಲ, ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಸರ್. 3rd February. 64
15th ಸಿಗ್ಬೋದಾ ಮೇಡಮ್? ಅಟ್ಲೀಸ್ಟ್ ಒಂದು ಟ್ರೈ ಮಾಡ್ಬೋದಾ?
ಅಲ್ಲ ಅದೇನ್ ಡಿಸ್ಪೋಸ್ ಆಗಕ್ತಾನೆ, ಬಿಡಿ ಸರ್ ಬರ್ಲಿ. 64 3rd February. 65 66 68 69
69 madam, after vacation ಕೊಟ್ಬಿಡಿ.
3rd February. 70 72
ಮೇಡಮ್ 71 ಎಂಟ್ರಿ ಮಾಡೋರು ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬೇಕು.
ಅದು ಬೆಳಗ್ಗೆ ಅಡ್ಜರ್ನ್ ಆಯ್ತು ಸರ್ 10:30ಗೆ. ಅವಾಗ ಏನಾಗಿದೆ ಅದೇ ಆಗುತ್ತೆ ಅಷ್ಟೇ.
ಮೇಡಮ್ ಎಂಟ್ರಿ ಮಾಡ್ರು ಮೇಡಮ್, ಅದಕ್ಕೆ
ಅಲ್ಲ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ, ರೀಚ್ ಆಗ್ದಿರಾ ಇರೋ ಮ್ಯಾಟ್ರ್ ಮಾತ್ರ ಅಷ್ಟೇ. 71 ಬೆಳಗ್ಗೆನೆ ಟೈಮ್ ತಗೊಂಡಿದಾರಲ್ವಾ.
ಓಕೆ ಓಕೆ.
3rd February ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಎಕ್ಸ್ಟೆಂಡೆಡ್. 73 7 ಅದೆಲ್ಲ ಒಂದೇ ದಿನ ಬರುತ್ತಲ್ಲ, ಅವತ್ತು ಹಾಕೋದಾ 15th. 74 ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ ಗೊತ್ತಿಲ್ವಾ? ಬಂದೆ 124 ಬರ್ತೀನಿ ಸೀರಿಯಲ್ ಆಗಿ.
ಮ್ಯಾಮ್ 72 ಮ್ಯಾಮ್ 72
3rd February.
Ma'am, no, anything in this month, ma'am. I'm present representative 3.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಲ್ಲ, ಪಿಟಿಷನರ್ ಹೇಳೋ ಡೇಟ್ ಕೊಡ್ತೀವಿ ಸರ್. 3rd February ಕೇಳಿದ್ದಾರೆ.
Petitioner time ತಗೊಂಡೋಗ್ಬಿಡ್ತಿದ್ದಾರೆ ಮೇಡಮ್. ನಂದು ಲಾಸ್ ಆಗ್ತಿದೆ. ಇನ್ ಆರ್ಡರ್ ಇಸ್ ಆನ್ ಮೈನ್, and I have to take the money from them.
ನೋಡಿ ಯಾವತ್ತಿಗೆ ಬೇಕು ಅವತ್ತಿಗೆ ಬರುತ್ತೆ. 74
Anything in this month.
3rd February. 75
Okay.
ಮಂಡೇ ಆಗಲ್ಲ. ಸುಮ್ನೆ ದಿನ ಬಂದು ಡೇಟ್ ತಗೊಂಡ್ ಹೋಗ್ತೀರಪ್ಪ. ದಿನ ನೋಡಿ ಇವೆಲ್ಲ ರಿಪೀಟ್ ಈ ದಿನ ಬರ್ತಾ ಇದೆ. ಕೇಳ್ತೀರಾ, ಸುಮ್ನೆ ಕಾಯ್ತೀರಾ, ಮತ್ತೆ ಸಂಜೆ ಬಂದ್ ನಾಳೆ ಅಂತೀರಾ. ಫೆಬ್ರವರಿ 3rd ಫೆಬ್ರವರಿ. ಇಲ್ಲ ಅಂದ್ರೆ ನೀವ್ ಯಾವತ್ತಿಗ್ ಬೇಕೋ ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್, ಅಷ್ಟೇ ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ. 8 ಇಲ್ಲ, 76 ಮುಂದೆ ಹೋಗಕ್ ಬಿಡಿ. 77 78 78 ಎಂಟ್ರಿ ಮಾಡ್ರ 3rd ಫೆಬ್ರವರಿ. 79 82 83 84
ಮೇಡಮ್
85
84 ಮೇಡಮ್ 84
ಯಾವತ್ತು 3rd ಫೆಬ್ರವರಿ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎನಿ ಡೇಟ್ ಮೇಡಮ್ ಪ್ಲೀಸ್ ಮೇಡಮ್.
ರೀಚ್ ಆಗಲ್ಲ ಸರ್.
ಇರ್ಲಿ ಮೇಡಮ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎನಿ ಡೇಟ್ ಮೇಡಮ್ ಪ್ಲೀಸ್.
ಸುಮ್ನೆ ಬರುತ್ತೆ ಅಷ್ಟೇ, ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇರುತ್ತೆ.
ಏನ್ ಸಮಸ್ಯೆ ಇಲ್ಲ ಮ್ಯಾಮ್, ನೋ ವರೀಸ್ ಮೇಡಮ್.
ಯಾವತ್ ಕಾಯ್ತೀರಾ?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎನಿ ಡೇಟ್ ಮೇಡಮ್.
ನೀವೇ ಹೇಳ್ಬೇಕು, ಕಾಯೋದ್ ನೀವೇ ಹೇಳಿ.
11th or 12th ಮೇಡಮ್.
ಎರಡರಲ್ಲಿ ಒಂದ್ ಹೇಳಿ ಸರ್.
11th ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್.
ಆಯ್ತು ಸರ್. 85
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
86 ಅದು ಕನೆಕ್ಟ್ ಗೆಲ್ಲ ಆರ್ಡರ್ ಆಗ್ಬೇಕು. ಬೇಡ ಸರ್, ಯಾವತ್ ಬೇಕು ಹೇಳಿ. 3rd ಫೆಬ್ರವರಿ. ಇದೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಸರ್. ಸರ್ 87 ರೀಚ್ ಆಗಲ್ಲ, ಅವತ್ತು ರೀಚ್ ಆಗಲ್ಲ. ಅದೇ 3rd ಫೆಬ್ರವರಿ. 88 3rd ಫೆಬ್ರವರಿ. 89
ಮೇಡಮ್ 88
3rd ಫೆಬ್ರವರಿ.
ನೆನ್ನೆನೋ 8 ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಇವತ್ತಿಗೆ ಹಾಕೊಂಡ್ರು ಮೇಡಮ್. ನನಗೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದು 8.
ಅದೇ ನೆನ್ನೆ ಇತ್ತು, ಇವತ್ತಿಗೆ ಹಾಕಿಸ್ಕೊಂಡಿದ್ದಾರೆ. 3rd ಫೆಬ್ರವರಿ ಸರ್.
ಇದಾದ್ರೂ ಚೇಂಜ್ ಮಾಡಬೇಡಿ ಮೇಡಮ್, ಮತ್ತೆ ಬಂದು ಇದು ಮಾಡ್ತಾರೆ.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ, ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
ಆಯ್ತು
89 90 92 91 1 ವೀಕ್ ಅಲ್ಲ, 1 ವೀಕ್ ಅಂದಿದ್ದಾರೆ. 1 ವೀಕ್ ಎಲ್ಲ ಆಗುತ್ತೆ. ಸರ್ ಇವತ್ತು ಎಷ್ಟು ಸರ್? 4th ಆದ್ಮೇಲೆ 1 ವಾರ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಏನೇನೆ 1 ವಾರ ನಿಮ್ಗೆ ಕಂಪ್ಲೇನ್ಸ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಸೊ 1 ವಾರ ಆದ್ಮೇಲೆ ಒಂದು ಡೇಟ್ ತಗೊಳ್ಳಿ ಸರ್. ಆರ್ಡರ್ ಹೇಳ ಸರ್, ಹೇಳಿದ್ದ ಆರ್ಡರ್ ಹೇಳ, ಲೈವ್ ಅಲ್ಲೂ ಬರುತ್ತೆ, ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ. ನಾನು ಏನ್ ಹೇಳಿದ್ರು ಅಂತ ನಾನ್ ಬರ್ಕೊಂಡಿದೀನಿ, ಹೇಳ್ತೀನಿ ನಿಮ್ಗೆ. 1 week time is granted to comply with the office objection pending consideration of application. ಯಾವತ್ ಹೇಳಿ? 9th ಮಾಡ್ತೀರಾ ಅಷ್ಟ್ರಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ಸ್? ಈಗ ಹೇಳ, ಫೈಲ್ ಹೋಗೋದಕ್ಕೇನೆ ಮಂಡೇ ಆಗತ್ತೆ. ನೀವು ಮಾಡ್ತೀರಾ? ಫೈಲ್ ಸಿಗಲ್ವಲ್ಲ ಕೈಗೆ ಮಾಡಕ್ಕೆ. 9th ಅದೇ ಫೈಲ್ ಹೋಗಲ್ಲ, ಅವ್ರು ಅವ್ರ ಹಿಂದೆ ಬೀಳ್ತಾರೆ ಬಿಡಿ, ಮಾಡಿಸ್ಕೊಂತಾರೆ. 92
Madam, 92 for the petitioner.
91 9th 92
92 for the petitioner, madam. Any date in January ಆಗ್ಬೋದಾ? January ಆಗ್ಬೋದಾ madam? January ಆಗ್ಬೋದಾ madam?
ಜನವರಿ ಎಲ್ಲ ಡೇಟ್ ತುಂಬಾ ಕೊಟ್ಟಿದೆ ಅದಕ್ಕೆ.
Last week madam, January ಆಗ್ಬೋದಾ ಒಂದು ಡೇಟ್?
3rd ಫೆಬ್ರವರಿ.
Entry madam kindly be extend madam.
ಸರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
Okay, thank you.
93 ಸರ್ಫೇಸ್ ನಾನು ಪ್ರೇಯರ್ ಚೆಕ್ ಮಾಡ್ತೀನಿ ಅಲ್ವಾ? ಅಲ್ಲ ಅಂದ್ರೆ ಯಾವತ್ ಬೇಕು? 3rd ಫೆಬ್ರವರಿ. ಲೈಕ್ ಪ್ರೇಯರ್ ನೋಡಿದ್ಮೇಲೆನೆ ಡಿಸೈಡ್ ಮಾಡೋದು ಅಲ್ಲ. ನಾನ್ ಫೈಲ್ ನೋಡ್ತೀನಿ, ನಿಮ್ ಫೈಲ್ ಬೇಡ ನಂಗೆ, ನಾನ್ ನೋಡ್ತೀನಿ. ಸರಿ ಇರಿ. 95 96 3rd ಫೆಬ್ರವರಿ. 97 ಇಬ್ರು ಸೇರಿ ಒಂದ್ ಡೇಟ್ ಹೇಳಿಪ್ಪ. ವೆಕೇಟಿಗೆ ಅವ್ರು ಹಾಕಿದ್ದಾರೆ, ಅವ್ರ ಐಎಕ್ ಬಂದಿರೋದದು. ಯಾವತ್ತಿದ್ರು ರೀಚ್ ಆಗಲ್ಲ. ಅದಕ್ಕೆ ಯಾವತ್ ಕಾಯ್ತೀರಾ ಹೇಳಿ? ನಿಮ್ ಅಡ್ವೊಕೇಟ್ ಯಾವತ್ ಕಾಯ್ತಾರೆ? ಯಾವತ್ ಕಾಯ್ತಾರೆ ಅವರು ಇಲ್ಲಿ ಕೋರ್ಟಲ್ಲಿ? ಯಾವ್ದ್ರಲ್ಲಿ? 96 ಎಂಟ್ರಿ ಮಾಡ್ರು, ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬೇಕು 3rd ಫೆಬ್ರವರಿ. ಯಾವ 3rd ಫೆಬ್ರವರಿನೇ. 97 ಅಲ್ಲ, ನಿಮ್ ಅಡ್ವೊಕೇಟ್ ಹೇಳಿ ಯಾವತ್ತಿಗೆ ಬೇಕೋ ಒಂದ್ ಮೆಮೊ ಹಾಕೊಂಡು ಅವತ್ತಿಗೆ ಹಾಕಿಸ್ಕೊಳ್ಳಿ. ಡೇಟ್ ಅದನ್ನ ಕೊಟ್ಟಿರ್ತೀವಿ. ಅವ್ರು ಯಾವತ್ ಕಾಯ್ತಾರೋ ಗೊತ್ತಿಲ್ವಲ್ಲ ನಮ್ಗೆ. ಅದೇ ಹಿಂಗೆ ಕಾಯ್ತೀರಾ, ಅವತ್ತು ಬಂದ್ ಡೇಟ್ ತಗೊಂಡ್ ಹೋಗ್ತೀರಾ. ಈ ಮಂತ್ ಅಲ್ಲಿ ಯಾವತ್ ಹಾಕೊಂಡ್ರು ಅದೇ ಆಗೋದು. ಎಲ್ಲ ದಿನ 200 ಮ್ಯಾಟ್ರ್ ಇದೆ ನೋಡಿ. ಇವತ್ತು ಬರೀ 125 ಇರೋದಕ್ಕೇನೆ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ. 200 ಎಲ್ಲ ಹೆಂಗ್ ಆಗ್ಬೋದು? ಇನ್ನು ಕೆಳಗ್ ಹೋಗ್ತೀರಾ. 99 ಅದೆಲ್ಲ ಇಲ್ಲ. 101, 103 ಯಾವತ್ತು? 3rd ಫೆಬ್ರವರಿ. ಇರ್ಲಿ ಬಿಡಿ, ನೀವು ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ ಯಾವತ್ತಿಗೆ ಬೇಕು. 105, 106, 107, 108, 109.
109 madam.
ಯಾವತ್? 109 ಯಾವತ್ ಮೇಡಮ್ ಅದು?
Any date.
3rd ಫೆಬ್ರವರಿ. 111, 12, 13. ಎಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ನಂಬರು? ಫೈಲ್ ಪಿನ್ ನೋಡಿದ್ದೀನಿ ಕೊಡಿ. 113 ಆಯ್ತು. 114 ಎಲ್ಲ ಆರ್ಡರ್ ಆಗೋಯ್ತು. 118, 119, 121, 120, 116 ಏನ್ ನೀವು ಕೇಳಿದ್ರಲ್ಲ ಏನು ಆರ್ಡರ್? 27 ಜಾನ್ವರಿ ರೀಚ್ ಆಗಲ್ಲ ಅಲ್ಲ, ನಂಗೆ ಗೊತ್ತಿಲ್ಲ. 27 ನೀವು ಡಿಕ್ಟೇಷನ್ ತಗೊಂಡ್ರಲ್ವಾ, ಅವಾಗ ಒಂದ್ ಡೇಟ್ ಕೊಡಿ ಅಂತ ನನಗೆ ಹೇಳ್ತಾರೆ. ನಾನು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ನಾನ್ ಬರೆಯಲ್ಲ, ಅದು ಅವ್ರು ಟೈಪ್ ಮಾಡ್ತಾರೆ. ಡಿಕ್ಟೇಷನ್ ತಗೊಂಡೋದ್ರಲ್ಲ ಅವರು. ಮುಂದಕ್ಕೆ ಹೋಗ್ತೀನಿ ನಾನು. 118 ಇದ್ರೆ ಆಗುತ್ತೆ. 118, 119, 121, 122, 123, 124.
ಮೇಡಮ್ 124 ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದೆ ಮೇಡಮ್.
ಹಾ ಸರ್, 3rd ಫೆಬ್ರವರಿ.
ಥ್ಯಾಂಕ್ ಯು.
120 ಇದೆ. 3rd ಫೆಬ್ರವರಿ. 123 3rd ಫೆಬ್ರವರಿ. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಯಾವತ್ ಹೇಳಿ? ಬಿಫೋರ್ ವೆಕೇಶನ್ ದಿನ. ಅದೂನು ಅಷ್ಟೇ, ದಿನ ಹಾಕಿಸ್ಕೊಂತೀರಾ. ರೀಚ್ ಆಗಲ್ಲ, ಲಾಸ್ಟ್ ಅಲ್ಲೇ ಇರುತ್ತೆ. ಅದೇ ರೀಚ್ ಆದ್ರೆ ಅಲ್ವಾ ನೀವು ಸಬ್ಮಿಷನ್ ಮಾಡೋದು. ಅದೇ ನಾನೇನ್ ಮಾಡ್ಲಿ ಈಗ? 3rd ಫೆಬ್ರವರಿ ಕೊಡ್ತೀನಿ, ಅವತ್ ತಗೊಳ್ಳಿ ಎಂಟ್ರಿ ಮಾಡ್ರು. ರೀಚ್ ಆಗಲ್ಲ ಸರ್. ನಿಮ್ ಮ್ಯಾಟರ್ ಎಲ್ಲ ದಿನ ಹಾಕಿಸ್ಕೋತೀರಾ. ಯಾಕೆ ಕಾಯಕ್ಕೆ? ದಿನ ಕೇಳ್ತೀರಾ ಇದು 3rd ಫೆಬ್ರವರಿ ಹಾಕ್ತೀನಿ. ನೀವು ಮೆಮೊ ಸರ್, ಮೆಮೊ ತಂದ್ಕೊಡಿ. ಯಾವತ್ತಿಗೆ ಬೇಕು ಅವತ್ತು ಹಾಕೊಂತೀನಿ. 125 ಹೇಳ್ಬೇಕು ನೀವೇ. ಕಾಯೋ ಅಲ್ಲಿ ರೀಚೇ ಆಗಲ್ವಲ್ಲ. ನೀವು ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು ಆಗಲ್ಲ. ಆಯ್ತು, 11th ಫೆಬ್ರವರಿಗೆ.
76 ಯಾವತ್ತು ಮೇಡಮ್?
76 ನೀವೇ ಕಾಯೋರು ಸರ್. ನೀವ್ ಹೇಳಿ ಡೇಟು. 76 ಸರ್. 76 3rd ಫೆಬ್ರವರಿ.
ಅಯ್ಯಯ್ಯೋ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಟ್ರೈ ಮಾಡ್ಬೋದಾ?
ಟ್ರೈ ಮಾಡಿದ್ರು ಹಿಂಗೆ ಕಾಯ್ದು ಡೇಟ್ ತಗೋತೀರಾ. ಅದಕ್ಕೆ ಟ್ರೈ ಮಾಡ್ಬೇಕಷ್ಟೇ.
ಅಷ್ಟೇ, ಅದೇನು ಶಾರ್ಟ್ ಒಂದೇ ಲೈನ್ ಆರ್ಡರ್ ಬರೋದು ಅದಕ್ಕೋಸ್ಕರ.
ನೀವೇ ಹೇಳ್ಬೇಕು ಸರ್, ನಂಗೆ ಗೊತ್ತಿಲ್ಲ. ರೀಚ್ ಆಗಲ್ಲ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಕೊಡಿ, ಪರವಾಗಿಲ್ಲ ಮೇಡಮ್.
ನೀವು ಲಾಸ್ಟ್ ಅಲ್ಲೇ ಬರೋದು.
127 ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಆಗುತ್ತೆ.
129 ಅಷ್ಟೇ. ವೀಸಿಲ್ ಮುಗಿತಾ? ಯಾರು ಇಲ್ಲ, ತೆಗೆದ್ಬಿಡ್ತೀನಿ ಅದು ಫಸ್ಟ್.
66